they will be starting with more and more cases, and they cannot have. So at any given time, when the panel or the judges in the Supreme Court are about 20, then we are saying that we have about 4 sets of panel of judges to handle those cases. So, Mr. Chairman, I will say, in my humble opinion, given the cases that are in the Supreme Court, I will recommend that 20 judges will be appropriate. Thank you.
Thank you very much. Any supplementary question? You can ask a different question. Your limit is 3. If there is a follow-up, fine. But if it is not a follow-up, I'll give the floor to Honorable Anthony Imie.
I'm the chair of the Judicial Committee.
Yes, as a chairperson of the Judicial Committee, you can be given a number of questions to ask far above members of the district. But if you have a follow-up on the question that you ask, I will allow it. But if it is a different question, you don't have a right so to do. Yes. So the follow-up has emanated from.
My follow-up question is, even with the existing numbers, people were complaining of packing judges at the Supreme Court, and you are proposing increasing the number to 20. Then that means we have to review the Constitution or educate us. Thank you.
Honorable member, the Constitution doesn't place any limit. There is no gap placed by the Constitution. Therefore, the number can be increased to 50 without revising the Constitution.
Nominee.
But the question that you asked, it is clear that there is no limit placed. So, very well. So, Honorable Anthony Imie, you have the floor.
Thank you, Mr. Chairman. Congratulations, my Lord.
Thank you.
My Lord, going through your CV last night, I took interest in particularly page 2 of your CV, your work and professional experience.
Yes.
I realize that you have risen from the ranks, from the rank of a court recorder and almost at the apex court. I would want us to do a little bit of exercise in view of your experience from the judicial service, not at the judiciary.
Okay.
My first question is, from your experience, do you think that premium is being placed on the judicial service in view of the fact that all trainings, JTI trainings, workshops, etc., majority of them are organized for members of the bench? That's my first question.
Thank you, Mr. Chair. I would venture to say that when we are talking about training or capacity building, it should not be limited to only the judges. Why? Because if the registrar doesn't know his work, the chances are that he can even mislead the judge. We have had accomplished registrars like Mr. Kankam, Mr. Benton, the late Benton. His son is now a justice of the High Court in Cape Coast. I can name them and name them. I'm a living testimony, as my CV will show. I had opportunity to go to school. And Mr. Chairman, permit me to say that it's very essential that an employer must always try to encourage the staff, and in this case, not, as I said, not only the judges but also the auxiliary staff and the registrars. I had the privilege of working with judges. I was in Sekene High Court when I had the opportunity to go to school. I worked with a judge called Ansekum. I owe Ansekum a great of gratitude. May his soul rest in perfect peace. I was my judge, so I was the character to him. I was very, very committed to my work, and the man took interest in me. I may say that Justice Ansekum, late Justice Ansekum, was a prophet. Why do I say this? He told me that, right, go to school, and if you went to school, you were going to be a great lawyer. I didn't take it serious. But when the time came, I saw the wisdom in it, and I applied myself to what he said. So I had the opportunity to go to the university in 1988 to read Diploma in Public Administration. I went back to Sekene, and then the following year, I had the chance to then go to the law faculty to read law. Went to Makwala to do my professional course, came out, and then went back to the service. Started as a magistrate, and I haven't looked back. So, and I must say, with all due respect, that my work has always spoken for me, and the records are there. It was because...
So, my lord, we don't intend to keep you here for long, so be brief.
So, what I'm saying is that I will say that when we want judiciary, get the judicial service to grow in leaps and bounds, we need to, one, build the capacity of the judges. There's this myth that the law is in the bosom of the judge. But if you, the judge, you do not educate yourself, how would the lawyer come and say that the law is in your bosom? So you need to educate yourself. Two, the infrastructure of the service. When you go to the hinterlands, they are so in some. I started from Sekene also. We were, so we need, and with your approval, please, when our budget comes here, I'm pleading, don't cut our budget, approve for us, so that the Chief Justice will use that to, acquire more, build more courthouses, renewed office accommodation, resident for the judges, because when you work in a serene environment, that even gives you the edge to work hard. I also think that there must be some reforms even with our laws. The laws that we are using, they must be overhauled. For example, the Act 30 was passed in 1960, and there's a need. Now we are in 2025. Some of the provisions have saved SCG students, so we need to, amend some of them so that there will be speedy recovery, speedy trial of cases, and so forth and so on. So my experience has shown that I will give premium to capacity building, and not only judges, but also the staff, and particularly the registrars. Thank you, Mr. Chairman.
Any follow-up?
Thank you very much. Yes, I have a follow-up. So you would agree with me, my lord, that there hasn't been proper, for instance, orientations, proper trainings, proper in-service training for persons like registrars. You agree with me?
To some extent, I will. But to a larger extent, I will also disagree, because we have Judicial Training Institute, And what it does is that it organizes courses periodically for judges and their registers. I have even trained some registers of the Court of Appeal and court clerks. So, and in recent past, some registers were sent to the UK to undergo some studies. Well, they said rapes or rape, I've forgotten that word. But all in an effort to build the capacity of the register. So it's not only the judges that these courses are offered to them, but also to the registers as well. But of course, the JTR, that is the Judicial Training Institute, must be resourced so that they can organize more and more courses for the registers. Thank you.
Thank you very much. Any further questions?
Yes, my Lord, can you tell this committee how often does the JTI organize capacity building workshops, for instance, for registrars? Let's limit it to the High Court.
Well, I will take that to be a fresh question. So, question number 2.
I know for a fact that they do organize courses for the registers. But how often, I cannot tell you. Thank you.
Is it the case that when registrars are appointed, no form of orientation is given to them before they assume office?
To a very large extent, I would say yes. Thank you.
Tell me about your last question.
A follow-up to this one. That was the second question. So I have a follow-up.
You want me to treat it as your third question?
No,
so that you answer follow-up
to
on
the
this.
second question. The last one was the second question.
Yes.
So I have a follow-up to the last question.
That is the training for very well.
Yes, now, my Lord, would you advocate that the budget for the judiciary is prepared in such a way that enough funds would be set aside for the training of both the judiciary and staff of the judicial service? Would you advocate that?
Thank you. In fact, that system is already in place. Parliament has given the judiciary part of the revenue that we generate to oversee our revenue cost and the rest of it. But you see, it's not enough. So, like Oliver Twist, we are saying that more and more resources must be given to the judiciary so that we can work efficiently and effectively. Thank you.
Thank you, my Lord. Now, from the internally generated funds of the judiciary, 30% is retained, while 70% goes to the government. In view of the fact that the judiciary is always struggling to meet its demands, would you advocate the uncapping of the funds so that the entire 100% of funds generated would be left for the judiciary to do business with?
Subject to the fact that that is not capping, you may proceed to answer the question.
Mr. Chair, can you repeat the question for me?
Very well, my Lord. My Lord, what I mean is funds generated from the judiciary keeps just 30% of the said amount for its use. The 70% goes away to the government. What I want to find out from you is, in view of the fact that the judiciary is struggling to do its work, do you think that it would be appropriate for some law being passed, some permission being granted for the judiciary to retain everything it generates for its use.
Indeed, it would be a good idea if that was done, but I'm afraid the revenue that we generate is also backed by law. It must go to the consolidated fund, because it is from the consolidated fund that the government, applies to its activities, including institutions of state and the judiciary. So, to say that the judiciary should retain 100%, I will not advocate for that, but I will say that maybe about 50 or 70% must come to the judiciary. Thank you.
Thank you very much. I will then give the floor to Honorable Bede Awantanzuma Azidi.
Thank you very much, Honorable Chairman. Congratulations, my Lord.
Thank you.
Yes, my Lord, I've gone through your CV, and I've also listened to you. Honestly, there is absolutely no reason why you should not be appointed a Supreme Court judge.
Thank you.
You have done all that it takes to become a judge, right from the magistrate through the ranks at the Supreme Court. And I think that I will not worry myself about whether you are qualified to be a Supreme Court judge or not. You are. And so I have no questions for you, my Lord. As far as I'm concerned, you are fit for the job and you are fit for purpose. Thank you.
Thank you.
Congratulations.
Thank you very much. It's now the turn of Honorable Tambuli. You have the floor.
Thank you very much. Madam, good morning and welcome.
Thank you. Good morning.
And congratulations, my Lord. My Lord, I heard you talk about the jurisdiction and the workload of courts in Nigeria, Federal Republic of Nigeria. And I want us to do a bit of comparison with ours here.
Okay.
So the Nigerian Constitution 1999 as amended, and in their case they call it sections. Section 2302B of the Nigerian Constitution provides, and I quote, "The Supreme Court of Nigeria shall consist of such number of justices of the Supreme Court, not exceeding 21, as may be prescribed by an act of the National Assembly." In Ghana, ours is in Article 1281. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. End quote. So, in other words, they have a ceiling, but we have a floor. So, at some point during the presidency of President Buhari, they even had 13 justices of the Supreme Court of the Federal Republic of Nigeria. But is it sustainable? And having regard to the fact that Article 128 is not an entrenched provision. The entire Chapter 11 has Article 125, 127, 145, and 146 as the only entrenched provisions. Do you think we should do something about this? Especially having regard to the fact also that 230 million people reside in Nigeria and about 32 million in Ghana. We have not less than 9. They have not more than 21. Don't you think by reason of these numbers, ours is a bit on the high side and potentially can even go way higher? Thank you.
Thank you, Mr. Chairman. I will start off by saying that if there should be need for expansion or capping of the Supreme Court, I think that there must be a wide and expansive consultation among all the stakeholders, lawyers, GBA, constitutional lawyers, the academia, even the political parties themselves, so that we will all come to consensus as to what we must do. And if there's a consensus that there should be a cap, then the law has to be amended. Fortunately, as you said, I also looked at the law, and that is not an entrenched provision of the Constitution. So the amendment, as it were, can be done without much difficulty, except that, as I advocated, there must be a very wide consultation. I brought this report, an annual report of the Judicial Service, and as at June 2023, this report was issued to us last week. 595 cases were pending in the Supreme Court. So when you are talking about capping, you must also take into consideration, as I've said already, the number of cases that are in the Supreme Court pending for attention. Thank you.
Thank you, Mr. Chair.
Any follow-up?
Follow-up question.
The ground rules.
I acknowledge, the ground rules. In view of the expansive jurisdiction of the Supreme Court, chieftaincy, jurisdiction, election, Supreme Court, presidential elections, and so on and so forth. Now, don't you think that there is need for us to stop the jurisdiction somewhere of the jurisdiction of the Supreme Court, especially, you can take, for instance, interlocutory appeals. Rules of Court Committee can, by CI, come up with something. Can you propose some limitation to the jurisdiction of the Supreme Court? Which jurisdiction do you think should be set aside and at the Court of Appeals, and which one should continue to remain with the Supreme Court? And by the way, at some point, the Supreme Court of Nigeria had over 10,000, pending cases. At some point in 2022. Over 10,000 pending cases. I thank you, Mr. Chairman.
Thank you, Mr. Chairman. You see, I will say that first and foremost, the Court of Appeal must be very strong. Being strong means that we need judges who, they are doing their work very well, I must admit. But we must make it stronger than now, so that some of the cases may not travel beyond that. But there must also be conscious effort on the part of the legislature and then the Rules of Court Committee to ensure that. And of course, we can't do that without, we have to subject the debate very wide, so as to see the number of cases that will go to the Supreme Court. Because, permit me to use the UK example. UK, most of the cases end up at the Court of Appeal. The cases that go to the Supreme Court will go there with the leave of the Court of Appeal or the Supreme Court. So you find that they do very little cases, and so the Supreme Court is always, they are not saddled with so many cases. So if that is what we want to replicate in Ghana, then the law itself must be amended so that some of the jurisdictions must be taken away. For example, if I should be given the opportunity to say, to recommend, the prerogative of mercy that is exercised by the president, I think that should remain in with the executive. It shouldn't come to the Supreme Court. Because after all, the Supreme Court itself has pronounced that when it comes to matters of advice, the president may take it or may not. Thank you.
My Lord, with the leave of the chairman.
Please, he said the mercy, not writ.
Prerogative of mercy.
Mercy, yes, prerogative of mercy, which is vested in the president. The president may come to the Supreme Court for advice. And once the interpretation placed on the advice is not compulsory or is not binding on the president, he feels that it should rest with the president. Yes.
So that's one example.
Honorable Mafoewa, you have the floor.
Congratulations, my Lord.
Thank you, Chair.
My Lord, I was happy to hear you say that there is the need to build a strong court of appeal, so that a lot of the cases that travel as far as the Supreme Court will be reduced. My Lord, when you take the law reports of the Republic of Ghana, there's one observation you are likely to make. A significant number of the cases determined by the Supreme Court, by the Court of Appeal, are overturned by the Supreme Court. In recent history, if you even look at the number of judges being appointed from the Court of Appeal to the Supreme Court, it's indicative of how strong our Court of Appeal is presently. But this is the situation. Why are we having that experience? Because currently we say we have a strong Court of Appeal, yet a significant number of cases are being overturned by the Supreme Court.
Thank you, Mr. Chair. In fact, I haven't had the benefit of that research you are talking about. So let me file a caveat. I will not be able to answer directly why that is the case. If I've had benefit of it, maybe I can profess an idea as to why that is the case. Thank you.
Mr. Chairman, no question.
Thank you very much. Honorable Aliklim Akurubu.
Thank you, Mr. Chair. Congratulations, my Lord.
Thank you.
Yes, there has been growing concerns about expanding access by breaking the monopoly of the Ghana School of Law. There are a lot of people who have completed their LLB and are home. Some of us are even planning to go read law, but we get scared about what is happening. What do you make of it, or what can you advise for our students who have been home for many years and haven't been called to the bar? Thank you.
Thank you, Mr. Chair. The number of students that are trying to get to the law school has increased significantly, because now we have universities that are offering LLB courses. In our time, it was only the University of Ghana, and then from there you come to the law school, so the number was few. Now it has been expanded without corresponding maybe infrastructure to take care of all those students. So I believe that is why the numbers have swelled. Now proposing a solution, offering a solution to the problem, I would think that those who have already passed their LLB and are waiting to enter the law school must be given what we call an immunity. Immunity in the sense that they could be grouped and then given maybe depending upon how the General Legal Counsel are going to do it. I think they can put a system in place where the students can be, grouped and then they are given the chance to do the courses at the law school. Now we have Kumasi Campus Law School. I think UPSA is also doing the same. So if they are given immunity and all of them are offered the opportunity to go to the law school, because invariably everybody who has entered the law faculty to do LLB who wants to become a lawyer in the long run. And I do not think it would be fair for us to impede the progress of the students who want to come to the law school. So the system must be looked at again holistically. The General Legal Counsel, together with maybe the director of the School of Law, they need to sit down and fashion up. And of course, there must be, also a debate. The academia must also be involved because they also have a role to play. Somebody has suggested that the courses being run at the law school must be taken there to the law faculties. That is maybe solving the problem. But the question also arises that the courses taught at the law faculties, they give the students the basic foundation of the law, a theoretical. What is taught at the law school are professional courses. So most of the courses there are practical. Therefore, if the law faculties have the capacity to run those courses with the oversight responsibility of the General Legal Counsel, ensuring that, because here too we are talking about quality assurance must be applied. So the General Legal Counsel must also get involved in some of these matters and find a solution to the problem. Thank you.
Thank you, Chair. My second question. Judges are seen not to have a social life because of the kind of work you do, pressure on you to read cases and run around. How do you balance your social life with your career? Thank you.
Thank you. The life of a judge is something which, unless you have come into a fold, you will, because the steps that you take, wherever you go, and the things that you do, you are in the public eye. So when we are also talking about trust in the system, you, the judge, you must behave yourself such that people will have confidence in the courts that they are coming for justice. It's not only that the justice must be served, but they must be seen that justice is being done. So, for example, if I'm a judge and I move my car and go around, taking on board all manner of people as my friends, it leaves room for suspicion and the rest of it. So sometimes you have to isolate yourself. Me, for example, I pick and choose my friends. And if I haven't traveled out of town, Sunday, I will make sure that I go to church. So my work and church. I believe yesterday, the last nominee said something which we were all amazed, that because of his work, his marriage has to suffer. That is a kind of reality. So, and the point is that even if you see a friend, a lawyer, you can't even go and shake hands with him, because people will say that he is the friend to the lawyer. So that is the situation we find ourselves. But you see, that is the job we have sworn to do. So we will manage it. Thank you.
Thank you, Mr. Chair. No further questions. Congratulations once again. All the best.
Thank you very much. Then I'll give the floor to Honorable Yauboma.
Thank you very much. Congratulations, my Lord.
Thank you.
Chairman, full disclosure, my Lord has been a very good friend of mine for many years. And I'm happy to see you go up as the Justice of the Supreme Court. Even if you are going to spend a year there, we know what you are going to stand up there. And I wish you well.
Thank you.
My Lord, first time I appeared before you was about 14 years ago.
Oh, that's so.
I remember Republic versus Oseje, Antonia Kuto Osei, Jambafo, also Professor Jambafo. And the former Attorney General was for Oseje. Brilliant submission of no case, which you upheld. A 90-page submission of no case, which you upheld. And Oseje got out of the woods. I've read recently some decisions of yours, the Amewu matter, the Atufosi matter, that I know you to be a very bold judge, regardless of who is before you.
Thank you.
And that is commendable.
Thank you for the observation.
That's very commendable. What gives you that weight and motivation? Because the kind of cases that I've read you handle and taking those bold decisions are very political in nature. The stakes were very high. I would have wished my colleague Bafo to have been around, since he said most of your cases are overturned on appeal at the Supreme Court. Some of these cases that you also overturned came from the High Court. So I would want to hear your views on some of them. The Amewu matter, the Oseje, Jambafo, Atufosin and Co. So those are matters that you've determined already, so you can give us an overview. Thank you.
Thank you, Chair. In the Amewu case, is it what? Amewu?
Amewu, John Peter Amewu.
John Peter Amewu. That case is still sub judice. What came before us was for an application, interlocutory, for an application for interlocutory injunction. So the case itself is pending for him, the appeal itself is pending for him. So it will be unethical for me to say something about it. Thank you. In the case of OCIJ,
Hello, do you still remember the facts? Talk about some rice importation from India.
From India, I do to some extent, but it's, as you rightly said, it's a long time ago. So what I would say is that in that particular case, or generally, my position has always been that as soon as I hand over my judgment, I don't think about them again. Because if you are dissatisfied with it, you have the opportunity to go out. So it will be very difficult on my part to discuss it now. Unless, so please, let's.
My Lord, I'll step it down and ask you if you still have some good friends at the bar, because when you are at the financial court one, anytime a case is brought to you and the lawyers discuss, they say, you're going to Justice Bright Mensah's court. On 1-3. Even if he's dismissing your application, he'll even put a smile on his face. He will just ask you to go out. Lord, all I want to entreat you and beg of you is to keep being yourself.
Thank you.
Keep being a firm judge.
Thank you.
And I wish you the very best. Thank you.
But you see, Chairman, please, my court is a very friendly court. Very, very friendly. If sometimes, thank you for the comments.
Yes, I'll give the floor to Honorable Haji Aladi Ayamba.
Thank you, Chairman. Congratulations, my brother.
Thank you.
So hard, riding through those ranks. Thank you. I think this is something that needs to be discussed with those up and coming. Some people think you must just get up and get to the topmost level, but here you are. Looking at where you came from and the issues that we have at hand, especially on the ground, when you go to our villages, for that matter, our districts, what is your suggestion about facts that we don't have, for lack of a better word, let me say, lawyers around, where maybe in Pusiga you have a case, you even need somebody, you may have to be calling Accra. We don't have the judges. Sometimes one judge is handling so many districts, or there may be only 2 judges in one region, and they continue shuttling, going up and down. What is your suggestion? What will you bring up to encourage whether those who are already trained professionals, so that they will take up places that are deprived, or judges to accept postings to such places?
Thank you, Chair. I think the solution to the problem is that the conditions of service, particularly at the lower court, must be attractive to lawyers to start from the lowest bench. Quite often, lawyers who want to join the bench will want to join it from the superior court. But when we talk about the work of the courts, it's those down there who normally do the bulk of the court. Indeed, when we are talking about access to justice and quality justice for that matter, it starts from down there. So therefore, to attract lawyers to start from the lower ebb of the ladder, then it means that the condition of service must be very, very attractive. I myself, when I started, I was also started with going to other courts. It was because there were no lawyers available to be engaged. Not that they are not available, but they didn't find our conditions of service attractive to come to start from the lower. So the solution to the problem is that the conditions of service of the judges, particularly at the lower bench, must be attractive for the lawyers to start from there. I believe that if the conditions of service are attractive, many lawyers will join the bench. Thank you.
Chairman, my second question. Cases take so long in courts, whether rural, urban, whatsoever. Some even eventually they die and the cases are not ended. They are not determined. Thank you for giving me the correct word. Are not determined. What is your suggestion to ensure that at least we make sure these cases are determined very fast so that we don't have so much at hand?
Thank you, Chair. There are so many factors that come into play when cases delay in court. I will not go into that because I'm being called upon to offer an advice or suggestion as to how they may be addressed. The first is that the judicial service must get their system digitalized, because now the modern trends are that if we were to digitalize our systems, cases filed will be filed electronically. When they are filed electronically, the belief that we'll have to effect service, we'll also do it, the proof of service, if it is served, you will issue proof of service and then it will be uploaded into the system. So we will not get a situation where a bailiff, though has served a process, will not prove service. Once proof of service is not on the docket, though the process has been served, the judge cannot go on with the case, and that will mean that the case must suffer an adjournment. When we also talk about e-justice system, we are also talking about virtual court. In other jurisdictions, even in Africa here, Tanzania and Kenya have invested so much in the judicial system, such that once the cases are filed electronically and the solution of cases are generated electronically, so the Chief Justice will not even have the power or has no control over who should sit on a particular case or the other. Which means that as soon as the processes are served and everything is in place, a judge who has traveled to his hometown, maybe I might have traveled to Amasma, and if a case is put before me, I will not have excuse to say that I'm not in Accra, so I can't do the case. It's virtual court, and sometimes you can also use Zoom to do those cases. If we were able to do that, I think it will be a leap forward, so that cases will be tried as expeditiously as possible. But if we feel that we must remain where we are, we won't get far. So that is the solution I would prefer to the problem on hand. Thank you.
Chairman, what I'm about to ask might not necessarily be in the Constitution, but is asked. There is this statement I've read in it that states that a child can have sex at 16, but can only marry at age 18. It has been baffling me because why do you think that someone has the right to have sex at 16, cannot marry at 16, but should wait until 18 because we say it's a law? Now, sex comes with so many things because you carry responsibilities when you go to have sex, whether at 16 or at 100. You may become pregnant, you may, a whole lot of things. What should we do? Should we bridge the gap between the 16 and 18 and make it that at least 18 is more acceptable? That the right for anybody to have sex is at 18, and when there is anything, even if you get impregnated, you could marry the one that you are interested in, or we should reduce it to 16 so that we don't even have that gap.
Thank you. I think the interment of which puts the marriageable age to 18 was thinking that by 18 years the girl would be a mature person to be able to know her responsibilities so far as marriage is concerned. Now, why should a girl have sex at 16 and not be permitted to be married? There's more of a moral question, sort of. Because look, 6 years, what does the girl know? The girl does not know anything. But if she's 18, and the Constitution even makes, describe an adult person as 18 years. So if you are 18, the presumption is that you have seen life a little to be able to be independent or think for yourself when you are married. But if you are 16 years and they are taking you for, I think it's quite. See, at 16, the girl must be in school. You should not go and follow 45-year-old man. Thank you.
Sorry, Chairman. The response I was asking, with that, your explanation, I'm quite satisfied. But I need to know whether we should then we should amend it.
Amend it to
18 years for both sex and marriage, or it should remain as a
to amend it to
18 years. To 18 years.
Oh, then that the girl can have sex.
Have sex at 16.
Hey.
My Lord, I think if that is done, the defilement cases will be a lot.
I see. But the point is that when this girls wait to 18, that is the question we must also settle ourselves with. If he remains in chastity to 18, well and good. But you as a parent, you will be sleeping and your daughter will be somewhere else, which you have no idea about. How can you control her? So please, let the law remain what it is, at least for now. Thank you.
Thank you very much.
Chairman. Thank you.
Yes, Alaji Omar, you have the floor.
Thank you, Chairman. My Lord, Philip Wright, congratulations.
Thank you.
My question is bordering on judicial or policy litmus test.
Judicial
or policy litmus test.
I didn't hear you well.
Okay. What is your stand on gun ownership?
Gun ownership. Gun. In fact, I think our laws are said that if you want to own a gun, first and foremost, you need to register it. So if your gun is unregistered, then you have already violated the law. And I'm sure that this is to prevent people from, using the gun not intended for the purpose for which the gun was acquired. So my position is that if you want to own a gun, first you must be an adult, and then you must also register it as the law requires. Thank you.
Thank you. The second question is, what is your view on the doctrine of separation of powers?
Separation of powers, it's somebody will say it's a political doctrine where the three arms of government are given their specific rules to play. And that's overlap. It's overlap in the sense that you can't say that because you are a judiciary, you will not have anything to do with the executive. And that the executive will also not have anything to do with the legislature. In fact, the core idea of separation of powers is to ensure that the three arms of government, there will be checks and balances. So no one arm will be controlling the others. So, for example, as of members of this House to ensure that when the executive is going astray from what it is required or they are required to do, you have the power to say that no, this one you are going ultra vires your powers. The same with Parliament. If Parliament passes laws which are ultra vires their powers, the judiciary should be able to tell the lawmakers that, look, here it didn't go well. You should have done this or you should have done that. So it's about ensuring that there are checks of balances so that there will be cohesion. After all, that is what good governance is all about. Thank you.
Please do. Thank you. My Lord, in recent past, the last few years, you have some interference and overlapping where Parliament is making decision, is not yet concluded, and yet the judiciary jump on it to make decisions to stop it. Is that not usurping of or interference in the separation of powers?
Thank you, Chairman. The law, as I understand it, is that if what the Parliament sought to do has to do with interpretation of the Constitution, then the judiciary is seized with that jurisdiction to go into the matter. It's not as if the judiciary is becoming a schoolmaster. Of course, in any event, Parliament, you are masters of your own, what do we even say it? Masters of your own rules. So if the rules are fashioned in consonance with the law, and for that matter, the Constitution, I do not think the Supreme Court will jump onto your head and say that, don't do this, don't do that. So, I would say that that case in question that you are talking about, if it bordered on constitutionality and interpretation of some provisions of the Constitution, then the Supreme Court has a right to intervene. Thank you.
I wish you well. Thank you so much.
Thank you. I will then proceed to give the floor to Honorable Jerry Shaib.
Thank you very much, Honorable Chair. Honorable Chair, let me take this opportunity to welcome the Honorable nominee and Nana Doctor and all the. I have a parcel of land in that area, so by extension, I'm a sub-chief.
Is that part of assets that you have declared?
Mr. Chair, I was given the land last night. Thank you very much. Nana Justice, congratulations and you are welcome.
Thank you. Thank you.
Honorable nominee, you've been a registrar of the court, and I believe for a period before getting to the High Court and then the Court of Appeal. And therefore, you are versed with a lot of knowledge on judicial matters. Respectfully, would you recommend any judicial reforms to this committee?
Certainly. Thank you. I've already made mention of some reforms that we can put in place to ensure that cases that come before us are tried expeditiously. And I made a point of this e-justice system. I think the rules of court that we also work with needs looking at again. For example, the High Court rules, CI 47. Indeed, we had the previous one, which was promulgated in the 50s. It was only in 2004 that we changed it, and that has become our tool that we work with. Now, there are also inherent difficulties or problems with some rules of our engagement. For example, interlocutory appeals. I'm talking about interlocutory appeals, both in civil and in criminal. Interlocutory appeals, when a decision is made by a trial judge, while the case is pending, most often the party that is dissatisfied will want to go on appeal. In that case, and if he applies for stay of proceedings, it's certify the hearing of the case. So I want to suggest that, yes, they have the right to appeal, but there must time limits within which the appeal must be heard so that it doesn't affect the hearing of the case adversely. Now, coming to the criminal aspect of it. Now, it has become fashionable that if you are doing the case as a judge, when you cough, a party will want to go up. When you sneeze, and sometimes they go even as far as to the Supreme Court. Meanwhile, then the case will say be pending. So I strongly advocate that the right of parties filing interlocutory appeals in criminal cases where the prosecution has not even ended its case must be stopped. And we can only do that through the amendment of the law, that is Act, talking specifically about Act 30. Now, another area which also needs reforms is our jury system. We inherited this system from our colonial masters, Britain, where they started this system. As I speak, India, some Commonwealth countries like India, Singapore, and South Africa, they have abolished the system. Why? Because it's not functional. Now, our experience in our jurisdiction has shown that that system has outlived its usefulness. So I would advocate that instead of the jury system, there must be assessors. Now, if you permit me, I will give one example. When I was in the High Court, I did assess, that was before my transfer to Secretary in 2015. I did a case where I had summed up the evidence to the jury, and as much as possible, I did it that everybody in the courtroom, or maybe those in the courtroom who understood what we were saying, anticipated that the jurors were going to, bring a verdict of guilty. They came out and said that the accused persons were not guilty. And you see, the law is also that they are the judges of fact. So their verdict is even binding on you, the judge. You may disagree, but you cannot open your mouth. You have to work with it. And there was a doctor who has been subpoenaed. I've come from Ankerford Psychiatric Hospital to give evidence in the case. The doctor was in the court when I was delivering my seminar. The man was so disappointed that he said that if that is what the jurors here are doing, that I will never come back again. He didn't come. So the case will have to be, I left it because I was on transfer to Secretary. So we can give examples, but because of constraints of time, I will not do that. But I'm saying that in its place, we should establish what we call assessors. In assessors, the judges who will try the case will be 3, and there will be lawyers. I mean, there will be lawyers who have become judges. They will sit on the case. And we have it on our statute books when judges try treason and high treason offenses. It's assessors. We don't do it. Jury. Our jury system here is porous. Some of them have become professional jurors. So that is one area which I will advocate. Thank you.
Thank you very much. My Lord, I asked this question yesterday. I think it was Sir Dennis. My Lord Sir Dennis that responded. But just opposing that with his response and yours, I'm looking at the issue of, for instance, the criminal interlocutory appeal that maybe a suspect or a witness believes that whatever ruling you made or whatever consideration you made would affect him or her. And if it is not corrected at the point that it has to be corrected, you would end up giving a judgment that would convict him and others. You don't think that the issue of time is key? That's what you said. But are you in the position to propose the time frame within which such appeals should be considered? Which I think is very, very crucial. Because if, for instance, I'm able to know that I can get an appeal for an interlocutory matter so that the court can proceed to deal with a substantive matter, would you consider giving us an idea of what time that appeal should be considered?
In my earlier submissions, I did make a point that if a party is aggrieved with a decision by a court, because the case has not traveled to its end and it is still ongoing, then that will be an interlocutory decision that by the court. Now, it's right that when a case has not come to an end, or when in criminal matters, when the prosecution has not closed its case, the judge has no power to convict. Therefore, if you want to appeal against an interlocutory decision, you will not be, as it were, at that stage, the court cannot convict you and sentence you. So earlier on, I did propose that right for parties, it could be the prosecution or it could be the defense, to file interlocutory appeals while the case is pending, must be reserved to the end of the case or at the end of the course of the prosecution's case. That one is allowable, I think, that so that the hearing of the substantive matter doesn't suffer. Now, if it comes to the time that we should allocate for filing of the appeal and hearing it, I will propose that when the appeal is filed, interlocutory appeal is filed, the registrar should be able to compile the appeal within 14 days. Because invariably, it's not every document that has been tendered in the proceedings that will have to be embodied in the record of appeal. It's only if it's an application, yes, it will take the processes that were filed in connection with that application, and then the decision of the court itself, that will be the relevant records that must be sent to the Court of Appeal. And when it is sent to the Court of Appeal, then the rules of court must also amend the rules to say that if it's an interlocutory appeal and it's of urgency, it's urgent, then that appeal must be heard within at most, is it at least or at most 30 days, so that it will not badly affect the hearing of the substantive case at the trial court. So that is my proposal.
Very well, thank you very much, my Lord. My Lord, were you once a magistrate, and would you pray that career magistracy be abolished?
Not at all. I would rather advocate that the system must be, must be strengthened, for want of better word. Because you see, this career magistrate came about as a result of when the Courts Act was amended. First we were sitting as tribunals with, panel members. I think in 2001 or so, when President Kufuor came into office, the Parliament sought to reverse the system back to its former. So now, then we had magistrate. Because of the vacuum that was created, most of there were so many vacancies. So that was why at that time it became necessary for the then Chief Justice to fashion out this career magistrate system. And it is not, Ghana is not the only place that we have, applied this system. When you go to Nigeria and Zimbabwe, they have that system. And there's a career part where you can start as a career magistrate and you, by dint of hard work, integrity, and your competence, you can rise to become chief magistrate, which is an enormous grace of a high court judge. Now, here, there's some difficulty with our system. Currently, because the service felt that we must encourage lawyers to come to occupy those positions. And as I said earlier on, the lawyers, when they want to join the service, want to start from the superior courts. So, as at now, there are about 70 plus more career magistrates still in the system, and those ones are in the hinterlands. And they do the same work as that of, professional lawyers who have become magistrates. So instead of scrapping it, it should be strengthened. They must be given the opportunity to also go to the law school, educate themselves, because when they come back, they also come and join the service. There is a second judge in Kumasi, started as a career magistrate. He had the opportunity to go to school, and now he's a second judge. So instead of scrapping it, because if you scrap it, and there are vacancies in the hinterlands, as Madam was saying, who will go there to, do this career magistrates who have been going pushed to the hinterlands to handle the courts there. And it's important that we should, encourage them to also come up with their competence. Thank you.
Well, that would be, I have my final question. And sitting in as a judge, Lord, what would be your role in curbing the menace of Galamsey? What suggestions would you put forth? And how are you going to deal with issues that come before you, especially on Galamsey?
First and foremost, we have this minerals and mining laws. And the offenses that the law creates are deterrent enough to punish people who are involved in Galamsey. What is left is the implementation, the effective implementation of the law. So I think there should be a collaboration between the service and then the police or the enforcing authorities. After all, we are fighting a common cause. If we allow this to go on, and in the next 5 or 10 years, we are importing water because all our water bodies are destroyed. Can we bear it? One area I also want to maybe hammer or suggest is that there are foreigners who also engage in this, say, activities, destroying our forests and the rest of it. you know, when they are arrested, especially these Chinese people, when they are arrested and sent to the court, the difficulty is that they don't speak English. Even if they can, you know, they understand English, they will refuse to speak English. And because the judges or the police enforcement agencies also are unable to speak their language, it becomes more and more difficult to get them prosecuted. So I will suggest strongly, or I recommend, that the judges who are in the areas where these galamseys are going on, the judges must either be taken to China for further studies in Chinese language, or they should fashion, the JTI must be resourced to bring experts to come and train our judges. That will also is another way of, because if the person has committed offense and he can't speak, you can't prosecute him. Then it's as well saying that, oh, let me leave him for him to go away. So that is the recommendation I will make. Thank you.
But my Lord, why not get interpreters?
Oh, that is also good. It's another point. But you see, the interpreters themselves, sometimes they are also a problem. So if the judge himself understands the language, language, it will be better served for them to understand what he is doing, what she or he is doing, and for us to, you know, be able to curb the menace of galamsey. Thank you.
Thank you, my Lord. But so, how does it mean that you want to deport a Chinese person involved in galamsey? What would be your stand?
This is a difficult question. Difficult in the sense that the power to deport is the executives. I'm not in the executive. So I cannot, with all due respect, answer this question. Because the discretion is the executives. Thank you.
Thank you very much, my Lord. I wish you all the best. Thank you. Thank you, Chair.
Yes, Honorable Koku, Ruketega. You have the floor.
Yeah. Thank you very much, Mr. Chairman. Nominee, my Lord.
Yes, sir.
Justice Philip Bright Mensah.
You are right, sir.
From Amosman.
Yes.
My neighbor. Your neighbor from Cape Coast.
Okay, I know.
Are you cool?
Yeah.
Going through your CV, just like going through your CV as many of us have done here, your CV is an epitome of what will be described as you have gone through the mill.
Thank you.
You have pretty much climbed the stairs through our courts. So obviously from where you will be sitting, God willing, you will have a much comprehensive view of the whole court system. And I have no doubt in my mind that you will do a good job.
Thank you.
For Ghana.
Thank you.
My questions this morning is on how we can improve the inefficiencies within the court system. In Ghana, even though we have district courts, which are supposed to deal expeditiously with matters, but we often hear that the courts are becoming like the circuit and high courts, I'm told.
Circuit and the high court?
Yes.
The district court?
The district courts.
I see.
We're talking about inefficiencies here.
Okay.
Do you think we need small claims courts, which can deal with matters involving claims that are, say, less than 10,000 Ghana cedis, and deal with those cases in a day or a week maximum. Thank you.
Thank you, Mr. Chair. Indeed, the service itself has, over time, devised some means or strategies by which such cases. So, with all due respect, you are not the only one who has raised this question. In fact, even in Accra, there used to be small claim courts. The rationale is that somebody who has a small claim must be able to walk to the district court, Gaboso, where I also did my work there, so that you will not require the services of a lawyer. You can walk in there, and of course, the district court is a case, the court of summary trial, so you don't have to file too many papers. You go there. If it's about money, as you are saying, the defendant will be served, and when they appear before the court, the magistrate will ask him, look, you owe this man, are you liable or not? If he admits that he is liable, then you enter judgment there and then. So it's a very good suggestion, a good idea, but it will also depend upon our lawmakers here. If you give us money to be able to set up the courts, we will be able to set up this small claim court that you are talking about. Thank you.
Mr. Chair, thank you very much. Again, my Lord, I'll go to my second question. No follow-up question.
Okay.
But also relates to the same inefficiencies within our courts and how we can improve on that. And this time with technology.
Okay.
You did say earlier on that if we have, electronic systems within a court, we can improve on things. I think the problem goes beyond just the electronics, but the whole data management of the courts. The data collection and the management of it. You realize that maybe the systems are not there, but I think it would be a good idea for the court to start getting people with expertise in technology to help, sort of augment the work that you do. And that the court should be looking at management systems, because the issue is to do with management. The reason why things are quite slow with the courts. So would you think that it would be a good idea to invest? I know you've done a lot of, you started many years ago to do some automation in the courts. Do you think you still need more investment in automating the court? To an extent, it cannot be 100%, but at least to a level that will make processes much faster than having some cases sitting in court for years without any solution. Thank you.
Thank you. Certainly, yes. The government or the executive, for that matter, must make conscious effort to invest in this project. I said that in Kenya and in Tanzania, I'm told that when you want to electronically file your cases, you walk into what we call here communication center to do it. So if we have been able to also invest in the system such that it's across the board, across the length and breadth of the country, and we educate people as to how we should use the system, it will help us a great deal, because it will mean that most cases will be tried as expeditiously as possible. And when we are able to do that, I think the confidence and trust in the judicial system will soar up. So I will still plead that when our budget comes, please try to even top it up for us so that we use part of the money to invest in this kind of, system to improve our efficiencies. Thank you.
Follow up, Mr. Chairman. Would it be an encouragement as well if this investment comes and a system for judges and the whole judicial system to equip themselves with modern technology to be able to, again, be up to speed, in addition to perhaps introducing Chinese classes so you can deal with Chinese issues. Thank you. So they become quite rampant in our system now. Thank you.
Mr. Chairman, I do agree. I don't have any qualms about it at all. We should improve our system. Everybody, I'm sure this time, most of the judges, if not all of them, they know how to, use their laptop. So it's a very laudable idea, and I thank you for the suggestion.
I'm going to end with this. I just noticed on your CV that you're actually a chief of Amosman and the Nyimfahene of Asebu traditional area. Would you let us know what your stool name or title is, please?
Mr. Chairman, I am Nanamwa the 8th, or let me say it in front of you. Nanamwa Otodo our tree. May Amos my hands and now may Nyimfahene or Asebu traditional area. Mama here not see. Okay, the chief of Asaminfi, the 7th, he has come all the way from Asebu to come and support me. And the Queen Mother and the other chiefs, they are all here to give me their moral support. Thank you.
Justice, but who's in the bill? Why he's in the bill?
Nanamwa Otodo our tree.
Nanamwa Otodo our tree.
No.
Please put your hair. Nana, Utinkwa. Thank you, Mr. Chairman.
My Lord, ni hao.
Ni hao. Ni hao.
Ni hao. Ni hao ma.
Chinese, hey, that's the first time I'm hearing it. Thank you, Chair.
It's greetings.
Oh, okay.
Yes.
And the meaning is what?
Like, how are you?
Oh, I'm fine.
I'm fine. Ni hao ma.
Ni hao ma.
Yes.
Hey, I see. Thank you.
Yes. Honourable members, I will proceed to give the floor to Honourable Patricia Piaget.
Right. Thank you very much, my Lord. Congratulations.
Thank you.
There's nobody but Mama Pat from Kumasi. Yes. We've been listening to you. Very interesting journey towards the judiciary. And one of the things I'd like to ask is for you to share with us your personal or professional obstacles you faced on your journey to becoming a justice of the court, and how your story might inspire the next generation of legal minds. Thank you.
Thank you. If I understood your question, you were asking how I was to become a judge or
Yes, and share a story that will inspire the next generation.
Yes. I think first and foremost, if you want to become a judge, you need to make sure that you should be prepared to work hard. That is point number one. You're also talking about your competence and integrity. The work of a judge, you are settling disputes between feuding parties. So as the statement always go, you must not only deliver justice, but you must also be seen to do justice. My journey, I told you I've had a checkered history, but I want to give one example. You know, it is resilience. You must persist. In fact, when I read the diploma in public administration, and I had the opportunity to go to school again to read law. I had then been bonded over to serve the judicial service for 4 years. When I went back to Sekene, the following year I had the opportunity to go to the university. And there were all kinds of obstacles. But it took the intervention of a very good man, the late Justice Archer. He was then the Chief Justice, and I'm always grateful to him that he eventually permitted me to go to school, because I was a family man and I could not have gone to school without steadily repay. So I worked hard, and my philosophy in life has always been that something worth doing must be done well. In fact, permit me to emphasize that I started my career as a magistrate in Sefiri also. I didn't say that because that place is far from Accra, I will do my work as I choose and as I please to. No. Rather, I worked extremely hard, and I had the opportunity to even teach myself the law, because I was always studying the law. I was always reading my law reports. I was already reading my books. And I say this without any shadow of contradiction or whatever, that it was as a review also that the late Chief Justice Akwa identified me because of my hard work. So what I will say is that every magistrate, judge, whatever, you must work hard. Let your work speak for you, and let the promotion be on merit and not of any other consideration. Thank you.
Thank you very much for sharing this with us. My Lord, I want to tease your view on this issue. You know, in Ghana mandates retirement at 70. We have other jurisdictions that looks, especially even in America, that provides life. Extending Ghana's retirement age to 75, and whether that will require a constitutional amendment, and if you personally will support that change. Thank you.
Thank you, Chair. I will never advocate that the age of a judge, Supreme Court for that matter, be raised from 70 to 75. Why? In other jurisdictions that they retire the workers of life for life, so they will maybe run to the age of about 80 plus. as you have all become aware, the cases that will go to the Supreme Court, they are few. In our jurisdiction, in our part of our jurisdiction, the Supreme Court is always dated with so many cases. And, Madam, unless you want to be a lazy judge, you will be found out. If you want to do the work and do it efficiently, you need to work very hard. And it is very stressful. So it's not advisable that when you get your retirement age of 70, then you say, I want to go to 75. If you don't take care, the 75 will not even reach. And you will go and join our sisters. So let the law remain as it is. 70, and then you will bow out from the bench. Thank you.
My Lord, what is your view on the Article 66? The 2-term for a constitutional term of 2 for each term. Please read Article 66.
Okay, thank you, Chair. 661 says that a person elected as president shall, subject to clause 3 of this article, hold office for a term of 4 years, beginning from the date on which he is sworn in as president. Now, clause 3 of that provision says that the office of the president shall become vacant, A, on the expiration of the period specified in clause 1 of this article, or B, if the incumbent dies or resigns from office or ceases to hold office under Article 69 of this Constitution. My view is that there's no ambiguity as to the terms that a president, an elected president, must, hold. So I will go by this law. I do not think I have anything to say in contravention of this, or I will not prefer any amendment.
We take it that you don't have any issue and you feel that 2 terms is 2 terms and it cannot be reviewed under any circumstance.
I think my position is clear, that the law is clear, so we should maintain it as it is. Thank you.
Thank you very much. My other issue, going by your answer to my second question, that you don't think that we should review the mandate for retirement. From your CV, I see a challenge, because I'm really going through your calendar. And if I go through your calendar, I see one thing, that your effectiveness will be just for about 3 months. And yes, if going through the calendar, you go through holidays, vacations, and all that. So I am thinking that if we don't review that law, how can you be? Because you are an institution, and therefore, if you have to, Ghana has to benefit your very existence in the judiciary, it is important that we look at that law again. Thank you.
Thank you, Madam. Thank you, Chair. My position on the review of the age hasn't changed. I will stand still by it. Now, the challenge you are talking about Mr. Chairman, there are precedents in the service. Some judges were appointed, and if you permit me, I will mention names. Justice Professor Kuji was appointed to the Supreme Court in August 2003 during the time of President Kufuor, and he retired in April 2004, a period of about 8 months. Justice Afrebu was also nominated from the Court of Appeal to the Supreme Court, also during the time of President Kufuor. He was there for only 1 year. So the president is there. I also think that promotions come from above. So, as a Christian, and if it has pleased the Lord for me to be promoted, even if it is 1 day, I think when I go there, I will do what is expected of me, and I will leave the service honorably. Thank you, Mr. Chair.
Thank you very much. Nanabwa, Utirukwa.
Honorable member is now the turn of the ranking member of the committee, Honorable Alexander Ponyawaki.
Chairman, thank you very much. Honorable nominee, questions that I shall take you through. We'll look at areas such as perceived absence and reluctance of Ghanaian courts, particularly the Supreme Court, to engage in bold, transformative adjudication in matters of public interest, social justice, and constitutional enforcement. In fact, I have drafted these questions to test your judicial philosophy, your understanding of constitutional interpretation, and your views on the proper role of the judiciary in nation building. I wish you well as we proceed. Thank you. By the way, I heard you talk about your journey thus far in public life. Just in a very short phrase, say something about what you've learned, especially in very difficult moments, to inspire the youth of Ghana, who perhaps by unfortunate situation of their background are placed at the lowest ebb of fortune's wheel and feel that there's no life for them at all.
Thank you, Mr. Chair. What I would say in response is that hard work pays. So the youth must be conscious of the fact that in shaping their life, hard work must be at the center of whatever they have chosen to do, whether career, job, and what have you. And as a person, you must also fashion for yourself. You must plan. You must plan for yourself. My journey started as a recorder. If I have not planned that, I also want to be like, and in fact, I was inspired by both the judges and the lawyers that were.
Enough, my lord. Enough, my lord.
Thank you.
Lord, your records have it that you are a chief, correct?
Certainly, yes.
You are a gazetted chief?
I am.
Since when?
2016.
Where you come from, did you ascend to that throne through maternal inheritance, or it was an honor, or through paternal inheritance?
Maternal.
Maternal, very well. So you've at all times been a lawyer, correct?
Certainly, yes.
Very well. Do you see the performance of your traditional role conflicting with your judicial function?
Very important and dear to my heart. So I've tried to manage as far as possible to ensure that I give equal attention to the two. Of course.
My lord, it's enough. What I would suggest strongly to you is to have at the back of your mind the rule of brevity. I don't want to keep you for too long, but if you decide to be answering my questions with long answers, then you may stay for long, and the impression will be created that the leader of the mighty minority is keeping you for too long. So just bear that in mind. Now, in your career as a judge, have you had the occasion of spotting talent at the bar and taking interest in directly inspiring such talent, including nurturing them to rise in the profession?
Thank you for the question. Indeed, the questioner himself was practicing in my court. I hadn't come from Kumasi, and he has also come out from the law school. Look, the point or the habit I have cultivated over time is that I always want to encourage young practitioners to have confidence in themselves. It's not good that as a judge, if a lawyer came before you, and a junior lawyer for that matter, I mean, we are all prone to mistakes. If a junior defaults, then you'll be shouting on the person. It has put some potential but brilliant lawyers shy away from practice. So I try to, from Kwasi right down to Accra here, and even in second aid, you can check. And you are testimony of that. Thank you.
Lord, now let's look at the role of judicial activism in a constitutional democracy. What is your own understanding of the role of judicial activism within Ghana's constitutional framework? And to what extent should judges be willing to creatively interpret the Constitution to address emerging injustices or legislative gaps? The emphasis here is creatively interpret. In fact, I'm not singling out a particular judge for mention, but I've been reading his judgments lately. If you look at my Lord Kulendi's ruling, you can see a certain path. Okay? And you realize that he's pursuing certain path, perhaps because of his long years in private practice and from private life to public life. He has a combination of these and is shaping his approach in the law. I have seen your judgments, and I, to some extent, can say that your thinking in the law is towards that pragmatic approach to seeing things. However, quite broadly, I mean, for over 10 years, I have not practiced in your courts, and I have not had the benefit of reading your judgment lately. So I want to know from you, how willing are you to creatively interpret the law? We are aware recently that there's a bold decision that when a process is filed and it is served, although it may be praying for that process, may be praying for an injunction, until that is expressly granted, there cannot be that presumption that you should be estopped. That's bold and very creative. What is your own position?
My Lord, before you come into answer, a few minutes ago you've been asked to observe the rules of brevity. I would want to plead with Osahi Togbi to also observe the same rule in asking the questions. Please, you have the floor.
Thank you so much. Mr. Chair, yes, they say I should be brief as much as possible. But some questions will allow you to go into a little detail. Now, the case in contention...
I'm not limiting you.
Okay.
So please proceed. I mean, this is a critical matter that you should...
I do not think that that case espoused a general rule that if an injunction application is filed, will not stop a party from doing whatever he is doing. My appreciation of that case and the ratio in that case was that if it's as a constitutionally mandated body, then, of course, the law has been that the court can sparingly grant injunction against a constitutionally mandated body. So I believe it was on that basis that this thinking has come. I mean, and the law, is said that it's always evolving. So if the position formally was that you can't grant injunction in any case against a constitution mandated, now they are saying that even if the application is pending, you cannot stop the... Now, that is the position of the law currently. And until the Supreme Court gets the opportunity to depart from that position,
That was by way of example. So my question to you that, how willing are you to be creative in your interpretation of the Constitution to address emerging injustices or legislative gaps? I mean, I want to know from you, how willing you are to be creative in your interpretation of the law. As to the debate regarding your understanding of the ruling, we can use another forum to discuss that.
You see, Tufo and Attorney General has settled the law that our constitution is an organism capable of growth. In fact, in other jurisdictions like Australia, Canada, and the rest, in Australia they say that even the constitution is like a tree. It has to grow. Our constitution is the fundamental law of the land. And it's, apart from being a legal document, it's also a political testament capable of growth. So when the situation arises that we have to interpret the Constitution, the provisions of the Constitution, to meet the exigencies of the time, I'm all for it. I mean, what is the sense of a judge, especially when you are going to the Supreme Court? And no, I'm not a timorous soul. I'm not timorous. I will apply the law as I understand it and interpret the Constitution to suit the exigency of the time. So that is my view on that.
Thank you very much.
My Lord, so let me get this from you. What is your own understanding or your appreciation of judicial activism as a judge?
You know, there's this, they say that judges do not make laws. Of course, that is the general rule. But it's also tried that where there are gaps, it's permissible that the judiciary will grease those gaps to make the law understandable, you know, for everybody to, you know, follow it. Let me give a typical example. You know, if you look at, I think, Article 22, it is provided that Parliament should pass law on the property settlement when the Constitution comes into force within 6 months. Parliament has not done that, but it became necessary for a Supreme Court judge to espouse this principle of jurisprudence of in this case of Mensah versus Mensah. You see, you will call it as judicial legislation, but it was necessary because I do not know the Parliament has then not passed the law, and the situation demanded that there should be something about the case. That's why jurisprudence of equality principle came in, and it was a judge who, being bold. And so if the situation calls for it, and I feel that it is Parliament who must do it and they haven't done it, or the law is such, it's so ambiguous that we need to oil it, put greases in it to make it understandable, readable. Why not? I'll be prepared to do it. Thank you.
Now, my Lord, let's delve a bit into Article 132, the supervisory mandates of our court, of the Supreme Court. 132, yes, please. That deals with quo warranto, mandamus, certiorari, etc., prohibition and all. Now, my practice at the Supreme Court I came across some inconsistencies in terms of the approach to this constitutional provision. And in fact, as a practitioner, anytime I had my case before the Supreme Court, certiorari application, and I saw a particular panel, I could straight away predict that this panel, they would not hear me. And at all times, I was never wrong. Because you could see that if this particular panel is presided, however meritorious it is, they will say, go on appeal. Why are you coming here? And in fact, the anti-Article 132 bench would always say that supervisory powers in 132 are discretionary. So they would not venture, however meritorious your case may be, because they want you to go through the appeal process because you have appeal as of right. And they will further argue that go through the mill. Whereas you also believe that invoking their supervisory right would lead to justice for the party who is aggrieved. What is your own view about Article 132? Do you hold the position that even where the error on the face of the record are so patent, you must discourage certiorari applications or prohibitions under 132 by telling lawyers or parties to go through the long haul?
Yes, my Lord, you may answer the question subject to the fact that some Supreme Court judges are anti-Article 132. So you may proceed to answer the question.
My Lord, hold on a second. Chairman, with the greatest respect, I don't want us to repeat what happened yesterday. If you have a certain appreciation of my question, you can take it with me privately. But this interjection has seemed subject to what I meant. If you go to court, I don't know about your practice at the Supreme Court, but I am an active Supreme Court practitioner, and all the judges know. If you go to the court, you know this is a pro-state bench. This is a pro-this. We know. Those of us who are very active, we know how they think. If the matter is on a certain direction, how they think. There are some law judges that when you go with a certiorari application, they will encourage you to go on appeal. So don't come in by saying that subject to it is not derogatory. What I meant by bringing that one in was not to denigrate anybody. So please, let it flow, then we can make progress.
Well, I do not want our record to show that some Supreme Court judges are classified to be anti-32.
It is not. Maybe you don't understand it. It is not derogatory.
Please proceed to answer the question, man. Was that?
Thank you, Mr. Chairman.
What is this? It's getting out of hand.
Mr. Chairman, I will listen.
Today I have to register this.
Please proceed to answer the question minus that.
Yesterday we were calm. If he wants to discharge, I will stop. He should discharge him, let him go and have his way. History will record. And one day, they would also be in opposition and this thing will play to them. What is this? Enough of it.
Please, you have the floor. Proceed to answer the question minus that.
Thank you, Mr. Chairman. I do not know those judges the chairman is talking about, that they are anti-Article 132. But you see, I think the practitioners should also be circumspect Because it appears to me that it has become fashionable that cases that are tried in the High Court or in the Court of Appeal, the least opportunity, the lawyers who want to go to the Supreme Court by way of certiorari and the prerogative applications, because they feel that that is shorter than going through the appeal process. But Mr. Chairman, see, there's this principle that the Superior Court, there's no case is above that of. So it has always been cautiously maintained that before you touch the decision of a Superior Court by judicial review, you need to be cautious. So the best option, to me, I think that is what the anti-182 provision chairman is talking about. Because they will take the position that once a Superior Court is a court of unlimited jurisdiction, they have, it's presumed that the judges on that bench are presumed to know their law. Of course, as human beings, they are also prone to make mistakes. But if the matter is for an appeal, I think it will be better served if you go to appeal. Because when you go on appeal, you see, the Supreme Court, they will have the opportunity to write judgment based on the merits of the case. One is about certiorari. Certiorari, we are not talking about the merits of the case, but about procedural rules. For example, if it is established that the error was patent on the record that said that it was uttered by the powers of the court, that one is acceptable. Or if they didn't have the power at all. But if they had the power and they did the mistake in the exercise of that jurisdiction, the best option or the better option is to appeal. So my position is that 182, yes, but
my Lord, would you be the type who would hasten slowly in dealing with matters of certiorari, or you look at it case by case?
I will look at it on a case-by-case basis.
Very well. Let's make progress. Now, let me take you through constitutional mandates and judicial restraint. Our country's constitution grants broad interpretative authority to the judiciary under Article 2 and Article 130. In your view, what factors have contributed to the judiciary's cautious approach in exercising this power in transformative or activist ways?
Can you repeat the question again?
So, I'm saying that Article 2 and 130,
yes,
in your view, these provisions clothe you with those interpretative powers. In your view, what factors have contributed to the judiciary's cautious approach in exercising this power in transformative or activist ways? Now, I would give you one case.
Okay.
The Pani Lamte versus the Kojoga Adra versus Attorney General matter. My Lord Acting CJ wrote the judgment for the panel, and I will just explain to you. This had to do with public servant participating in our partisan political activities, and the contention of the plaintiff was to the effect that, yes, the 93-1, hold on a second. Because because students are listening to us, I don't want to make a mistake. 91 to be, yes, it's here. 94, 3B, those prohibitions. Now, the contention of Mr. Agra in that matter, which had to do with the eligibility and the prohibition, who qualifies to be a member of parliament. So his case was anchored on 94 3B, which says that, let me read it in full. A person shall not be eligible to be a member of parliament if A, is prohibited from standing election by law in force in Ghana by reason of his holding or acting in office, the functions of which involve responsibility for or are connected with the conduct of an election, or responsibility for the compilation or revision of an electoral register. B, is a member of the police service, the prison service, the armed forces, judicial service, the legal service, the civil service, the audit service, parliamentary service, the statistical service, the fire service, customs, excise and preventive service, the immigration service, or the internal revenue service, or is a chief. Now, in this matter, Mr. Kodjogadre's contention was to the effect that yes, these have been listed, but there were officers in the public service, specifically Ghana Highway Authority and Ghana Education Service. And he does not understand why, if somebody is a member, a staff of Ministry of Education, the person is prohibited. Ministry of Health, the person is prohibited. Ministry of Roads and Highways, the person is prohibited. But if the person is a staff of Ghana Highway Authority, the person will say that I have not been listed. Now, my Lord Bafoboni took that conservative stand to say that to the extent that those others have not been listed here, it means that the Constitution did not contemplate them to be part. I disagree with him, but I yielded. I have not seen anybody going back to really further tease the mind of the Supreme Court on this. So it still remains a law, and subsequently, those who are in the public service mainstream but not listed here are part of our partisan political activities. So my question to you with this background is, to what extent would you say that the cautious approach in exercising this power has affected governance in one way or the other? Because obviously I see some practical challenges here where a minister is instructing an officer as Ghana Highway Authority or GES and knows that the person is the constituency or regional chairman of a party and is in opposition. I feel that the court was too reluctant in dealing with this matter. What is your view on that?
My view is very simple. When the court has spoken, that is the law.
That's correct. I agree.
Yes. So I do not have any useful, addition to it.
My Lord, with respect, I'm not asking you to critique. What I'm saying is the basis or the gravamen of my question is the cautious approach. What is your view on this cautious approach to interpretation regarding governance? That's all. I only gave you that example to give a background because you said you didn't understand my question. You get my point now? Very well. Then
Honorable member, my Lord has answered the question that once the court has made pronouncement on the matter, he has no view on it. I think his answer is very clear.
I drew his attention to the fact that I wasn't asking him to critique the decision of the court in the Kojoga-Adra case. I only introduced it to draw his attention to the mainstay of my question, because he had come back to say he didn't understand the import of my question. So I needed to give him that background. So I am not asking him to question the judgment of my Lord Bafuboni, who spoke for the bench. Please. Now I have clarified that what is your view on the cautious approach by the judiciary in exercises its power of interpretation on governance? That is my question.
Very well, my Lord.
Thank you, Mr. Chair. I do not think that judiciary in every case has been cautious in interpreting the Constitution to shape our governance or our democracy. Indeed, there are cases which the Supreme Court has determined that has even helped shape our good governance and democracy. And a typical case, example I can give is G.H. Mensah versus the Attorney General. In G.H. Mensah, the summary of the case was that, or let me say, it's bordered on interpretation as to whether the ministers which the then president wanted to retain them in his government during the second time to be, to carry on with their work without parliamentary approval, because President Warren has won the second term and he has taken retained some of the ministers. Now, there's the Minister of Finance at the time, I think Kwame Poposo, had prepared a budget which was to present to Parliament. And the issue rose up as to whether he has that power to appear before the Parliament to present the budget. There was debate here and there, and the then majority said that we are going along with it. And the minister said, no, let's go to Supreme Court for interpretation. They came to Supreme Court, and the Supreme Court held that the term or the tenure of those ministers ended with the term of the president, so that if the President Warren has not won the elections, it will mean that they would have gone away. So they have been ushered into a new, they said fourth what? First session and blah, 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 blah. So I think that was the second session.
You mean the second parliament? Yes. Rawlings 193.
Yes.
And then 196.
Yeah.
So that was the second, my Lord, just a moment, because of the little ones who are listening. So the second parliament of the Fourth Republic, you mean?
Good.
Very well.
So the Supreme Court that once their term of office or tenure of office ended with the first regime, then they cannot be maintained or retained as ministers. What lesson do we learn here? The Supreme Court held that the purported retention of those ministers violated Article 87 of the Constitution. So it prevented the occurrence of recurrence violations of the Constitution, the provisions of the Constitution. So depending upon each case, and as you rightly said, it should be on case-to-case basis. So Supreme Court, they are pragmatic. After all, they are policy courts. They give directions to shape our good governance, rule of law, and the rest of it. So if they have been cautious, and they have the right to be cautious, if it demands that they must be pragmatic, they have to do it. So that is my answer to your question. Thank you.
Very well, my Lord. My Lord, you've spent the better part of your adult life after your call to the bar on the bench. I once remember you in your court saying that though you, the judges, don't go out, but perhaps you are the first to hear of every public rumor or gossip. I remember you telling us in your court. What it means is that you are equally aware of criticisms that emanate from the public space when you speak to shape governance and public opinion. Lord, would you agree with the position by some critics that the Supreme Court of our country has had the occasion to miss opportunities to provide judicial leadership in advancing constitutional justice and or protecting fundamental rights?
The Supreme Court has neglected this duty in shaping the... Is that what you said?
Oh, my Lord.
Can you...
Very well.
Please.
Very well. So, you hear of criticisms. Definitely, even amongst you, yourselves, your judgment could go up and your brothers above you will say no. I am saying that the feeling that there are times that our courts have missed the opportunity to provide judicial leadership, which leadership would have helped in advancing constitutional justice or protecting fundamental human rights. Would you agree with me that we've had instances like that?
I disagree.
Okay. My Lord, much as I appreciate your answer, is it your case also that in all situations the Supreme Court has scored 100% in providing 100% judicial leadership?
I will not say that it's 100% because it's human institution. Because the judges have the right to go right, they also have the right to err. That is why Article 129.3 even provides that when exigency comes or when there are situations that the Supreme Court will have to depart from its previous decision, they have the right to do so. They will not come out to say that they were mistaken anyway. But in doing so, they will require that there are exceptional circumstances for them to depart from their previous decisions. And then two, it must also be said that the exigencies of the time demand that they depart from their previous decisions. So I would say that being a human institution, they are prone also to make mistakes. They are human beings. I mean, and there's no judge under the sun whose decision has not one way or the other not be overturned. We are human beings. It's only God who is perfect.
Therefore, we've had instances of missed opportunities in judicial leadership. Now, my Lord, let me bring you back to this case you decided at the High Court. And if you can immediately recall, I'll refresh your memory on that.
Which one is that?
Yeah, I'm yet to say it. I'm yet to. In the matter of Ninoy Odonko versus the Iyoko, I can give you the brief facts of the case, just to recollect, for your recollection. If you remember, we would proceed. But if you...
It's a long time ago.
Sure, that's what I'm saying. I understand. My Lord, in the Nino Odonko case, Yoko had frozen Nino's account without notice to him. The man had traveled out of the jurisdiction. At the time his account was frozen. He came back into Ghana after some 5 years and made an application before you. Yoko at the time had already expended the money which was in their exhibit account. Your ruling was to the effect that the time for him to apply was far gone, so time back, procedurally, you could not apply for the defreezing at the time he was. However, the argument that he was not in the jurisdiction, and in fact, when the matter went on appeal to the Court of Appeal, your position was sustained. A certiorari was also filed, and relying on the Supreme Court's earlier decision, in a matter I will remember very shortly, he was again denied because applying for certiorari, per the rules of court, you need to do so in 90 days. So this gentleman lost every opportunity at all levels because of the time factor. He was not in the jurisdiction, his money is gone, and his fundamental human rights had been infringed upon. His right to have access to his own cash in his account had been taken away from him without trial. My Lord, my position is that the approach in interpretation was rather unfortunately very strict in this situation of Ninoy Odonko. And I consider it as a missed opportunity for the judiciary to have exercised a judicial leadership to protect fundamental rights, because on the fact it was all obvious the man has not been tried, he was not even on notice, but he's been affected by time because he could not apply. Equity would not be for his benefit in that instance. What, my Lord, in the present circumstance, would you advise the interpretation approach should be, with this in mind?
In the first place, let me say that I'm very happy that my decision was affirmed. And when you went to the Supreme Court too, you were overthrown. But coming back to your question, you see, judges, I mean, it's right that we do justice according to law. We don't do justice according to emotions. The court that you came to for it was not a what do you call it, human rights court. You were not espousing human rights issues. Okay, you were talking.
But the equity will look at substance, not form.
Oh, but the equity follows the law. Equity follows the law. So if the law says that within 1 year, and we started the Financial Crimes Court, I together with this judge who is no more with us. We started, and that time the Eco law had just been passed, so we were involved in it. And I quite remember that there is a provision in, if it has been changed, I do not know because I left the court a long time ago. Under that law, if your account has been frozen and the ECO people do not prosecute you within 1 year, you have the right to come to court to challenge it and have your account defrozen. You see, I'm not sure about whether your client has then traveled out of jurisdiction, and if it did, it wasn't served with notice. I'm not sure about that. But what I'm saying is that once the law provided the time frame within which to come to court, and you are outside the court, look, and it's 1 year. If you stay abroad for 5 years and you come to court, how will equity help you?
Okay, my lord.
Honorable leader, before you come in, let me suggest that if a question is posed to the nominee and the nominee is answering the question, we should allow him to finish answering the question before we pose another question.
My lord, the case I wanted to cite to support the earlier point I was making was the NCS versus Intelstat case. Have you come across that case? It was a 3-2 decision.
NCA what?
NCS versus Intelstat. So it's the 2012 Supreme Court of Ghana Law Report. NCS versus Intelstat. Intelstat. NCS versus Intelstat.
Yes, what happened in that?
My lord, it was a matter on appeal that went to the Supreme Court through a certiorari application. And the application was mounted after the 90-day window provided. And this was a case that my lord Bedegbe of blessed memory departed from his good brother Atuguba. It was a 3-2. He went with my lady who is now with the Council of State, I forgot her name, Akoto Banfo, my lady Akoto Banfo. It was a 3-2. My lord, in view of your argument that equity follows the law, and the fact that the courts in this instance applied the limitation rule strictly, that yes, the person did not was not in the country, but the fact that you were not in the country and the fact that the IOCO did not serve you notice will not inure to your benefit. The law says within 1 year apply. Now, if you read the Intelstat case very well, you realize that my lord Atuguba was making an argument to the effect that the court would not sit idly by and watch statutory provisions being breached. Now, with this on mind, IOCO has breached the law. The affected party did not apply on time. You think that for this, his fundamental human rights should still be denying him because he was, quote unquote, indolent at equity, and that the law says if you don't do it in a year, you are denied.
Let me repeat that I'm not too certain as whether the applicant in that case was served with a freezing order or not.
My lord, for record, he was never served. I mean, I say so on authority, and I can furnish you with your own ruling.
Yeah, so
later.
I just provided some guide as the chairman of the committee that when a question is asked, let's allow my lord to answer the question, then we can interject. I believe that is the way we're supposed to go.
Okay, so maybe at a later stage, let me have the benefit of that judgment you are talking about. But my position is that you didn't go to human rights court for enforcement of your human rights. Because if you went to human rights court, the perimeters are different from the ordinary courts. Like the Financial Crimes Court. They are quite different. And even the term limits, I think they are also different. So insofar as you didn't come within the rule, and equity will never come to your aid. Thank you.
It's okay. My Lord, let's deal with another issue that has to do with charting a judicial path for the future of our democracy. Because for me, I think we, the political activists, for many years, will rely on our courts to keep this democracy alive. And I say so with a lot of passion in me. Without you, the court, particularly the Supreme Court, this country's democracy will not survive. Now, with that in mind, what role do you think the Supreme Court should play in shaping Ghana's constitutional destiny in the next 2 decades? And how would you define your own judicial posture if presented with choice between restraint and activism in cases of national importance?
To begin with, Chairman, are you listening to me?
Oh, go ahead, the Chairman is listening. My Lord, you may proceed. The chair allows you to go on.
You have distorted my thoughts. The question again, you ask the question, please.
My Lord, what I want to know from you, that what role should the Supreme Court play in shaping Ghana's constitutional destiny in the next 2 decades? And how would you define your own judicial posture if presented with a choice between restraint and activism in cases of national importance?
To begin with, I have sworn judicial oaths, and throughout my practice on the bench, I've demonstrated my fidelity in the law. Whether it's about activism or posture and the rest of it. Indeed, it is the duty of a judge to come out with a decision that resolves dispute. A party who loses the case may not be satisfied or happy with it, but that will have been your decision anyway. So I'm not so obsessed with judicial activism and the rest of it. The core business of a judge is to do justice. And having applied the law to the facts of the case, you need to ask yourself, is it reasonable? Is it conscionable? Is it, all the qualifications that make a judgment or decision to stand the test of time? If, as a judge, you apply your judicial activism, or as we will call it, judicial philosophies and the rest of it, and at the end of it all, your law or the decision is not in consonance with the law, or I will say that, then you have done nothing at all. It may be a bad law that you have espoused. So I will look at it from the pragmatic view that, look, I've sworn in judicial oath, and where it also comes to matters bordering the security of the state, we also need to be, that is why the Constitution itself says the principle is that it's capable of good. It's an organism capable of good. So you take all these things into account before we can come out with a decision that will meet the the demands of the times. So that is what I would say that is what I would say in response to your question. Thank you.
My Lord, now I want us to deal with the issue of democratic inclusion versus constitutional restriction. And I want to pick your thoughts on this. How should the constitutional disqualification of dual nationals from holding certain public offices be balanced against Ghana's democratic values of inclusiveness and political participation?
My position is that this has been pronounced on by the court, the Supreme Court. So I do not think it will be better for me to, once the Supreme Court has come out with a position on this issue, that is the law. If there is the need for the law to be changed, maybe the appropriate time will come. But for now, that is the law, and I abide by it. Thank you.
But do you believe in the principle of inclusiveness in political participation in the light of the law prohibiting dual nationals?
Dual nationals, so far as I understand the law, if you have a dual, you a Ghanaian and you also hold nationality of other country, there are certain positions that you cannot hold. So if the Constitution says that is it. That is the law. And it's not about inclusiveness. The law is the law. Thank you.
Now, my Lord, without prejudice to existing case law principles and emphasis, without prejudice to existing case law principle, what in your view constitutes allegiance to Ghana in the modern global context? And how should this understanding shape the legal treatment of dual nationals seeking public office?
You see, this allegiance, the issue of allegiance, it's borders on our security. So if you allegiance, at a particular point in time, it must be with one country. Because if you owe double allegiance, how do you have a situation where even those countries have an issue to deal with? So that is my answer. Thank you.
The Honorable Nominee, let me deal with the issue of diaspora contribution and governance. Let me pick your thoughts on it. In your view, in what ways can the law recognize the significant contributions of Ghanaians in the diaspora while maintaining constitutional safeguards for public service and national interest?
You mean Ghanaians in diaspora or?
Yeah, Ghanaians.
Ghanaians in diaspora?
Yes, that's correct.
Yes, they contribute significantly. But if they want to fully participate in our democracy, I think they should also take into account the fact that when elections are held, they must come here and also participate. I remember one case, I've forgotten the title of the case, where a Ghanaian in the diaspora came to Ghana to vote, and the EC was saying that the time for registering that candidate, that voter, has passed, so it cannot be registered. He sent the case to the Supreme Court. And the Supreme Court looked at the merits of the case and directed that that voter must be registered. So, because they contribute, and I'm sure that we are all aware that when our president or we are trying to, woo them to come home and contribute their quota to the growth and development of the country, especially the professionals. So we need to encourage that. I have no problem with it at all. Thank you.
Lord, I would want to pick your thoughts on comparative constitutional practice. Now, to you, what lessons or models can Ghana draw from other democratic jurisdictions in the eligibility of dual citizens to serve in parliament, cabinet, or security positions? You know that some countries embrace this dual citizenship in their laws. To what extent do you think, having regard to your earlier answer of the Ghanaians in the diaspora and their contributions to our national economy, do you think that we can draw some useful lessons from other jurisdictions regarding eligibility of dual citizens to serve in parliament and even in cabinet?
I will say that if there is the need to do that, we should do it. Of course, we then have to look at the law again and see if it has to be amended to take on board the proposition that, Chair, you are making. Thank you.
Now, again, without prejudice to case law, because I submit to the proposition that the law is a law. I submit to that. So, without prejudice to that, share your view with me. To what extent do you consider the current constitutional restrictions for nationals as being discriminative or incompatible with the principle of equality before the law under Article 17 of the Constitution? And you may refer to Article 17 of the Constitution.
Article 17(1), if the chairman will permit me to read, says, all persons shall be equal before the law. 2, a person shall not be discriminated against on grounds of gender, race, color, ethnic origin, religion, creed, or social or economic status. 3 says that for the purposes of this article, discriminate means to give different treatment to different persons, attributable only to or merely to their respective descriptions by race, place of origin, political opinions, etc., etc. My tip on this is that those in the diaspora, if it's about shaping our political space or what, they should come here, they should come home and participate. So if they are there, I do not think this article applies to them. That is my tip. They cannot be said that they are being discriminated against. Thank you.
Now, let's look at issue of public trust. Risk management, public trust, on this same area. What legitimate concerns, in your view, may justify the exclusion of dual citizens from certain sensitive positions? And how should the law ensure that such exclusions are narrowly tailored and made proportionate? Narrowly tailored. The emphasis there.
Yeah, Mr. Chairman, I think certain sensitive positions, like, let me, if the example I'm citing may be far-fetched, permit me to do that. For example, if a president whose double citizenship aspire to achieve. Because if he is a president here and he goes to the United States and he is also the prime minister, in whose interest is he working for? So I think that there are certain positions. The law, if the law says that this position should not be given to a person who owes two allegiances to Ghana and to so be it, because it will be in the interest of the state that those positions are held by the indigenous or those in the jurisdiction. Thank you.
My Lord, I have just two more questions, and I mean two more, then we should be done. The last on this matter. Now you're going to the Supreme Court. I know of one Ghanaian citizen who is so passionate about this matter and is always coming to your court with cases, and definitely there will be some requests for reform and judicial interpretation. What role, in your view, should the court play in interpreting or potentially reshaping application for dual nationality restrictions in the light of Ghana's changing social, economic, and political realities? We live in a dynamic world now. Things keep changing. Going to the Supreme Court, would you suggest that we should take some new steps in reshaping the application of the dual nationality restrictions by revisiting the law?
I don't want to go into speculative analysis, but if I should answer the question, I will suggest that once the law, if you think that the law as it stands now needs to be amended, there's nothing that stops us from doing it, because even under the Constitution itself gives the parameters within which we should amend our laws. So if it's necessary for the laws on dual citizenship to change, given the exigencies of the time, I think it is appropriate to do that. Thank you.
Now, my Lord, let's deal with the constitutional purpose of bail. I know the courts have come out boldly to say that there is nothing like non-bailable offenses anymore, and have gone further to say that bail should not be used as a punishment. Now, in your view, how should the constitutional guarantee of personal liberty under Article 14(3) guide the interpretation and application of bail, particularly when conditions imposed make it practically onerous for the accused persons? Our courts are still struggling on this issue of bail. People are complaining. Investigative agencies are granting very onerous bail that accused persons, suspects, not accused, suspects, practically find it difficult to meet. What do you think should be the best approach in dealing with this issue whilst you are guaranteeing the liberties of such individuals under 14(3)?
Thank you. Mr. Chairman, if Article 14(3),
yes, I have a follow-up. Yes.
If Article 14(3) of the Constitution is read in conjunction with Section 96 of Act 30, the paramount consideration has always been that the person being suspected or has been charged with an offense will make himself available whenever he's wanted by either the police or the courts. Now, case law also makes it quite clear and plainly that when the terms of the conditions are onerous, it's amount to denial of a bail, and bail should not be used as punishment. However, it is case by case situation where the person who is exercising the discretion to grant bail should take. There are certain factors. For example, if the person is a flight risk, if a person will interfere with the investigations, and the rest of it, it's not advisable or it's not permissible that the person must be granted bail. But if it's about, so that is it. It's an exercise of discretion, and it's, the law is quite clear on it that there's no precedent in the exercise of discretion unless you want to say that it was done capriciously and the rest of it. So if the exercise of the discretion is fair, you cannot fault the person. But let me emphasize the point that the basic rule in this application for bail is that it has to, the person who is exercising the discretion of bail must ensure that the accused or the suspect will come and stand trial or will avail himself whenever is wanted. Thank you.
My Lord, as a follow-up to end the day, you've made a very profound statement that there is no such thing as precedents. Of course, case by case basis, and you've given us a broad view as the conditions for grant of bail. But there are still gaps that must be addressed to allow for some certainty. With that in mind, what would be your own reflections on the current bail practices, which sometimes seek to undermine equal access to justice for suspects or accused persons from economically disadvantaged backgrounds, and how might the justice system better serve better address such disparities, in your view? So, you know that the person is not a flight risk, but the person does not also, from where he's coming from, will not get a property, will not have somebody with a certain standing in society. And my Lord, just to share this with you, I have seen a bill term where the judge directed that the accused should get a police inspector within a certain jurisdiction to sign the bill as a bill condition, a police inspector. And then I have also cited a bill condition where the judge ordered civil servants within a certain jurisdiction, I mean like a district, you know, not from the particular district where the matter was being heard. And I asked myself, how unconscionable could this be? Is it really to grant the bill or not? So what are your reflections on some of these situations?
Thank you. You see,
my Lord, have you also cited those things that he has mentioned?
I haven't done that. But I was going to even ask him, he was talking about gaps. Which gaps was he talking about, so that I will be able to answer the question rightly?
No, with respect, I referred you to situations where we access to justice for suspects who come from economically disadvantaged background, and how we can address this situation to create a better access to address such disparities. And it's a reason why I give you that example, because the ordinary Ghanaian is still concerned about the terms of bail, how onerous they are, after the court decided that now all cases are bailable. So I hope there's clarity now, or I should still expatiate.
I've understood you.
Thank you.
I think in such situations, you need to apply for the review of the court order, and if it is refused, you go up, or you may want to even go to, if the case is pending in the lower court, you can go to the high court for Judiciary to have it quiet. Because as I said, I mean, bail is not used as a form of punishment. Therefore, if you think that it is onerous and you can't meet it, I think the best place for you to go is to go to the high court or a higher court that can, you know, look at it and then make a determination for the bail to be rescinded or varied, as it were. Because the law is that the paramount consideration in all this is that the person must come to court to stand his trial. Because look, if it's a police inquiry bail and the person ends up in court, the court will not say that because the police granted this bail, I'm going by it. The court will look at the circumstances of the case and will fashion its own bail conditions. And a judge who is informed of this law, the position of the law, that the purposes of a bail, so far as Section 96 of Act 39 is concerned, is that we need to ensure that the person came to court to stand his trial. I do not think, of course, when you start at first, you can do all sorts of things. As David said, when I was, is it David? No, Paul. When I was young, I did my things as a young person, but now that I'm old, so if you start as a magistrate, these are some of the things But as you grow, and the experience will tell you that you need to, soften your stand in some of the matters. I mean, how would you say that the person you want to impose conditions of bail for which the person cannot, get out of? Because he must be given a free trial, a fair trial, and a fair trial means that you must give the person the opportunity to prepare for his defense and the rest of it. But if you keep the person in cells or in custody, how will he come to defend himself? So that is my position. Thank you.
Thank you very much. Honourable members, our revered guests, we've come to the conclusion of the vetting. But following some matters that ensue yesterday, when we were vetting Justice Sir Dennis Dominic Adjei, a letter was written to the GRA, and they have the response sent to the chairman of the committee. For the purposes of the record, I may want to read the letter verbatim so that it can be captured accordingly. The letter dated 17th June 2025 on the letterhead of Ghana Revenue Authority, GRA, addressed to the Chairman, Appointment Committee of Parliament of the Republic of Ghana, Accra. Dear Sir, task position of the Supreme Court nominee, Sir Dennis Dominic Adjei, on income from part-time teaching. Reference is made to the request of the Appointment Committee during the vetting of the Supreme Court's nominee, Sir Dennis Dominic Adjei, regarding the payment of tax on income derived from his part-time teaching. Sir, under the Income Tax Act 2015, Act 896, as amended, the income derived from part-time teaching is subject to final withholding payment at the rate of 10%. Section 116A(2) and 1191F and paragraph 8C(2) of the first schedule to the Act 896. The obligation to withhold is on the withholding agent, that is the payer of the amount, and not on the withholdee, and it is done at source, that is at the time the amount is paid or payable. Section 1161 of Act 896. Once the tax has been withheld, that satisfies the tax liability of the withholdee under Section 11B of the Income Tax Act, because it is a final withholding tax, Section 1192A of Act 896. The withholdee, Sir Dennis Dominic Adjei, is not required or obliged to declare that income on the tax clearance certificate, into bracket TCC, because it is a final tax as stated earlier. Therefore, the tax clearance certificate issued by GRA reflected his income earned for the period the tax certificate was issued. Thank you. Yours faithfully, Mrs. Kate Nto, Kimbu Sub-LTO managers for the Commissioner of Ghana Revenue Authority. Thank you very much. I will then proceed to acknowledge. Honorable members, I will then proceed. Order.
It's here. It's only one chairman.
I will then proceed to acknowledge our revered guests. First on the list is Mrs. Dorothy Mensah. Order. Let there be order. Please, Uma, let there be order. Please, Jerry, let there be order. Mrs. Dorothy Mensah, Mr. Philip Bright Mensah Jr., Bishop Dr. Abak Wilson, Mr. Charles Aidan, Deputy Director of Finance, Judicial Service, Dr. Ebenezer Akwabente, Oketechie, Professor Amemfi, Omanhini, Asebu Traditional Area, Nana Amemfiwa, Queen Mother of Asebu Traditional Area, Nana Bochrewa Ikumbri, Ebusiapeni, Nana Edweful. Justice Christopher Archer, Her Ladyship Jennifer Abena Dazi, His Lordship Jerome Noble Nkrumah, His Lordship Anthony Opon, His Lordship the Acting CJ Justice Paul Bafoboni. You are all welcome. Honorable, very well. I do not have the name of Justice Yoli Kulendis, but I have been informed that he is here. He is in a mask, so there is a difficulty recognizing him. I recognize the presence of Justice Yoli Kulendis, Justice of the Supreme Court. I'm also informed that Mrs. Bafoboni is also here. On my own behalf and on behalf of the committee, you are warmly welcome. Very well. I recognize all the Queen Mothers, those whose name I do not have here. There will be difficulty mentioning your name because I do not have your names here. Forgive me. You are also welcome. Honorable nominee, on behalf of the committee and on my own behalf, we thank you very much for attending upon the committee and providing answers to questions. We are also happy for your endurance. We've gone beyond a stated time, but bear with us. You will surely hear from the committee. You are hereby accordingly discharged.
Thank you so much for the opportunity to meet you. Thank you.
This week on Women Power Politics, we explore the critical issues driving women's advocacy in Ghana with one of the most powerful voices behind the movement.
Somebody will shake your hand and tickle your palm, and when you do this, they say, why?
The executive director of the ACT Foundation, home to Ghana's first shelter for battered women.
I call myself a child of God called to do work.
Every day, people have money emergencies. Ma, I need my school fees emergency. Mommy, chop money emergency. Emergency. Rashid, I'm your rent emergency. Now, there's a new emergency number in town. Dial *770# for all your money emergencies and chop life.
Dial *770# for money emergencies and get easy and quick access to your money, loans, and other banking needs. EcoBank, the Pan-African Bank.
Will be crowned for JoyNews Impact Maker 2025. Catch it live on JoyNews, Joy 99.7 FM, and streaming on all our social media platforms on Saturday, 28th June, 7 p.m. at the EcoBank head office across Central. The JoyNews Impact Makers Awards is brought to you by McDan Foundation, empowering futures, building communities, Gold Key Properties, transforming the landscape, M&C Group Global, Totally Reliant, German Ozone Medical Center, Alternative Therapy, Dental Wellness and Beauty, and latest form, your partner for life. CEO Summit, inspiring businesses and economic transformation. Maranatha Oil Services Limited. Safety is our priority. Ministry of Gender, Children and Social Protection. The Center for Strategic Philanthropy and Social Investment. Unleashing transformational philanthropy, research and innovation for community impact. Philanthropy Ghana, promoting and elevating philanthropy in Ghana. JoyNews Impact Makers Awards, celebrating ordinary people making extraordinary impact.
The EcoBank JoyNews Habitat Fair 2025. Dream it. Own it. Live it. Coming soon.
They may be young, but don't be deceived. These rising culinary stars are ready to battle it out in the most intense kitchen showdown on television. With mind-blowing challenges, surprise twists, and jaw-dropping dishes, only one will rise to the top and claim the title. New rivalries, bigger stakes, and epic flavors. Who has the skill, the heart, and the strength to survive the fire in the kitchen? Join me, Michelle Ajakum, the judges, and the awesome kiddie chefs every Sunday at 4 p.m. only on Joy Prime. Big share.
Good news, my kids.
Congratulations, Multimedia Limited, Joy FM, on your incredible 30 years of shaping voices and connecting communities. On behalf of Republic Bank PLC, we celebrate this milestone with you. Your commitment to excellence and impactful journalism has been truly inspiring. As a proud partner from the early days of Habitat Fest till today, you help us shape our brand, connected us to homeowners both in Ghana and abroad. And we are truly grateful for this partnership. As you celebrate this transformation journey of 30 years of journalism, thank you and continue to be a beacon of impact, then, now, and always.
Hello there and welcome back to the Joy News channel. It's time now for polls. We've just been bringing you the live coverage of the vetting of the nominees that, if they make it, will be headed to the Supreme Court. And today, the spotlight has been on Justice Philip Bright Mensah, who has just been answering a lot of questions, quite a legal battle there. We'll cross over a little later for the next vetting. And as well, James Aveji will be on standby to bring us all of the details that you may have missed. But you are welcome to the polls, and the polls is always brought to you by Defendrol Cough Expectorant. Defendrol, breathe easy, feel better. I am Emefa Akusiadeti, and guess who I've got here today with me? Yeah,
yes.
Yeah,
it's been a while.
It's been a while.
I've missed you,
and I love this as well. When we get to understand some of the things that happen at the vetting, we'll cross over.
That's a lengthy one, though.
Of course, we will. And yesterday was even more eventful. We'll get into all of that and plus today and as well. But a little later, when we get the opportunity, we'll speak to some experts on how so far they've gone. But we'll go to James when he's ready. But so far, you've been following. Yesterday, you were here.
Quite a long one yesterday. Yeah. The minority leader did us the honors of making sure we stayed here the whole day yesterday.
Yeah.
But quite an interesting vetting proceeding. For me, sitting at the back, just listening to some of the key things that came up yesterday. It was quite a legal, educational journey for me, just looking at some of the key concerns being raised by the judges before the vetting committee. One thing that stood out for me really yesterday was that controversy about the gaps in Article 60 of the Constitution. It actually spells out a succession architecture in the country, but then the gaps are quite wide as to who exactly will steer the affairs of the country in the absence of the president, the vice president, and the Speaker of Parliament. Something that happened not too long ago, where the president was outside the country, the vice president outside the country because she was out on medical leave. The Speaker was also outside the jurisdiction. And so it was quite a difficult task finding out who exactly is steering the affairs of the country. And that came up yesterday. Some people were of the opinion that the Chief Justice automatically should step into the role as president in the absence of these three individuals. And it was subject of controversy yesterday. The question as to if there's indeed a lacuna in that article came up yesterday.
That's a good place to take us to. We'll go to the appointment committee where James Aveji is on standby. When we come back, we'll get into that. We'll try and answer a few questions. We'll turn ourselves into resource persons and answer that. But hi, James. Tell us, what did we miss at the appointment committee and who's next to be vetted?
For those who have been following.
Not so much, especially for those who have been following the live broadcast on the JoyNews channel, might have followed all of the discussions, especially today's vetting has served as some flip side as well, where there's been some lighter notes on the vetting committee between the committee members as well as Justice Bright Mensah, Philip Bright Mensah. But one key issue that's been coming up from his vetting has been his proposal for the nomination of at least 20 justices to the Apex Court. That has been the matter at the center of controversy over the period, and it has been featuring heavy on the vetting process of all of the 4 nominees that have been vetted out of the 7 so far, and I would want to believe that it would still feature in the vetting of the rest.
need to.
Well, we'll try and reconnect with James Savage again to get the details on a few things that came up today. Now, before we go into Article 60 and as to who comes up or who should be governing the country, one of the controversies would be that if the Vice President is not available, and then the Speaker of Parliament is not available, and then the Chief Justice is available, whoever the Constitution arrives at or allows to be the acting president, two things comes up. When they take a decision, should it be binding on us? When they take a decision that is a very life-changing decision for us as a people, should it be as they have taken at the time that they are acting, or should they even take an oath? Should they swear an oath before, or they should just assume automatically?
That came up when Roxanne Nelson Daffy-Amekpa had the conversation with us here on JoyNews Prime. When we're having this whole conversation, the minority were quite worried about the situation. They wanted to find out who exactly is there in the affairs of the country. That came up. Roxanne Nelson Daffy-Amekpa's argument was that indeed the Chief Justice takes over the position automatically. But then the concern being raised by the minority was, at what point was the Chief Justice sworn in? Was the Chief Justice acting at that point? Because we all know at that point the Chief Justice was going through the proceeding and still even going through the proceeding for investigations, and hence she's been suspended. And so the Chief Justice currently occupying that position is acting. And so can an acting Chief Justice actually take up that role? It's a conversation that we need to have. The reason why yesterday some of the key panelists that went through the vetting committee felt that indeed there is a lacuna in that article and they ought to be looked at if we want to look at how...
If an acting is acting as well.
Exactly. Yeah. But then I feel that our laws are made for humans. And as we evolve as humans, we should make provisions for this law. Some 8-10 years back, we didn't have a situation where 3 individuals were outside the country, the president, the vice, and the speaker as well. I think it's high time we should look into the constitution if we need to make provision for that, so that in situations like this, we can actually have someone defined by the constitution that will be steering the affairs.
It's good that you have brought this, the lacuna that we find in our laws. And now today again, the conversation about an 18-year-old can get married and a 16-year-old can consent into
our defilement laws. That was a subject of controversy yesterday. Sir Danis actually raised it up during his vetting. He was quite concerned that our laws allow for a 16-year-old to give consent. At 16, you can give consent for sex. However, our laws only allow you to give consent for marriage at age 18. And he's of the opinion that there's a gap there, really, because if you are not able to give consent for marriage, why should you be able to give consent for sex? And it's a conversation we need to have. I'm sure that's why the committee looking at...
The Justice asks a very relevant question. You know? Are they ready to wait till 18? Can they wait?
Can they?
He asked that question.
It's a big question we have to ask. And indeed, we need to work on our... And I think this is quite key at this point, because we have a constitutional review committee already doing their work. This is not the first time a committee has been set up by government to look at our constitutions and the gap within the constitutions and solicit ideas from journalists and sector players on how best we can frame our constitution to best fit some of the challenges we're facing in the country. And this is something that they might want to look at. Another thing that came up yesterday, MFA, was the retirement age of judges.
Absolutely.
The proposal to either push it to 75 years or maintain the 70 years. A lot of different opinion as to how this would pan out. But I'm of the personal opinion that we should actually even reduce the age. That way you have them more active in service. When they're retiring, they can take up other roles. But, well, yesterday, a lot of opinions as to how to go about it.
How about the theory? Let's take a cue from what the professors and lecturers, academicians have said, which they've raised some arguments. They've said that if you push the retirement age of a professor or an academician a little further, it allows that what they have learned and the experience they have gathered over the years, they're able to utilize them even more, and for younger people to actually draw from them and learn from them.
Experience is subjective, I feel.
A professor who is 75 and has acquired all of the knowledge, of course, cannot be the same as a 30-year-old professor.
Far from it, but we're living in an age and time where we have artificial intelligence. the experience you're bringing on board is something AI can, think about in a matter of seconds.
Let's try. Let's put a
solutions
in AI and ask, should the legal consent?
I feel that. Let them go early. Let other people come on board. And then let's see how best we can go about it.
Okay. Well, stay with us. Let's go to our colleague, James Aveji. James, we lost you right there. You were bringing us up to speed as some of the things that happened at the vetting today.
Certainly, MFI. I was talking about the major proposition of Justice Philip Bride-Mensah on the number of judges to be appointed to the Apex Court regarding the controversy that has been surrounding the matter. And the call for some is that we need to look at Article 128 of the Constitution, probably amend that to put a ceiling on the number of judges to be appointed to the Supreme Court and all of that. And for him, he thinks that at least 20 judges should do for the Supreme Court, looking at the load of work they have to do and all of that. Since yesterday, there have been conversations about what the U.S. jurisdiction has vis-a-vis what we have in Ghana, where Justice said Dennis J, for instance, have been explaining the U.S. jurisdiction and what it provides. And he have been giving some clarification that it is not entirely true when people say that for a country like the U.S., Supreme Court has just 9 judges, and Ghana would have, as we speak, we have at least 17 judges, with some going on retirement and others being appointed now to step in. He says that that is not entirely true, and that in the U.S. jurisdiction, almost every state has a Supreme Court where only federal matters are sent to the federal Supreme Court of the U.S., where you have the 9 judges. And so it cannot be entirely true that the U.S. has only 9 Supreme Court judges, have been given that education. And so as far as Justice Philip Bride-Mensah is concerned, we should be having at least 9 judges at the Supreme Court to look into that issue. Honorable Hassan Tampuli also brought in the Nigerian jurisdiction, where they have a ceiling of not more than 21 judges, and how we can look at that vis-a-vis the Ghanaian jurisdiction, and also make the point that perhaps maybe that is why we have a number of cases pending at the Nigerian Supreme Court, which they are not able to dispose each year. And so there have been conversations around that. Again, we had issues coming up about the legal age for, sex with consent among especially girls. If you look at the Constitution, it stipulates that a girl can have sex with consent at 16 years, but will not be able to marry at 18. Hajia Ladi Ayamba brought up that issue and talked about the fact that how that does not make sense to her, why the Constitution will allow for girls to have sex at 16 but could only get married at 18. And so was asking Justice Philip Bride-Mensah if he would hold an advocacy for that part of the Constitution to also be reviewed, so that the age for consensual sex could be increased to 18 to match that of marriage. That was when, after understanding what the MP was saying, exclaimed, he said, "Hey," and then burst into laughter. Then later came on to make the point that, if only the ladies will wait to be 18 to have consensual sex. Chairman of the committee, Bernard Ahiafo, took the view that if that is done, then we should be prepared for more cases of defilement hitting the court. But at the end of the day, he believes that we should just keep it as it is now in the Constitution. The law should just be the law. We shouldn't worry ourselves about that particular provision and what it entails, and thinking of making some changes to it. So those are some of it. And for some of the flip sides, were the issue about how looking at his CV and the number of legal issues he's been engaged with education and all of that, and how he marries that with his social life. That was when he drew upon the issue expressed by one of the judges yesterday. I want to believe Justice
Simon Subari.
Justice Simon Biel, who talks about the fact that he, after losing his wife, unfortunately tried to get married again, but unfortunately the woman left him because he could not make out time for his family and social life. Justice Philip Bryce Mensah drew on that and talked about how he also could not get a spouse for himself, or lost his first spouse and could not get another one because every woman perceived him to be what we call anti-so, or he's too much private with his life. And the fact that those are some of the sacrifices they have to make as justices, who not only as judges in court, but also have the to hold the moral standard of society, where you are not allowed to mingle with a lot of people, because if you are mingling with people and such people come to before you at the court, a lot of people will perceive that you are going to tamper justice with mercy, or your ruling on their matter may not be a true reflection of what the law entails on the issue at stake, but could be that you are a bit you soften your hands on them and could not deliver true justice. And so those are the reasons why most of them judges do not have friends. They pick and choose who becomes their friend. And sometimes they would have to sacrifice time, the time they have to have with their families and all of that. And so those are the key issues that have been coming up. And the matter of how he would propose the issue of galamsey or environmental cases to be handled when they come to the courts, providing especially the fact that the current government, through the Minister of Interior, let go Chinese or other foreign nationals who are arrested in the galamsey site together with their Ghanaian counterparts, and how we can deal with the matter. He, on a more serious note, thinks that there should be a look at that, but he believes that perhaps the reason why we are letting the other nationals, especially the Chinese, go is the language gap that exists between us and the Chinese, where sometimes even some of these suspects, when brought to court, are not able to speak the English. Even some who hear a bit of English would pretend not to hear the language, and so posing difficulty to judges in prosecuting these issues. On a lighter note, he says that maybe some of these judges in this galamsey-prone areas should be taken to China to be trained in the Mandarin language, so that when they come back, they can have upper hand over these issues. And also went on to flex his Chinese Mandarin language muscles with chairman of the committee, Bernard Ahiafo, who greeted him in Chinese, saying ni hao, and taught him how to respond to that and all of that. And then came the ranking member on the committee, Apenyum Makin, who went more into the courtroom, delve into some of the key cases he has presided over and has made some ruling over, and tested his knowledge on these cases, these rulings, and whether or not, if he has the opportunity, he would differ from some of the judgment he has pronounced. But largely, he has maintained his stance on some of these issues he presided over and given ruling on, and maintained that these cases, sometimes it is either lack of evidence on the part of the prosecutions, that some rulings will go in some cases. His advocacy generally, as Faustina was mentioning about the adoption of technology and all of that, and that has generally been his area of advocacy, as well as the call to strengthen the lower courts, especially the appeals court, so that not much cases will be traveling from the appeals court to the Supreme Court, to lessen the burden on the justices at the Supreme Court, and also cautioned lawyers who have the appetite in dragging every single matter the appeals court preside over to the Supreme Court, hoping that the Supreme Court would overturn some of those judgments in their favor and all of that. And so generally, that's the atmosphere. That's how the atmosphere has been at today's vetting of Justice Philip Bright Mensah at the Parliament House here in Accra. We are on break now. We'll be returning at 4 p.m. to deal with the first female out of 2 females who have been nominated by the president amongst the 7 nominees, Justice Janapari Battles Kojo, who will be taking her seat as the first out of the 2 females nominated to answer some questions. We'll be expecting that this drag to at least 6 or maybe 7 p.m. As far as the second vetting would be concerned for C and MFA.
Right, James, perfect. Now, we'll take a quick one and do a detour, but when we come to you, what I'm interested in is how he dealt with the question about what we should be doing to illegal minors who are foreigners, as whether we should ship them or we should have them face justice here. As we know, Democracy Hub has actually filed a case in court suing that arm of government that they should be tried in Ghana. What he's been saying about that when I come to you. But when you wrote your BEC, Fosti, the last one, the very last one, how did you feel about it? What did you eat that day?
Great. What did I even eat on that day? I can't even remember. But I felt extremely great. And it's a good time to take us all the way to Nima, because Stephen is on standby. We know that some individuals will be writing tomorrow Islamic paper, which will be the final paper for some of them. But for most students, today would be their final paper. Let's cross you over live now to Nima. My colleague Stephen Mensah is on standby to engage some excited students who just completed their paper. Stephen, what can you report?
It's been quite an interesting one for me, especially since it's been quite some years. I'm not going to disclose when I wrote my BEC. We've seen emotions range from tears to laughter. I've seen people pour powder on themselves and water on themselves because they're happy, because they're done with their BEC today. I'm here at the Kanda Cluster of Schools. I want to speak to some of the students on what they make of it as a noun. You're welcome to JoyNews.
Thank you.
I want to start with, how happy are you?
The way I'm happy, I can't even say it. Like, I don't know. I'm really, really happy.
I see. How about you?
I'm also very happy that, inshallah, God has brought us here. We finished our BEC in peace, and we are going home to jubilate with our friends in peace. So
I'd want to ask you, how are you going to use this period from now to September when your results are released?
I'll help my mother with her work and be studying more for my next level of school.
You don't seem so happy for me. Are you genuinely happy?
Yeah, I'm very, very happy. Okay. I'm very happy.
For you, what was the most difficult subject you wrote?
Maths was a bit difficult, but I could do it. But I'm very happy. Yeah.
Okay. I'm still here with some more students. I'd want to ask you, how happy are you? I've been asking everyone, but how happy are you?
I'm really, really happy. Judging from my smile, you can really see how happy I am, because 9 years of education up to this point is really an amazing point. Being able to finish our BEC in one piece is really amazing, and I thank God that He's able to bring us to this moment right now. I'm really, really happy, genuinely.
What course are you planning on studying when you go to the senior high school?
Well, I'm really interested in doing general arts because of my career choice.
What was the career choice?
I want to be a journalist, just like you guys. I believe misinformation is the reason why we have a lot of hatred in this world. So I think if I come into this world and I'm able to keep my promise and my virtues, I'll be able to spread good information that hatred will not be in this world. So that's my core belief about journalists. That's why I want to be a journalist.
What was the most difficult course for you, the subject for you, writing this exam?
I would say tree.
That's quite interesting. Why was it difficult to you?
the section B was okay, but for the section A, I was finding it really difficult. Even though Twi is my Ghanaian language, it's my home language, but then when it comes to writing Twi and answering Twi, it's very difficult for me. But then I did it well in the Twi.
Young one, how was the exam?
Oh, it was well. Everything went okay.
I like your smile. I really like your smile. So what are you going to do going on? What are you going to do? From now to September, what are you going to study? What are you going to do?
Oh, I'm going to master on my course, what I'm going to do on SS. Like, I'm going to apply for technical automotive. So I'm going to enter into the training before I read there.
Well, MFA, Ed Faustina, here at the Kanda cluster of schools, there's been a range of emotions, from laughter to tears, joyful moments here at the Kanda cluster of schools. Back to you over in the studio.
Thank you, Stephen, for giving us that conversation. And really, it's been great so far just listening to you interact with the students. They're quite optimistic. Those days when MFA, when you ask us how many A's are you expecting? We're expecting straight A's.
For the BC, 10 ones and all of that. Yeah. But before we went to Stephen, can you imagine Steve saying that I'll not disclose when I wrote my BEC? Oh my goodness, and God giving us. So you recall that. Let's talk even about BC generally. This year, I've seen that WAEC has taken it a step higher or a notch higher, indicating that if you're a teacher, a supervisor, whichever way you're linked, if you're a teacher and then you're found helping in any way or engaging in examination malpractice, well, that will be an outright dismissal.
Well, for me, examination malpractice has always been an individual problem. Even though you have systems in place to check it at various levels, it all boils down to the individual. If you want to cut corners, you would do so. And you always find the way to do so. Even those days when we're writing BC, you have to go through a lot of checks. Even at the entrance, they take your phones, your bag, they give you instructions. People still find a way to cheat. And teachers sometimes are complicit. It's an individual problem. You have to rise to the occasion. You have to feel you are up for the task. You have to go there and deliver. And for most students, they feel they are not up to the task. That's what I feel. That's the reason why you would want to cheat your way through.
Again, it's nice to know that the Minister in charge of Education is providing some sort of respite for these candidates who were unfortunately involved in accidents when they were headed to take their exam at the Tamale Secondary School. They have said that if there's no justification, you may have to sit for the exam next year. But many have also said that because that power is quite discretionary for and to WAEC, they can exercise that discretionary power to say that, well, we've looked at the fact of it, on the face of it, we think we can allow these students to actually take the exam. But what I do not understand is that both the school and then the hospital haven't said anything officially, at least to help these students make their case. Because from our reports, you'd hear that, well, they show up at the exam centers with the plasters and showing that, well, they are unwell, they have just been involved in in some accident, some form of accident, but are not showing that, that document or that thing that would allow them to be able to fetch that seat for maybe taking the exams and not having to wait for next year. And I've heard the minister say that they were looking to investigate and at least allow these students, second chance to take the exam, because I cannot imagine you, if you're really prepared for this year's exams, you having to wait for the next year. Again, we cannot talk about the exams without young ladies who were pregnant and had to sit for the exams.
Indeed.
And we applaud that young lady who was nearly in labor, or I must say was even in labor at the time of one of the exams, and still after delivery, still came back to sit for the exams. And that is just a showmanship of dedication and resilience. And for a young girl, of course, during that age, they're a bit younger, but they still show that strength to be able to, take the exams and all of that in the face of all of the challenges.
I think our educational system has evolved over
very much.
Giving room for some of these women, ladies, and children to actually partake in the examination. those days when you are pregnant, in your mind,
it was almost like a snooze. It was the end, yeah.
You know,
yeah.
But now we have our systems where you can still come back to school. You can still find your life back. You may have made a mistake. It might even be a consensual decision to get pregnant at that point, but then you have the opportunity to get educated. And for us, that is one of the things that we're proud of. I think our educational system has evolved and we are seeing growth. And it gives women the platform to want to drive harder in spite of the challenges around them and achieve more. And that's why we'll be touching base with our correspondents across the country just to get a sense of how the exercise went for different individuals. We'll be going shortly to the Volta region. Ivy will be on standby for us. Just give us a sense of what is happening in her region.
Volta region, yeah.
Emma, across the region so far, I think this exercise has been peaceful so far.
Yes, except in the Western region. Natalia reports that there were some candidates who were involved in a motor accident. At the time that we did that report, that the rider of the motor was hospitalized, because then I was interested in whether the police had started any investigation. Again, for those set of candidates who were involved in that accident, still also showed up at the examination center to still take the exam. There was also another person who unfortunately was reported to have had an episode of peptic ulcer, but we'll get into that. But before that, let's go to the Volta region. Ivy Setoji from the Volta region. Ivy, what's it like in the Volta region?
Currently, the students have just finished writing their last paper, and some of them are still on campus jubilating. I am at the Sokode Senior High School, which is one of the centers. Some of the students are still here, especially the Mater Ecclesia School, a private Catholic school in Sokode. They are here. We spoke with some of them who are very confident of coming out successfully. So across the region, especially the places I have visited, students are confident that they will come out with flying colors. They are happy as they speak and still on campus.
Right, Ivy, in the Volta region, you also reported in the week there was a young lady who was pregnant, or two of them, I think, who also sat for the exam. Did they make it to the finish line?
Yes, of course. When I got here, I saw her in a flash. I saw her excited, talking or speaking with her friends and colleagues after they came out from the exam hall. Yes, the two of them were able to finish up the paper. And I saw that she was visibly pregnant, as people say, heavily pregnant. According to the teachers of this student, one of them may put to bed maybe even this month or early next month.
Right.
Ivy, just before we let you go, any case of examination malpractice recorded in your region?
Not that we know of. For now, we've not heard of any examination malpractice. We checked across the region and we've not had any issue of malpractice in the region.
Thank you so much, Ivy, reporting live from the Volta region. And we're touching base with our correspondents across the country just to get a sense of what is happening on the grounds. And we're also keeping our eyes on Parliament as well. The committee is set to arrive shortly to vet the only female in that committee's vetting today. And
one of the two females, actually.
One of the two females. And we're looking forward to that. We'll be taking you there live at 4 p.m. when that starts. But let's stay with the BEC and touch base with our correspondents across the country. We've gone to
the Volta region. Okay.
And then we've gone to Volta region as well, MFA.
Now, I think there should be a prize for regions that do not record malpractice. This is me taking one for the Volta region. That is quite impressive.
Region. We should be going to the Ashanti region soon, just to get a sense of what is happening there. I'm sure the students are excited. You know, Ashanti 40, shucks.
Yeah, we were on with the Western region about in Natalia's report about how some young girls as well were involved in a motor accident, and at the time that we reported, the rider of that motor accident was also admitted at the hospital. Now, back in the northern region, when Martina brought us that report about these candidates who were involved in accidents, what struck me was that, so these candidates were en route in a tricycle. I mean, maybe it will be a stretch, but it will tell you that people are not having equal education. People are having equitable education in this country because of what some candidates may have to go through and face. And in the face of that, still wanted to take the exams. We're also reporting still in the northern region was a young girl who also took ill and had to be taken out of the exam hall. And we reported that she was struggling with peptic ulcer, and that was very severe. In fact, if you look at the undertaking from the medical officer who wrote on her behalf, says that the exam paper should actually be taken to her at the hospital. But now let's go on the phone and engage John Kapi, the PR for WAEC. Thank you for joining us. And it will be safe to say congratulations on quite a peaceful examination so far.
Very much, yes, indeed. We would congratulate ourselves on a peaceful exam, even though there have been a few hitches here and there.
I'm interested in those hitches here and there. What cases are you reporting across the country?
Well, on our part, I think that in terms of production and getting stationery to our candidates, we would say that we scored a high mark. There were on our part, the hitches I'm talking about are related to the late arrival of question papers to some of the centers due to the bad nature of the road. But then it did not really affect any of the candidates. So on the whole, we'll say that, yes, we are glad. The other side of it is the conduct of some of our supervisors, invigilators, and then some heads of school. Unfortunately, whatever they did leaves a lot to be desired.
And let me get a sense of the reports you've been receiving across the country, the number of individuals implicated in some form of examination malpractice. What figures do you have?
Well, as we speak, per my records, I have 25, even though I've received others I've not formally recorded.
25
cases.
Give me a breakdown, regional breakdown as to the number.
It will be difficult for me right now because I'm not in the office. But then I think the highest number comes from Bono East region. Okay. We have also some cases from the Bono region. There's one case from Northeast region. There was one case also from Western region. We have one from Ashanti. And from Eastern, we have about 6 cases. So these are the ones that I can recall off my head at this particular moment.
I like the kind of examination malpractice case you're dealing with and some of the cases that you have on your hands. Give us a sense of what exactly happened based on the report you've received.
So per the reports that we have received, for most of these people that we are talking about, the vigilators and then the supervisors in particular had on the mobile phones, and there was evidence of them having taken pictures of the question papers that they had circulated on some social media platforms, or at least sent to some specific individuals. Now, on the part of some of those who were not directly related to the examination, there were 2 head teachers that were picked up. There were about 7 people that were picked up who were not directly involved with the examination, but who found themselves in the examination area where they had in their possession photocopied answers to the questions, and they were busy distributing that to the candidates when our personnel accosted them.
Right. Mr. Kapi, let's go back to the northern region. Have you revisited that case of some candidates who were en route to take the exams and had an accident?
Yeah, so we the information that we have from our branch controller in Tamale indicates that there were 12 of them who were in this motorized tricycle. Unfortunately, they collided with a motor rider, and then 8 of them had to be taken to the hospital. Unfortunately, the motor rider passed on. That's the information that we have. So the 8 that were sent to the hospital had to be treated. and they returned at the end of the paper without any formal report from any medical officer as to why they were reporting late. And so they did not have the opportunity to write the examination. That's the information that we have. Now, when these issues occur, we are not able to offer any remedial measures because the council does not make provision for individuals who may have missed the examination without any formal report from us. So I would say that for now, those candidates have missed that opportunity. If there are any remedial measures that will be taken by the council, I would not be able to speak to that for now.
But shouldn't the council be considering looking into this, looking at what we have on our hands and giving them some sort of opportunity to write the exams? You can go back to the bench and then come up with something that helps these children at least. Isn't that something you're looking at?
Well, for now, for this particular situation, I would not be able to give a specific response, but with reference to previous incidents, all that we ask is for some, prior information to be given about the condition of these candidates so that at least one of the major things that we do is that for anyone who is unable to go to the examination center at the time of the commencement of the exam or when the exam is in progress, we have to quarantine those particular candidates. In this particular context, there was no communication whatsoever with the supervisor, neither was there any communication with the branch controller or any of the vigilators. I am not sure about the role that the head of their school played in this particular situation. Now, from previous experiences, people have taken advantage of this and caused a lot of mess for us in terms of examination malpractices and then also circulating questions in a manner that they should not have done. So technically, we have not made any provision for any candidates who may have delayed in appearing at the examination center without any prior notice to the officials at that particular examination center.
But isn't their reason justifiable enough?
Well, you look at it from different angles. For now, nobody has made a formal complaint to any of our personnel that were deployed in the field. Neither has there been any formal, request to the branch controller who is in charge of work in the region regarding this particular issue. So as we speak, I would say that there's not been any formal request for us to do anything to that effect.
Should you receive a formal complaint, will you consider these children and allow them write the exams?
Well, it is not for me to decide at this particular moment. Certainly, there will be the relevant committee of the council that may take a decision regarding this particular issue.
Right, Mr. Kapi, so normally, what does the remedial look like? If the council will sit from history, I mean, you have just painted a picture of how previously some candidates would, cause some mess for you as a council. But if the council indeed sits, what does it look like? What will be the remedial measures? What would they look like for the candidates?
For now, what we have in place is that once you've missed a particular paper, I remember it happened in one of the areas in the northern or northeast region when there was a conflict between two communities, and one community where there were candidates failed to cross into another area where they felt they had their, enemies in, if you want, enemies in quotes. So they failed to sit for one or two papers. Now, what happened was that the Ghana Education Service considered their situation and decided to place them in senior high school pending their resitting the paper the next year. So as we speak, I would not want to preempt what the Ghana Education Service would say, but then they would be the final arbiter, if you want, because we conduct the BC for and on their behalf. So once they come up with any, a statement as to what should happen, the council may consider that and they will see what remedial measures can be, effected.
Okay, finally, Mr. Kapi, before I let you go on this one. So it looks like today is the last day, but it's not the last day because there's another exam tomorrow. What does that mean? And we're hearing it's Arabic?
Yeah, it's Arabic for tomorrow. It's about 6,500 candidates across the country. So it is not for every single one. I believe by now there'll be some who are jubilating because they have finished their first major examination.
Mm-hmm.
But then generally, I think that we would pat ourselves in the back and say that things have gone well, except for the fact that some of the people that our partners in this context mean some of the personnel from the Ghana Education Service who have not actually lived up to expectation. Otherwise, I would say that generally we've had a very peaceful examination period.
All right. Thank you so much for talking to us on the polls today.
It's my pleasure.
We'll definitely come to you when the marking starts and then when there's funding issues coming up, Mr. Kapi.
Sure, you are most welcome. I'll be there for you.
Thank you so much. Let's stay in the northern region. Well, let's go to the northern region where Martina is on standby. Martina, what can you report from the northern region?
Northern region officials have described the exams as a successful one. They said that they had anticipated a peaceful process, and truly, even though we've had some incidents, but largely it's been successful in the region as we speak. Most of the issues that came up, the accident dominated, but we also had some few more practices. For instance, for yesterday, we are told at the Ghana Senior High School Center, 5 students were picked up for more practice. They had gone in with their mobile phones to try and write, and they were caught. And so largely, yes, it's been a great one in the northern region. No extraordinary event.
Right. Let's talk about the young lady. If you recall, on JoyNews today, we reported about she having a sudden episode which was attributed to some spirituality. Do you recall that, candidate?
Yes, yes.
What can you report about her?
She's been able to write through the on and off, but largely we are told that she's been able to write through. And I spoke to one of her teachers who believes that yes, she will be able to pass, considering what she's put in. She believes that she'll be able to pass.
Okay.
But we are told that this is an event that keeps coming on, especially Fridays and then Thursdays. And so normally on a school day, Friday and Thursday, she has a way of avoiding it. Say, for instance, not wearing school uniform to school, we are told. So what the spiritualist said was that if the examiners had agreed, she would come in without uniform, which was not possible. And that's why the attack keeps coming on the Thursday and the Friday. But largely she's been able to write, and they are hoping that she passes to the next stage of her education.
Right, and on the 8 candidates, physically, how are they doing?
They are doing well. I'm told that they were spoken to. Yesterday we met with the regional education director, and he says that they have assured them that they would get school placement once the results are in. And he says that it's happened before, and those students were placed. So they believe that they may not get automatic placement, but they can place themselves to schools that they would want. And he said he gives the assurance that these students, it was not their fault. It's an accident, and so they shouldn't suffer for something they haven't caused to themselves. So he says that it should be well assured that these children would obviously move to the next stage of their education.
That's interesting, Martina. That we'll be following the story keenly. Martina, thank you for bringing it. You've got any question for Martina before we go to...
Martina can go. Let's take you now to the Upper West region. Rafiq Salam is on standby from WA to give us a sense of what is happening in that region. Rafiq, what can you report?
Report to you that the candidates are really overjoyed. They are really excited for finishing the BC successful. You know, the airport civil here, over 14,733 candidates took part in the exams. And so it went on well in the airport region. All 11 municipal and districts are in the region without a hitch.
Now, did you report any case of examination malpractice in your region? What's the situation like?
For the centers that I have visited, you know, the one municipality, we are having about 12 centers, and then we haven't recorded and any issue of exam malpractice in the one municipality.
Now, your region is one of the regions in the northern region that we actually saw young girls who were pregnant come out to write the examination. What's their status as we speak?
The issue of, some of the candidates who couldn't write the examination because they were pregnant didn't come to the fourth year in the structure in the one municipality. Some of them, they will tell you that they are absent, but they haven't gotten any reason why they were absent. I believe that it is after the elections, it's after the visa examination, when they finish, then they will be able to ascertain as to the reason why some of them fail to turn up.
But I'm sure you've been engaging some of the students who will be writing their final paper tomorrow, Arabic to be precise. What are your thoughts?
I'm not quite sure that whether there are many in the region here who are writing Arabic as their paper, but the majority, over 90% of the candidates in that post region are expected to finish this evening. And you can see that some of them from the other districts are moving, and they are really in the eclectic mood. They are moving away from the senior high school and also other centers. For now, they are in high spirit, and they are hoping and praying that when the results are released, they will be able to sail through.
Thank you, Rafiq, reporting all the way from Wa. Quite an interesting situation. Parts of the country we visited, the Volta region. Northern region. Martina was there for us, and now Wa.
A real place and a real place we should keep our eyes on will be this northern region, these 8 candidates who are getting assurances of school placements.
Exactly.
When it's in the full glare of people that they are unable to take some exams. So how they get the placements, it's something to look at.
It's a legitimate question.
Mechanisms that will be put in place, a part of the remedials or the respite that maybe the council may recommend to GES, as we have just been knowing that the power really, though discretionary, it's not only on the side of the council, Wire Council, but GES will play a key role. But it's good to know that the minister in charge of education has been speaking largely and says that it will be looked at and then they will do what they have to do for the candidates.
But if GES is the final arbiter, then it's something that they could consider.
Maybe.
When council meets, I'm sure they'll come up with a solution to this. But then should we consider organizing our own exams ourselves as a country? It's a conversation we should start having. Do we have the capacity?
I don't know. We may have to look at it. I don't know. I don't know. Yeah.
It's a conversation. It's a conversation that I'm sure the education minister will be open to having. Should we consider organizing our own external exams ourselves? Would WAEC, BEC?
It's just a scheme because of the whole West African exam. Because you need a certificate that allows you to cross border. West Africa examination certificate.
Yes, but then can we as a country decide that, okay, we want to organize this ourselves, we would make sure we meet West African examination standards, but we're in charge, it's our money, it's our students, it's our examination, and it's something that we should consider moving forward, shouldn't we?
Maybe.
It's a conversation we should have as we touch base with our correspondents across the country. You can share your thoughts with us. If you're a final year student writing your BC, and I'm sure you're excited, share your thoughts with us. We'll join you on TV on all our social media handles. Don't forget, we'll be taking you to Parliament shortly because the first female justice will be vetted in a matter of minutes. I'm looking forward to that session and some of the key things that will come up, MFR.
Yeah.
But
one of the
today,
2 female justices will be President Mahama nominated 2 out of the 7 for women justices who, if they pass the vetting, would be part of the Supreme Court justices, and of course will not be the first, will be part of the many women who would be at the Supreme Court as Supreme Court judges.
Just one thing that came up during the vetting both yesterday and today. Should we consider capping the number of judges that could be nominated to the Supreme Court? It's a conversation that we've had different thoughts about how to go about it. Should we place a ceiling on it? It's a conversation that we would love to have.
Well, yeah, you want to stay with us. We definitely will bring you the rest of the vetting today. We'll cross over when they are ready, but we're still on the BEC. We shall take you across the country. We went up north. We went to the Upper West region. We also went to the Volta region, where Ivy's been bringing us updates of the success stories from the Volta region. I think so far, Ivy has not reported any malpractice in the Volta region.
Yes, so far, the Volta region is doing very well.
We're trying to connect with our correspondents as well in the Ashanti region to see if Ashanti as well made it to the good books of WAEC.
We shouldn't, rush the Ashanti region. We should take our time.
I mean, Volta region is quite small, and so if we don't record such activities, I'm not surprised. Ashanti region is very, very large, and so if we record, I will not be surprised.
Well, we may disappoint you. There may be some cases, but largely it will go out well. And so we're keeping our tabs on that across the country. Share your thoughts with us. We want to find out who else is on standby for us. The Ashanti region is key to us, and we'd like to cross over shortly just to get a sense of what is happening there. The other regions too, we would like to touch base with as we get the thoughts of our correspondents on the ground engaging BC students who have written their final paper today. Well, at least 90% of them may have done that. We know that another paper will be written tomorrow, which is Arabic, and we're looking forward to that. And we're touching base with our correspondents across the country just to get a sense of what is happening. Well, we took you to the Volta region, we took you to the northern region, we took you to the Upper West region. We also came back here in Accra, where Stephen decided to withhold from us.
But tell me, I didn't think I saw some excitement from. I didn't think I saw some excitement from the candidates. It was almost as though they're morose, they're tired, or
there is this funny video on social media I came across when I was writing my exams. It says Yatroniama. So probably some of them
that's what's happening.
Concerned about what they've written, but then largely they'll be fine.
So at the time when the ministry said that, well, let's have them pick their school of choices before they take the exams, we had a lot of debates here on both the polls, Newsnight and everything, that, well, in the past, students will write the exams and then they will select their schools, the choices that they want. This year, they select the schools and then they take the exams. And here's what parents said that had my full attention. They said they like it this way. Why? Because when a candidate picks their school choice, they are rather motivated to write the exams well, learn and write the exams well, to meet up to the choice that they picked.
Well, this system was in place, MFR. The only time we had to change was because of the introduction of COVID-19 and some of the reforms the previous administration was introducing in the educational curriculum. And the need to actually put the placement after you've written the exams. That way, you're sure that you know what you wrote, really. You cannot be choosing certain schools when you know exactly what you wrote. So that's the reason why they introduced that system. But how effective has it been, really? It's the question that we would have to pose to the administration of the system. The reason why this time they're looking at a different approach, allow them to select their schools and then come back and write your exams, see how it goes. But then what would change? That's the big question. What's the change, really?
You know the school you chose, and so you know how you're going to learn, and you know how you sit for the exams.
Let's see how that goes. I'm hoping that the placement system this time will not come with so much difficulties as we recorded in previous years, where parents are quite concerned about getting the right school for their wards. And so, MFA.
Right, we'll now take them to the Ashanti region, particularly Kumasi, where Irabna Akwe is joining us on phone. Irabna, tell me what's happening in Kumasi today, and what's your take? You want to tell us about the inmates as well who start for the exams this year?
Hello.
Hi, yes, we can hear you.
Yes. Can you ask the question again?
Right, so what's it like in the Ashanti region? Today is the last day for some, despite some people taking the exams tomorrow, Arabic specifically. But today, what's the ambience like in Kumasi? And I also want to know about the inmates as well that you reported were also taking the exams this year.
All right, so the highlights of the BC in the Ashanti region have been about the 5 inmates and the lady who delivered the child while writing her second paper, that's the ICC. So far, the excitement is high. All the students are excited that they have been able to finish writing their thesis. All of them, excluding the Arabic students, but they feel like they have basically finished. And with the inmate issue, they are hopeful that they will be able to get a preferred enrollment choice so that they could further their education while still serving their sentence. And with the pregnant lady, she is just excited that she has been able to go through with her exams, even though she was pregnant and she had to be going home to take her medications and breastfeeding the baby in between papers.
Right. I was wondering if you had an interaction with the inmates as well and how they prepared for the exams.
Pardon me?
Did the inmates say that they prepared enough for the exams?
Yes, they said they were prepared enough for the exam, and they even said it was easier than they expected it. So far, so good for them. Yes.
Any case of examination malpractice recorded in that region?
Sorry, I can barely hear you.
Oh dear. You may have to position rightly. I'm hoping that it's clearer now. We just wanted to get a sense of any case of examination malpractice recorded in the region so far. Whilst we work on our lines, just to get clearer connection to Rabna, she was just giving us highlights of some of the key things that happened in the Ashanti region. Some inmates partook in the exams this time, and it was great just seeing them get their life back, get the chance to be part of the process. And then also that young lady who delivered while writing ICT.
That's a miracle. But Rabna, I'll try again if you can hear me. Were there any reports of examination malpractice? Okay. Unfortunately, we lost the Rabna. But of course, we'll bring you all the updates. And you're still watching The Pulse. We're bringing you all the highlights of how the BEC has been so far, and today being the final day for some candidates, except those who will be taking Arabic exams tomorrow. We've also been bringing you the vetting of Justice Philip Bright Mensah. Before we go on a break, I'll just bring you some highlights of his vetting so far. He says that judicial staff should be included in capacity building. He also thinks that if we want the judiciary to grow, we need to build the capacity of judges as well, and also calling on government to approve promptly budget when it comes to them as well for the judiciary, and says that we shouldn't cut the budget. We need it to enhance capacity building. Says the judiciary needs more resources to be effective, and he also thinks that the judiciary should retain about 50 to 70% of its IGF, internally generated funds, so that they'll be able to run the systems even more effectively. He says that jurisdiction of the Supreme Court should be considered when capping its appointments, and also said those who pass their LLB and are waiting to enter Makola should be granted immunity. This is an area a lot of students will be interested in. LLB holders awaiting Makola entry should as well be granted immunity, and a holistic approach is essential when reviewing legal education. And as well, one that I want to bring your attention on says that the jury system has outlived its usefulness, and thinks that mining laws are deterrent enough to punish illegal miners. What remains ineffective is the implementation of it. You're watching The Pulse. You want to stay with us? When we return, we'll bring you the live coverage of the next batch of nominees who, if they make it, will be headed to the Supreme Court. You're watching The Pulse.
While sports take a break, there's no better time to jump into the thrill of virtual gaming. Roll, tap, spin, and be a part of exciting journey. 1x Games, where luck never takes a break. You want it tough. never cough, syrup, class away, class away, otoko, oye witia, keto, akuko pesa, namidia, minyara womo, honey and ginger, licorice and mussel, long pepper and violet. You only cough, never cough, syrup, class away, class away.
Effective for relief from cough, sore throat, and throat irritation. New Honey Cough. Class away. Manufactured and distributed by NS Chemist Limited. This advert is FDA approved.
They may be young, but don't be deceived. These rising culinary stars are ready to battle it out in the most intense kitchen showdown on television. With mind-blowing challenges, surprise twists, and jaw-dropping dishes, only one will rise to the top and claim the title. New rivalries, bigger stakes, and epic flavors. Who has the skill, the heart, and the strength to survive the fire in the kitchen? Join me, Michelle Ojekum, the judges, and the awesome kitty chefs every Sunday at 4 p.m. only on Joy Prime. Big Chef.
Good news, my kids.
Have you been to Aqua Safari lately? Let me share my experience with you at the new Aqua Safari Resort. When you arrive, you're greeted by warm smiles and introduced to your 24-hour butler who already has your itinerary sorted. Enjoy water sports activities like jet ski rides, kayaking, water sliding, flyboarding, and castnet fishing. You can even have your lunch here on the boat cruise. Experience horseback riding, tennis, and some golfing amongst a host of other activities. Let the tour guides take you through the sceneries of the Volta River, the mangrove forest, the friendliness of the animals, local and exotic birds, while you pet and feed them. You can have this large space for your conferences, corporate retreats, and so many activities as part of the package. We chose to have our breakfast with a beautiful sunrise right in front of our cabin. We had an amazing experience and I can't wait to return for more.
Visit Aqua Safari Eco Resort in Ghana, bringing you closer to nature.
Hi, my name is Cynthia OFORI-ATTA. I'm the Group Head of Marketing, Corporate Affairs and Customer Experience at Hollard Ghana, your favorite insurance group made up of Hollard Insurance and Hollard Life Assurance. So we want to say congratulations to Multimedia Ghana. It's been 30 years of being a catalyst for enduring change. At Hollard, we have something we call the Hollard Way, and we see that Multimedia has espoused the values of the Hollard Way because you aspire for excellence, and everything that Multimedia has done in the last 30 years have spoken to that drive for excellence and enduring change. So from all of us here at Hollard, we say charge, as we like to say. Congratulations once again, and in 30 years, we are sure we'll be here again to congratulate you for doing even more. Thank you.
Well, thank you for staying with us, but we'll now take you live back to the Vetting Committee or the Appointments Committee, where Justice Battles has taken her seat now.
And did my GC O-levels in 1978. I followed up my GCA certificate in St. Monica's Secondary School, Ashanti Mampo, and finished in 1980. In the same year, I entered the University of Cape Coast, where, due to the universities being closed down in those times, I finished in 1985 instead of 84. And then I did my national service with the Department of English of the same university for 2 years, finishing in 1987. Thereafter, I gained an employment with the Ghana Education Service and was posted to my alma mater to teach. I taught there for a period of 8 years, and during that period, I found time to learn to become a lawyer. I finally left the teaching field in about 1994-5, where I joined the VAT service, and the law was, and also the legal department of the VAT service was absorbed into the legal department of the then IRS. So I was there briefly. I was always desirous of joining the bench. So I applied, and I was taken in as a magistrate in November of 1997. I was a magistrate till 2004, and then became a circuit court judge, went on till 2010, and became a court of appeal judge. Became a high court judge, and then went on to the Court of Appeal in I'm mixing up the dates a bit, if I may just refer.
We have all those things on your
Very
CV.
well. I mean, from the High Court, I went to the Court of Appeal December 2019, and I've been there since this moment. So briefly, that's something about me.
Thank you. We've delayed you, so we don't intend to delay you further. We move straight ahead to call for questions. So, Honorable Tampuli, you have the floor.
Thank you. My lady, you are welcome. I congratulate you on your nomination. I have a question for you. I may come with a follow-up, but depending on how you answer. But I want us to do Article 5 of the 1992 Constitution. The rights, duties, declarations, and guarantees relating to the fundamental human rights and freedoms specifically mentioned in this chapter shall not be regarded as excluding others not specifically mentioned, which are considered to be inherent in the democracy and intended to secure the freedom and dignity of man. Unquote. With this provision at the back of your mind, would you consider that LGBTQ rights can be captured under the Ghanaian law by extension, by extending it to Article 33.5? Thank you, Malik.
Thank you, Mr. Chairman. At this moment in time, I am of the view that the Supreme Court has pronounced on matters relating to the LGBT. Readily, I cannot remember those cases. There are about 3 of them. One of them, I believe the Sky, I can't remember their names fully. So I will not prefer an opinion on whether or not the rights of LGBT people.
Thank you very much. Any follow-up?
Thank you, Mr. Chairman. So apart from these LGBTQ, do you conceive of any rights that can come under this provision under Article 33.5? From your practice and your, everyday relationship with people.
At the moment, no.
Very well, that will be Mr.
Honorable Bafo.
Thank you, Mr. Chairman. Congratulations, my lady, and welcome to the committee. My lady, in 1981, the intestate succession law was passed to protect mainly widows. That was the philosophy. Their right to the property and also surviving children. In our local parlance, we refer to them as, colloquially, we refer to them as orphans. So mainly, spouse. Patrick is not, Honorable Baba is not ready to look at it as a law mainly for women. Thank you very much, my brother. But I'm looking at protection for women, widows, and their children. Beyond establishing matrimonial courts and specialized courts to ensure speedy resolution of disputes over the estates of deceased persons in the interest of widows and their surviving children. What can you think of by way of recommendation to Parliament that we should do to ensure expeditious justice for widows and their surviving children?
Yes, my lady, before you answer the question, we are enjoined to be gender neutral. So wherever a widow and children is referred to, particularly widow, let's use the appropriate phraseology, spouse. So you may proceed to answer the question.
Thank you, Mr. Chairman. Your question, if I understood, is what Parliament would do to speed up resolving matters of estate in favor of spouses and orphaned children. I am humbly of the view that Parliament has done its bit in coming out with the laws. The matters come to court, and I think, apart from probably interpreting them to the hills, the judges or courts also bring in some judicial activism to protect those who are on the weak side of the law, if I may put it that way. Therefore, in terms of Parliament doing something further, I do not think they can do more than come out with laws. Maybe some of the problems that have to do with the settlement of estates are cultural issues, in terms of perhaps, even though PNDC law 111 is there, some people think that even though the law says this, I think that this person shouldn't have that. So beyond the promulgation of laws, I do not see how much further Parliament can go. That is my view.
Thank you very much. Any follow-up question?
My lady, so from your answer, Parliament has done its bit. The people of Menchia want to know what the court can do to ensure that when such cases come to court, there will be limited procedural bottlenecks, more or less speedy delivery of justice for such people. What can the court do? If there are procedural reforms you may want to recommend to ensure that such people get justice expeditiously, given the consequence of lengthy litigation on the properties and even the persons themselves, to the extent that some of them, their education is affected, their well-being affected. I mean, their lives.
Yes, my lady, you have the floor.
Thank you, Mr. Chairman. Very well. I believe that you are interested in how fast cases or matters to do with administration of estates are settled. I believe the Judicial Service has put in place courts that deal with matters of estate, probate issues. On the other hand, I have been in courts, even at a time in the Court of Appeal, something came on appeal to do with a matter of estate. And as we say in the Children's Act, the children cannot wait, or even if not in the Children's Act. Since I was a magistrate, it was always one of mine. So things come up, maybe somebody's school fees are outstanding, something is hot and burning. The courts find ways of dealing with it. I do not think estate matters wait unnecessarily long, unless, of course, there are some contentious estate. Well, but generally, I think the courts do their best. Thank you.
Well, I will give the floor to Honorable. Is it Asamoah? Buama, Honorable Buama. You are entitled to one question and a follow-up.
Thank you very much, Mr. Chairman.
Not Yao Buama, but Buama Nyako.
I'm also Yao Buama.
You're also Yao Buama.
But Isaac against party.
Okay, then Yao Buama the first time.
Yes, Chairman. Thank you very much, Chair, and congratulations, my lady, for your nomination. There's been a lot of discussion around the workload at the Supreme Court, which is leading to the increase in justices at that level. Now, we know the jurisdiction of the Supreme Court from its original to appellate and supervisory. There's a conversation around limiting the jurisdiction of the Supreme Court to terminate some cases at the Court of Appeal so that the Supreme Court can manage its original jurisdiction powers amongst other appellate matters. What is your view in terms of limiting the rule or the functions of the Supreme Court to other matters and capping some cases at the Court of Appeal level? Thank you very much.
Very well. Thank you, Mr. Chairman. I am aware, or I realize that the load at the Supreme Court has gone or grown bigger with the years. Yes, it will be good if some cases terminate, let me put it that way, at the Court of Appeal, so that the Supreme Court will have maybe less load in that sense. I do not know whether that satisfies your question, or that's all of the question you asked. I think it was 2 in 1. I didn't quite.
Chairman, thank you. Yes, you concur that it is possible to do a cap of or limit the jurisdiction of the Supreme Court to an extent. But in your reasonable contemplation, from all the jurisdictions that we've raised, which one do you think comes in handy, taking off the burden at the level of the Supreme Court, knowing that you are coming from the Court of Appeal and have risen through the ranks from magistrate up to the Court of Appeal now to Supreme Court?
I'm of the view that some of the appellate load should be taken off. Maybe cases that begin perhaps in the magistrate courts could terminate at the Court of Appeal, and that will be it. Thank you.
Yes, I'll give the floor to Honorable Anthony Mia.
I'm very grateful, Mr. Chairman. Welcome, my lady, and congratulations on your nomination. Accra. Right, Dr. Mai, let's start with the legal aid. My first question would come from the legal aid. In your contemplation, do you think that the Legal Aid Commission has successfully implemented Act 977, which established the legal aid? Again, do you also think that in the case of the vulnerable and the marginalized, that the legal aid has succeeded in addressing their concerns for legal aid?
Thank you, Mr. Chairman. I would not say that they have not succeeded. Rome certainly was not built in a day. The legal aid has its own issues in terms of funding, in terms of enough lawyers, and other peculiarities. And besides, I don't know how well spread they are in the regions, whether they are represented everywhere, and how many lawyers are manning it. So in terms of helping the vulnerable, there are many more people that need legal aid than the country has legal aid to offer. Thank you.
Thank you. Follow-up question. If you have the opportunity to make recommendations to help the legal aid properly achieve its mandate of serving the poor, what are some of the recommendations you would make?
Thank you, Mr. Chairman. One thing that comes readily to mind in terms of manning or staffing the legal aid, I would say that for fresh lawyers from school, they could be made to do their national service right across the country in legal aid offices. Maybe a certain minimum number posted, or depending on the size of the region and the population, maybe on that level. Where there's more, they need more. So the point is, if we can send national service for young lawyers to go to legal aid offices, that will also fill in the gap. And the next time they finish, another batch goes. And I think we'll build the capacity and we'll be achieving what they're set out to do. Some may even stay on and make their lives in legal aid. Thank you.
Now, my second question. Would you support a constitutional amendment barring the appointment or nomination of persons perceived to be politically exposed to the Superior Court of Judicature?
Did I hear say, will I support, Mr. Chairman? Can he just, the question said, will I support the question?
You see, in the recent past, okay, a school of thought has held a view that certain persons, I would give examples, persons who have held positions as regional chairman, constituency chairman, etc., of political parties. For instance, it could even be a former minister of state. All these persons are described as persons that are politically exposed. Would you recommend that the Constitution is amended so that these persons are barred from joining them?
Very well. In other words, the Constitution is silent on that now. I believe that if we are to go that route, the country has to have a conversation about it. I do not believe that I am enough here to give an opinion on that. Thank you.
It's your third question.
Thank you. So my follow-up question then. Now, let us zoom into Article 1284.
My brother, that cannot be a follow-up question.
It's directly related. It's directly related to appointments.
It's directly related to
on the qualification of judges to be nominated to the Court of Adjudication.
That would be a different question, because your earlier question was on anybody who has a political color. Can such a person be given the opportunity to go to the, listen to me, to go to the Supreme Court?
Exactly.
And she said, we can have a conversation on it.
Exactly.
But she's not here to offer opinion
Mr. Chairman,
on that matter.
Both questions fall or come under 128, under qualification of persons to be nominated to the Supreme Court.
Well, ask the question and let me see.
Very, very well. My lady, my follow-up question is, many perceive judicial promotions, nominations, etc., to the apex court as politicized. Okay? What transparent mechanisms would you recommend to ensure that merit-based progression is introduced within the judiciary?
Well, before allowing my lady to answer the question, take note that that is your question number 3.
Very well. Your good self expressed the view that many perceive. From where I come from, I've been in the service for 28 years. In 2019 by the other administration, and like a thunderbolt, minding my own business, I am here by the grace of God. Thank you.
I'm very grateful. That will be all for the nominee.
Thank you very much, Honorable Member. I'll proceed to give the floor to Honorable Alikple Makorogo.
Thank you, Chairman. Congratulations, my Lord. I'm always excited to see women get to this position. In fact, you are a role model, and we are all learning from you. Just a quick one. How does the law deal with properties owned by couples in divorce or death? Very well. I believe this House has still yet to pass the law on spousal property rights. But in the courts, anytime the courts have been challenged with the properties belonging to spouses, they have dealt with them in an equitable manner. I do not think the law is that just because you are a spouse, you are entitled to anything. You will be dealt with according to the law, and every case will be looked at on its own merits. It's either, even if it's contribution and it's in, let me say for lack of a better word, kind, it will be upon the facts. If it is both of you work hard, if it is one person who went to take a loan, or if there's agreement that I will acquire my own property whilst I was married to you and you acquire yours. So at the end of the day, the law would always be fair and equitable in dealing with spousal property. That is what I can say. A follow-up question. We know outside Ghana they practice child support. I don't know if there's one existing in Ghana. If not, are you considering it? Thank you. Thank you, Mr. Chairman. I do not believe it is in my place as a nominee for the Supreme Court to consider spousal support. If we want to enact a law as a people, the debate would have to go out here on this floor, and at the end of the day, those who make the laws will make them. Thank you. Mr. Chair, thank you so much. I'm wishing you all the best.
It's now the turn of Alhaji Omar.
Thank you, Chairman. Ladyship, congratulations. I have one single question that I've been asking, and that has to do with separation, the doctrine of separation of powers. What's your view about it regarding the Constitution that we have for the 1992 Constitution?
Very well, Mr. Chairman. I believe that the Constitution has created a path for all the arms of government, and ordinarily everybody is in their lane, the executive, the legislature, judiciary. In Parliament here you have your own laws, you carry on with your lives like everybody else does. But then, that won't mean that if something is done which is repugnant to the Constitution, under which we all are shaded, those who are responsible for taking a say on it will not. For example, if a matter comes to court which has to do with Parliament or executive not doing what they're supposed to do under the Parliament. I don't think the Judiciary will sit down and just fold its hands. That does not mean that it will be encroaching on your rights or your work. That is how good governance works ultimately for the common good. Thank you.
Any further question? Yes. A follow-up. Thank you. This is, I think, is a question about practicability. Practical. That a few years ago, Parliament was working on a law, and it had not yet come to conclusion because it has to be signed into law, then we go for interpretation or challenge it. But it looks as if the Supreme Court, not once, severally, interfered in the work of Parliament. And I want to find out, if you are sitting there, will you continue that?
Well, are you talking in respect of the decision of the Supreme Court in Ezwame versus Attorney General? Ezwame versus the Attorney General?
Talking about the recent LGBT law which was passed and got arrested, someone went to court, and the president had not yet...
Then with all due respect, I'm likely to overrule you because the nominee is not here to comment on a matter pending before the court or a matter that the court has already made pronouncement. So you may ask another question.
Thank you, as I guided. Thank you. I wish you well.
Thank you. I will proceed to give the floor to Honorable Patrick Yaobuama, the senior.
All right. Thank you. Thank you, Chairman, and congratulations, my lady. My lady, I think with your experience, you've read a lot about Chapter 6 of our Constitution on the directive principles of state policy. My lady, please, are you there? Yes. Especially Article 36 on economic freedoms and rights, and the fact that the president must, within 2 years, bring to Parliament his plan of development and what have you, asking for direct investment to come into the country. There's been a debate on the bench for some time about the justiciability of this chapter. I want to hear your views on whether the provisions of under Chapter 6 are justiciable, in your view, because I'm sure some of your colleagues have their own ways of merging these provisions with other statutory provisions to make it enforceable. So I just want your take on this. Thank you.
If I understood you, Mr. Chairman, you mean whether the provisions under Chapter 6 are justiciable. I am of the view that if they were not, the framers of the Constitution wouldn't have even put it there. At the end of the day, the whole country is entitled to development. As a people, we have brought up this law for ourselves, and we have carved a path which we wish to follow. And I believe we also have a national development planning body. So at the end of the day, if we follow the trail, we would achieve or would arrive at where we want to. So in my view, it is. Thank you.
Really, that would be difficult, in my view. Because if you look at some of the provisions.
We'll get there. Rome was never built in a day.
Very well, very well. I just wanted your thoughts because I've read certain positions by Justice Dateba and his group and how the positions some of them took. That's why I asked you. So let's look at emerging trends. You're a very modern judge. And I know you've taken an Uber before. Or very well. You've heard about Airbnb. I'm sure you've stayed in one of them.
Not yet.
Not yet. Yango and all the new technologies that you don't even know the source, but you pay with your card and enjoy the facilities. You are there 2 minutes, a car comes up, you don't know the person, you key in your address, the person takes you, whether the person is a murderer or not. You just sit in the car, takes you there, you travel and you book an Airbnb and you go and stay there. With some of these evolving technologies, would you recommend to your JTI, Judicial Training Institute, to take a critical look at some of these emerging trends so that the justices are abreast or kept abreast with some of these modern trends so that they will be able to determine some of these issues when they come to them in the nearest future? There is a decision in Italy. That's why I'm asking you this question. Thank you.
Very well, Mr. Chair. You've mentioned a lot of business names that all form part of this modern trend. But your question, if I understand you, saying that the JTI should train judges when some of these things come up, do you mean when issues, if you could clarify that kindly?
Thank you. That these are emerging trends and new decisions are being taken in some other jurisdictions. I haven't heard of any in our country. So I just want to find out from you whether it will be part of your activism or your advocacy when you go for training so that we are not caught off guard when some of these things come up. That's it.
Very well, Mr. Chairman. I share the view with you that these are modern and new trends, and we all have to learn, especially the judges, because the society is ever evolving and these things will catch up. I would give you a simple example about Facebook. Some years back, when I was in the circuit court, I think, I know there's something that is called porn revenge or nude revenge. Porn revenge or nude revenge between exes, like ex-partners. So somebody shared a picture of his former girlfriend. Let me see, we are all adults here, a nude picture of his former girlfriend with other people. And you know how the world is. I always tell friends that once you take the first photo, click, it's no longer yours the moment you send it. And you can imagine the mental agony to this person, but the matter came to court and it was difficult to apprehend, but with our electronic laws, etc., and I think the police also did some good investigation, and he was apprehended and dealt with. So we have to learn about these things all the time. And sometimes, like you said, it's not just the Uber. You go to San Francisco, the cars come with no driver, and we still sit in them and go.
Thank you very much, my lady. As for me, when the car comes and nobody is in it, I will not sit inside. I'll run away. No, we just go and observe the parade and run away. My lady, let's stay there and talk about media freedoms. The Constitution guarantees media freedoms, but there's little to talk about when it comes to content. People generate content, share them, discuss them, before you realize everything is out there. But they will tell you, oh, the press is not subject to any direction or control. Yes, but there are limitations. within the media space anyway. Do you think, as a country and as Parliament, we haven't done so much with regards to regulations to ensure that the media is kept within bounds and within the Constitution, so that our image as a country and as individuals are well protected and respected within the media space? Because a judge will wake up in the morning and find his or her picture on the front page on a matter that he or she has sat on. You wouldn't know where that journalist or media house got the judge's photograph, but it will be there. And maybe even the ruling that the judge gave is not well reported, it's skewed in a way. Those are things that I believe do worry some of you as justices of the court. So I just want to hear from you on some of the things I've spoken about. Thank you.
Very well. Ghana is a strong advocate for media freedom. Going back some years back, maybe 30, 40 years ago, I do not believe that the media landscape was what it is today. And perhaps that has propelled us into a kind of media free-for-all, if I may put it that way, like you are saying. So some of these things happen, and of course, we get disturbed. Others go to court seeking for their reliefs. However, I do not think that we have to go out right away with the big stick, knocking everybody. Maybe we first of all have to engage the media. Their responsibilities, their freedoms have to go with responsibilities. They have to know that. We have to sensitize them. People have to learn how to report. Even like you mentioned about a case being reported. We have a judicial media persons, I believe, but sometimes they don't report exactly. But I think it's a learning process and sensitization. And when we've done all that, at the end of the day, maybe we can have some further regulations that will make the media or the journalists realize that the fact that he has a microphone, or the fact that there's ink in his barrel or pen, or the fact that he has a keyboard that has an enter stroke, does not mean that he can just go to town. Respectfully, my views. Thank you.
My follow-up question to that. Would you advise the Judicial Service to train some of the journalists in this country, or you have a training program for them, those who report from the courts? Would you ask that your next budget you request for some more money? I can see the acting CJ here, for some training of the journalists who report from the courts. Would you? And I wish you the very best, my lady. Thank you.
I believe that can be done in collaboration with the JTI, and if it's brought to the attention of the Office of the Acting CJ, that certainly can be arranged. Thank you.
So you're asking for more money?
No, I didn't talk about money. I just said they could be trained. But of course, if we got more money, we would not be any less miserable.
Thank you.
Honorable Patrick Obama, you can donate 40% of your bank account to them. It will be in the right direction.
I wish I could do that, but, you know, I'm miserable.
It's now the turn of Honorable Haji Aladi Ayamba.
Thank you, Chairman. Congratulations, my sister. I'm so proud to see you seated there. As a woman, it's not easy. I know you've worked hard, so I continue to pray that your efforts would send you higher. Well done. I wouldn't have asked you any question, but if I don't, I know what some of, I won't say that one. My sister, there is a problem. And the problem has to do with an issue that is on the Criminal and Other Offences Act. I asked earlier on, and I think this is my third time of asking this same question. There is a gap when it comes to the age of having sex and the age of marriage. And it's quite disturbing. For me as a woman, I have looked at it severally, and I think that if at 16 years, especially the girl child, is still in school or supposed to be in school, and she is allowed or permitted by law to have sex, I believe she could easily become pregnant, get infected, run away, elope and leave school and what have you. Or even she could be misused. Excuse my language, I'm a teacher by profession, so I'm not derogating any teachers, even those who are teaching her. Now she has been given the permission. It means that even if that happens, nobody can be held responsible. She can become pregnant, that ends everything. But then, she cannot get married to the one who has impregnated her because she is still 16 years. Because the law says that 18 years before she can get married. The gap between 16 and 18 is a very big problem. 2 years is not a small thing. The child would have started even running around if she becomes pregnant, but she is not married. How do we reconcile this issue? My question is, how are we going to make sure that the girl either shouldn't have sex when she's 16 because of all these things we have identified, or the girl can marry? I'm referring to the girl mostly because I've seen that the issues are mostly on the girl child. Or she should wait until when she's 18. What do we do as women to help them, whether the girl or the boy?
Very well, Mr. Chairman. If my memory serves me right, I think this gap was even bigger when I was a junior judge. It was probably 14 something, if I remember. I may be wrong, but it was bigger. You are perfectly right with what do we do with the gap. It has to do with the law and it has to do with morality. Sometimes it is very difficult to legislate issues that border on morality. If somebody can have sex at 16 but cannot marry, what is the whole point? All the dangers are there. I mean, I can't imagine when I was 16 and what? I was reading for my O-levels. I believe when you say, what can we do as women? You didn't say, what can you do as lawmakers? But I can say, what can we do as women, sisters, mothers? I think education is a natural contraceptive. The longer the girl child stays in school, the longer it will get to the point of settling down to have a family. It doesn't mean that, I'm not saying that everybody should go to school and become a judge or a doctor or a lawyer or something, but even if a girl child grows up to become a young lady, has to do some training to learn cookery or sewing, all those are training times and they keep you rooted and focused. So that is one of the things that can be done. But if we move the gap and we even make it 18-21, I am sure we'll come back and have the same conversation. So you cannot keep on legislating. There are other ways, like I've mentioned, that this problem can be solved. And then education should go out there to families, to our brothers, our uncles, our teachers, our granduncles, that we must leave the girl child to grow up and become the woman that we expect them to be. Thank you.
Thank you, Chairman. When I started asking this question, I want us to all know how difficult it is. But then, what I started hearing from even people whom I don't we want them to be apprentices before they become the so you see, Yes. I want to just say, no, we don't want them to be apprentices. But then, that's on a lighter note. Let me thank you very much for coming up with a suggestion. That is on the issue of not having lawyers and what have you in the hinterlands, especially our villages. You made a very good suggestion. And I believe that we've all heard it. And I wish that if Parliament could even take it up and make sure that it is enacted into law to ensure that lawyers who come out should be posted out there, but with support, with some kind of support to encourage them. They should have accommodation, travel allowances, fringe benefits, to make sure that they actually go and practice. I believe that it will encourage others. And I think that you made that point. It made my day. So thank you very much. And then I wish you all the best. I pray that you continue to rise. Inshallah. Thank you.
Thank you.
Thank you very much. I will proceed to give the floor to Honorable Kweku Rickett-Hagan.
Thank you very much, Mr. Chairman. And my ladyship, congratulations. I have perused your CV like everyone has. And actually like the idea that you went to St. Monica's. It's a school that I know very well. Because every
honorable members, order. We can call for further and better particulars after the vetting.
Actually, every auntie, cousin, including my mother, went to St. Monica's in Ashanti Mampo. So that's all. Yeah. But on a serious note, I have a question here which I asked the previous nominee. And it's, I said in Ghana, even though we have district courts which are supposed to deal expeditiously with matters, but it looks as if our court processes are still very, very slow. And I wanted to pick your mind on this, that if you think we need to set up some small claim courts to deal with matters that borders around, let's say, 10,000 Ghana cedis, that can be dealt with, small courts, that can deal with such matters very quickly, instead of keeping the law process longer and longer. Just want your view on that.
Very well. If you are just talking about small claims courts, I believe that the courts as we have them now, they have the space for those small claims. And setting up more and more courts, in my view, respectfully, will not solve the problem of cases moving fast. Thank you.
I'll just end with this. I did another, it's also something that I'm curious about, and that is to do with, I did ask this question earlier, I think it was yesterday, that most of the courts that I have seen, and not, thank God, not many, you go there and then the atmosphere doesn't look that conducive. You have either there are no ACs present, or if they are there, they are not working. But I still see, I mean, I've been accused of that. I still see, you know, our lawyers and judges in their wigs and gowns that are actually, look, they are suffering. They're really heated. I know this is a colonial legacy, that we institutions like yours, guard very well. But don't you think it's a bit outmoded? And we should start maybe designing something that is much more practical to our climate, and that will make our lawyers and judges feel comfortable. Like our speakers, I know there are only 3 of them in Parliament now, have taken their gowns off and put on the attire that Mr. Speaker here, my chairman, is wearing. And maybe do with the gowns and wigs on ceremonial occasions. This is on a very light note, my concern for lawyers and judges. Thank you.
Very well, like you said, it's on a light note. Old habits die hard. The spots of leopards never go. The surgeon is in his scrub. The policeman is in his dark uniform in the hot sun. So I do not think that the judges are so upset or the lawyers about it, but if we have to, it's a conversation that we should have. And at the end of the day, if we think so, it will happen. Thank you.
You see,
okay, sorry.
Honorable Rickett Hagan, the lawyers love the wig and gun, but the non-lawyers are rather worried about the wig and gun. Because of this, anytime I'm going to preside, I will wear the gun.
My ladyship, congratulations once again, and I wish you well. Thank you, Mr. Chairman.
Thank you so much. I will proceed to give the floor to Honorable Jerry Ahmed Shaib.
Thank you very much, Mr. Chair. My lady, you are welcome, and congratulations to you. My lady, so you are known to be honest. You're also known to be friendly, industrious, ambitious, and you're a grammarian. You're a grammarian. I mean, you're somebody who has very good skills in writing grammar. That's a report I read. I just want to find out how you came by all of this.
Mr. Chairman, thank you. Well, I say fortunately, my parents were both into education. My mother was a teacher. I followed her to class 1. I started reading early, writing early, went through school, and ended up reading English for my first degree in literature, and taught it for about 8 years. So maybe that is the explanation. Thank you.
So, on the issue of you being honest and having practiced for about 3 decades, as having been on the bench for about 3 decades, from the district court to the circuit court to the high court, the appellate court, now, to the appeals court, now to the Supreme Court. Have you, at any time in point, been approached by someone to offer you some sort of gift, bribe? And what was your posture? What did you do about it?
Maybe 25, 26 years ago. Maybe I can't remember totally, but when we started as young magistrates, sometimes you go to a court and you have to develop a certain posture because people watch you and then people come and try and play tricks with you. But the moment you also send them the body language that you're not here to play monkey games with them, that's the end. So I wouldn't say directly somebody has come to, but we live with people, people get to know you. Integrity is everything. What you do in the daylight and what you do in the night, they are the same. So I wouldn't say that somebody has walked up to me or gone through somebody directly to come to me. Thank you.
So my second question. So having still been here for about 30 years, what recommendations would you make in reference to judicial reforms and why?
when you talk respectfully, Mr. Chairman, judicial reforms, will that mean to do with the actual courts and administratively?
They are all encompassing.
Very well. To do with judicial reforms, many or oftentimes people complain about the slow pace of trials or court work. I won't say that. I will say that the judicial service I entered 28 years ago is not the same as today. For example, the lower courts, I don't think I ever saw a recording equipment in my court. We wrote laboriously, but times have changed. To have great reforms, we need to put in the infrastructure. If we talk about even e-justice, e-justice does not operate on steam, for lack of a better word. We need to put in the network. And many times we find that a lot of things, we keep them in Accra for lack of finance to expand. So for judicial reforms, they should be across country. If we talk about cases moving fast, efficient, speedy trials, it shouldn't happen in only maybe the law court complex. It must happen across the nation. That means that there must be massive injection of funds. So judicial reform does not come cheap. That's the first thing. We need massive injection of funds if we want to run an e-justice system. For example, 2 years ago, I happened to visit Kenya, and we went to their judicial training school, referring to e-justice and what they were doing there. And they even said, they came much after us. Ghana started e-justice some years back. They really came on board when COVID caught up with them. And at a point, their Supreme Court even sat when one member was outside the country. And they had this slogan, to the last mile. They were laying their fiber optics. You know, they were serious. The World Bank was with them, yes. So if we want to reform drastically, we have to take some of these things, the bull by the horn, and do them. Otherwise, we'll be tackling them piecemeal, piecemeal, piecemeal. That is one. For reforms, capacity building of judges. You can't train a judge maybe at entry point and say that is it. It must be continuous education. We must have good libraries. Law books are expensive. Not many people. We are entitled to a book allowance. That comes when it comes. For sure, it comes, but when it comes. And I am sure the book allowance will not buy too many books. So fair enough, if we can't buy too many books individually, we must have a well-stocked library where judges can go and have reference. Otherwise, we have to pay for these online libraries, even if it can be done for maybe the service and everybody can access it. Those are some of the things that will equip the judges to give off their best. Immediately, those are the two I can think of. Thank you.
Thank you, Milady. Milady, I picked up the e-justice part that I'm more excited about. If you had your way, what exactly would you recommend that we execute in reference to e-justice?
Very well.
For instance, I mean, can we say that judges should be taken through a whole educational program on AI and all of that, and even the service of REIT and all of that? Are we looking at any new ways of doing so?
E-justice is a complete package. It's not new to the judicial service. It is there, but it is being applied maybe to a limited extent. So I do not think that it is something new that judges have to go and learn. We build upon it as we go on. And talking about AI, I mean, AI has come, but that is not the immediate need of judges to deliver judgments. Already in the Western world, even with AI, lawyers are summing up and writing addresses for the bench, and some of the things that they bring from AI are completely, as we say in these parts, non-fact. So it's not a matter of AI. E-justice is where the things that we do in the physical world. Why should somebody sitting in Tamale who wants to sue somebody in Accra travel, whether by air or by bus, to come and file a writ in the registry? This can be done online. Evidence can be directly taken. Those are the things we are talking about. A judgment, even rulings. Why should people travel all the way somewhere to go for a ruling? They can be delivered online, etc., etc. Even with the criminal justice, talking about bail and 48 hours, etc., etc. I am of the view, the law says people should not be kept more than 48 hours. The police will arrest them anyway. They will arrest them maybe on a Friday. Don't keep them for 48 hours. The courts will only open on Mondays. For example, we could have a weekend court, but it does not mean that the court has to sit physically on weekends, like the housemen and the residents do in the Ministry of Health. If you know you are the judge on duty for the magistrate level this weekend, you know it. So between the hours of 4 p.m. and 7 p.m., you're running an online court for people who have been kept 48 hours across. We can work out the modalities, but these are little things we could do to help the cause of improving the judiciary on the whole. Thank you.
Thank you, Milady. Milady, this will be my last question. Milady, same reforms, and in particular, I'm looking at the criminal jurisprudence or criminal justice system. Our prisons are choked. The prisoners get pittances. Sometimes feeding is even a problem. I mean, I don't know the exact amount now, but the last time the Minister of Interior was here, he admitted that amounts per prisoner or the monies per prisoner is very inadequate. Do you generally have any suggestions with reference to the criminal justice systems, and if there are any reviews you recommend, please?
Thank you, Mr. Chairman. I am of the view that the time has come when we should strongly advocate for non-custodial sentences in relation to minor crimes. We will have to define what we mean by those minor crimes, but that's a way to go, non-custodial sentences. And I would also dare say, the prisons are congested. We see them. Judges, we used to go around. I mean, we see them on TV. We've seen them physically. Why shouldn't they also have rights? We could build 1 or 2 more prisons to decongest. They are entitled to sleep like we sleep, not just be all squashed up like sardines. So, in my view, non-custodial sentences, and maybe a new prison or two, maybe one built in the middle of the country further up, one built somewhere. That is a way of decongesting the old prisons. Thank you.
So this is just a follow-up. Yes, I'm still the prisoners. Are we considering caning people when they do wrong? Maybe once in a while you openly give them some lashings. Maybe somebody stole Honorable Patrick Baumer's phone, and no. It's just as part of the non-custodial ways of dealing with criminals. Can we suggest that caning should be proposed, and that when someone goes to steal a phone or yam or some olunka of gari, and you can tell that this person is famished, and that's the reason why the person got it. Can we cane those people? Is that a suggestion you would make?
Honorable Chair, certainly not.
Lady, I wish you all the very best.
Well, it's now the turn of the available leader, deputy leader. Are you also taking the place of the leader? Very well.
Thank you very much. Congratulations, my lady. we are all equally happy that in the scheme of things, gender equity has been considered. And it is my belief that is the more reason why we have the 7 nominees. We have 2 strong ladies within the 7 nominees that have been appointed by the president. And I believe that, yes, there are people who believe that the affirmative action law, which has been passed, relates more to competency than just the promotion of women into any position. I believe that competency is a critical need. But the issue is that we know that from our patriarchal nature as a country, we have issues with the women participation in leadership and in governance. And therefore it is critical that this affirmative action law is enacted. I would like to tease out from you, what will you do to promote this law, considering the fact that we have a number of people within the judiciary who may be up for the right appointment, but because they have not reached the the qualification, that's what I would say, the qualification back, it has not been possible to promote them to the level which you have reached at the moment. But we need more women in the judiciary. What will be your effort to enhance the participation of women in the judiciary? Thank you.
Thank you, Honorable Chair. I'm not saying that we have enough women in the judiciary, but we have many women in the judiciary. Currently, if you look at our annual report book, the ratio, the men are about 50 point something, and we are about 49. They are just about 1% and a little more than us. In the past years, maybe 20 years down the road, backwards, a lot was done for the girl child. I am a woman, but I do not believe in affirmative action for affirmative action's sake. I say that because you and I are women. If women are just put anywhere for any house sake, and they go and they don't perform, you and who gets the flag? It is we, the women. I believe in mentoring young girls, bringing them up, building capacity, encouraging them to gain the heights. I would say, apart from the grace of God, nobody has plucked me from anywhere and put me anywhere ever in my life. All the steps of my life, I have worked hard, bid my time, waited on the Lord if need be, and at the end of the day, I am here. So in the judiciary, we have quite a number of good women, like I said, the skills, and like Honorable Adja said, very soon, it might be that there may be more. Maybe at this point, I may become a boy-child advocate if I'm not careful.
A follow-up. It's very interesting to mention that very soon you become a boy-child advocate. And if I can get your sense well, it's all because of the kind of insecurity that our current male, the male youth are finding themselves, because they feel that we emphasize too much on the female, but it is important that we bring every female into speed on this particular issue. We are never saying, and I need to underscore that we are never saying that promote any woman at all. Competencies are a critical need that will require the promotion of every woman. But what I wanted from you is that, what are you going to do specifically? Unless maybe you are telling me that you don't want to promote women into the positions in which you have been able to because nobody nurtured you. But that is what I wanted. You've named education as one aspect. There are also mentoring that you can also be looking at any point in time. I don't know. There are so many people who feel that talking about affirmative action, it means you're a feminist, and they put all kind of negativity to it.
Honorable Leader,
and I feel that is not the case. So we are only creating awareness for all people to note that it is important that we get the women into the society, because women also do well in whatever they do. But what I believe must be done at this point in time, for which maybe we will require your proposal, is what constitutional provision can we make at this point in time to take good cognizance of the affirmative action act that we've promoted out there. Thank you.
Sorry if you understood me by saying that affirmative action, as I understood it, meant that women should just be promoted for promotion's sake. I did not mean that. I said if that were to be the case and the woman didn't perform, we the women would not be happy. But asking me that what constitutional provision, I am of the view that women and men in Ghana have equal rights. I mean, we all start out at school. We are all encouraged to be the best of ourselves, gain the highest. In my little space, I have young lawyers, some of whom I've encouraged, who have become magistrates and circuit judges now. Others who are in law school, my hands during internship, and enter them. At the end of the day, in my little space, those are some of the ways. And also, going back to the girl child, we encourage girls to stay in school. Education, 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 education. Because education, in my personal view, did a lot for me. So that is what I have to say.
Thank you very much. My lady, could you share some personal or professional obstacles you have faced on your journey to become a justice of the court, and how your story might inspire the next generation of legal minds? Thank you.
Very well. Our work can be laborious, lonely, frustrating, and what have you. I mean, sometimes I look back when this nomination came and I just wonder whether this is me, because sometimes you have to sit up night after night after night to read, and you never finish reading. Those were obstacles. Even sometimes to go to work. There was a time I worked in Tema, but there was no official accommodation in Tema. And I was not, there was no official accommodation in Tema, and I lived on the far edge of town, towards the West Hills Mall. I had no choice, and at that time, the N1 was under construction. I had to go daily, go at dawn. Sometimes you leave the house and the moon is still shining, and you have to cross Accra. The N1 was under construction. You have to go around Pambrose, Dansuma, Independence Avenue, come back to Tetekwashi before you go on. I mean, I went through all that. There were very frustrating moments. And going to Tema and coming every day on the motorway and all that. But resilience, I mean, tough times build resilience. That's what I'll say. So even though you have sleepless nights, you want to do what everybody's doing, you can't. You have to be very disciplined as a judge. Those are all obstacles. Maybe you want to go and sit somewhere, but you cannot go and sit at plus 233. You have to sit behind your books. And all your mates, like all my mates are retired now, and then you see all the wonderful things they can do and get up to, but you cannot. But at the end of the day, we are here and we are thankful to God.
Thank you very much, Mr. Chair. My lady, I think we are teasing this issue out of almost everybody here. What do you think of Article 66? First, if you may open and then get it read out.
Mr. Chairman, did I hear her say I should read it out? Very well.
And share your views with us.
Very well. Term of office of President. A person elected as President shall, subject to Clause 3 of this article, hold office for a term of 4 years, beginning from the date on which he is sworn in as President. A person shall not be elected to hold office as President of Ghana for more than 2 terms. The office of President shall become vacant on the expiration of the period specified in Clause 1 of this article, or B, if the incumbent dies or resigns from office or ceases to hold office under Article 69 of this Constitution. 4, the President may by writing, signed by him, and addressed to the Speaker of Parliament, resign from his office as President. Please, what was the follow-up question? What did I think of? I think it's crystal clear. The Constitution, the President cannot hold office for more than 2 terms, and that is it, period.
There's no ambiguity about it.
As far as I'm concerned, or I can see, I do not find any such ambiguity.
Anyway. Yes. And I'd like to find out from you, there is that common belief that the judiciary, critics have held the judiciary as corrupt. But I would like you to share with us what you think about corruption in this respect.
Corruption anywhere should be eschewed, not only in the judiciary, but anywhere. I am of the view that when people talk about the judiciary, a lot of times they clamp up or gather up everybody working in the judicial space. It's not only judges who make up judicial work, right through from other services, the police, the prisons, judicial staff, judiciary, they all work together. So I do not think it is a blame to be laid at only the foot of the judiciary. However, one bad fruit in a basket makes all others bad. So I am humbly of the view that any presence or otherwise of corruption should be stringently seen to and wiped out. That is what I have to say. Thank you.
Thank you. Yes. Well, my last question, my lady, that is, how do you balance respect for local cultural norms against international human rights obligations? Thank you.
Very well, Mr. Chairman. Did I hear you say, how do we balance local cultural norms against international human rights obligations? I would say that, if I understood you, I would say that whatever is not culturally repugnant to us and is intellectually right, we'll marry the two and work with it. Thank you.
Thank you very much. I proceed to give the floor to Honorable Togui Osahi Alexander Kwamina Abonyomaki. You have the floor.
My lady, please, let us look at page 1 of your CV, your 5-page CV. Okay. Lady, you said at J, biodata personal profile. At J, you say you speak every English entry.
Yes, Mr. Chairman.
Your tree, out of 10, 9 out of 10, 1 out of 10, 2 out of 10.
7 out of 10.
How would you rate your
7
tree?
out of 10.
Oh, okay. Which of the trees you mean? The Ashanti tree or the Kriapim tree? Or your own standard tree?
Received tree.
Which one?
Received tree.
My lady, which one is that?
As I heard it being spoken around me and I picked up.
You come from Peki?
Yes, Mr. Chairman.
And you were born in Tamale?
Yes, Honorable Chair.
Are you therefore telling the committee that your parents were civil servants or public servants who
Yes,
found
my
their
father
way?
was an education officer. He traveled the breadth and length of this country.
In your family, are you the only woman or a couple of?
My siblings, we are 3 females and 2 males.
Are you the oldest or the youngest?
I'm in the middle.
Is the male older than you or younger?
Respectfully, Mr. Chairman, one is older, one is younger.
From the records, you were in Achimota School, and then you moved to St. Monica's Secondary School in Ashanti Mampo. So you had an experience of a mixed school and same-sex school.
Yes,
growing up.
Honorable Chair.
Are you able to share with us any experience in both situations, please?
Very well. I spent 5 years in a mixed school, so I was used to that. And then I found myself in a girls' school for 2 years, but I survived. Thank you, Mr. Chair.
My lady, proud to your joining the bench, you indicated you worked with the GRA. On your CV, page 3 or 5.
Yes, Honorable Chair.
Where exactly were you at GRA? Were you at the...
At the time, I joined as Honorable Chair, humbly Honorable Chair. At the time, I joined the Value-Added Tax Service when it had just been introduced. Then within a few months, it was annulled. Therefore, the staff there in the legal department were absorbed into the Internal Revenue Service as it was then known. So in those days when I was there was nothing like GRE as we know it now. Thank you.
From the records also, you would agree with me that you spent some 9 years at the High Court.
Yes, Mr. Chairman.
Until you were eventually promoted in December of 2019 to the Court of Appeal.
Yes, Mr. Chairman.
You also spent 6 years, 2004 to 2010, Circuit Court, but you don't indicate where you were.
I was in the, respectfully, Mr. Chair, I was in the Cocoa Affairs Court. I spent the time there in Accra.
Have you been a High Court judge in Winneba?
Honorable Chair, I believe the Speaker, the Honorable Member remembers me from Winneba.
I want to be sure.
Yes, well. I was there.
Very well. My lady, you've spent many years on the bench. And I want to take you through the very case that we did, a certiorari application that was brought before you regarding some actions of the University of Education that came up for question. And you listened patiently. One of the things I learned from you, your level of patience. You listened to everybody, lengthy submissions, and gave your ruling that they were acting within jurisdiction. And you even encouraged that the decision be tested at the Supreme Court, which was something very unusual, because I've had the occasion of practicing before judges at the High Court. When they give their ruling, they say, go and certiorari me, go and certiorari me. And they just embarrass you, the lawyer, as if it's a personal fight. But you said, look, it would be good to test the law, so go and test it. And in fact, after going to the Supreme Court and back, you inquired to know the outcome. Though your decision was set aside, you were not at all worried. Now, in your determination of matters that involve state institutions, by way of judicial philosophy, are you likely always to look at state interests as your first option? Are you likely to look at state interests as your first option in terms of arriving at a decision? Are you a pro-state person?
Respectfully, I always pay fidelity to the law, so I will not say that I am a state person. Whatever comes before me, I'll look at the facts and look at the law, and I will be guided.
My lady, you know that many lawyers have difficulty in open court practice. Sometimes when we meet as lawyers and we ask some of our colleagues, why have you stopped going to the court, or why don't you want to do court practice? The complaints are that some judges are too harsh, not that they don't like to be corrected. That is the lawyers, not that they don't want to be corrected, but their utterances. And the emphasis is that some female judges are not kind at all regarding their words, and some are very emotional. I have really experienced that myself. What would you say to encourage some of these young lawyers who have such concerns about such attitudes of judges, particularly female judges?
Mr. Chairman, I will say that it's unfortunate that people will want to stop their whole practice because of, again, it would be unfortunate if a judge or a female judge were to speak harshly or berate a lawyer, be it a junior or whatever. I do not think that has been my cup of tea. I have not behaved that way on the bench. I would not encourage it. If I were to meet any lawyer who says he has stopped practice before that, I will encourage that person to go back and pick up the pieces and practice, and not to be deterred by such.
Quite encouraging. Thank you very much. My lady, I'm going to take you through some few questions. These border on constitutional principle of equality before the law, especially in the context of calls for equal parental leave rights for men, paternity leave. And my main aim on these set of questions basically is to explore your understanding of gender equality and social justice reasoning. So I shall proceed with the first of these set of questions, respectfully. 1, on constitutional interpretation of Article 17. Article 17 of the Constitution guarantees equality before the law and prohibits discrimination on the basis of gender. Do you think the absence of paternity leave in Ghanaian law constitutes gender discrimination against men?
Honorable Chair, thank you. To the extent that the men are denied it, that is some form of discrimination.
Would you therefore propose a legislation, a parliament enactment, and not a court enactment to fill this gap? Or now that you're going to the policy court, where things are large, you would prefer that if Parliament is not acting, you will zoom in to act. Bearing in mind the fact that after Glomega in Article 1815, where you give Parliament the chance to enact, to regulate, we are still not done with that. Would you want to take that up should there be a situation like this to fill the gap, my Lord?
Thank you, Honorable Chairman. If the opportunity came my way, I do not think I would mind. However, Parliament could do same. Thank you.
My lady, I didn't get the last part of your question.
However,
your answer, please.
I said, however, Parliament could do same, but if I had the opportunity, I would do it. But
I'm sure the leader of government business has heard us, and the Children and Social Protection Minister has heard us to make proposal to the executive. If it comes, I'm sure it's something that Parliament could consider. Thank you very much for that view. Now, on social rules and constitutional evolution, some have argued that exclusive maternity leave reinforces outdated gender roles and that equal parental leave will promote shared caregiving. From a constitutional perspective, how should the law respond to such evolving social expectations?
thank you, Mr. Chairman. Did I hear equal paternity?
What I'm saying is that there is a school of thought that exclusive maternity leave reinforces outdated gender roles, and that equal parental leave will promote shared caregiving. Now, from a constitutional perspective, you go into a constitutional court. How should the law respond to such evolving social expectations?
I think a question ago, Honorable Chair, a question ago, that the answers would fit into this. If we are to go forward and apply equal leave on both the paternity and the maternity side, we have the maternity leave already. We should then bring about the paternal leave so that it is equal. Both parents can share. Thank you.
You are giving some good news to the men. Very well. Now let's also look at balancing biological realities with equality. On this score, I would want to pick your thoughts on this. So while childbirth is biologically tied to the woman, some say that postnatal care responsibilities should be shared. How should the law balance biological differences with the constitutional imperative of gender equality?
Very well. Talking about postnatal biological duties. If I were a young mother, just had a baby, I do not think that I'll leave my baby with the father of the baby to breastfeed it. Thank you.
My lady, but these days we are told that there is this machine that pumps the breast milk. So, my lady, if you have to go and preside, and the man has taken paternity leave, maybe if you, within some 4 hours, maybe these days that you can sit in the afternoon, doing your case management, some 2 hours, and come back. Is it the case of my lady that you're going to straightly stay by baby girl? Is that the impression my lady is creating? Without maybe pumping for the man to take care of that within the 2 hours or 3?
Honorable Chair, thank you. My premise was, if I was a fresh mother and had just had a baby, I do not think, if I had just had a baby, I don't think I'll be going to the courtroom soon, and I wouldn't like to leave my fresh baby with the daddy. If the baby were 9 months, I can
that's fine.
Express milk and put down and...
Very well. Okay. All right. Now let's deal with international human rights commitment a bit. Our country is a party to international human rights treaties that promote gender equality, such as the CEDAW. Should these international obligations influence judicial interpretation in favor of paternity leave? In view of all the thinking so far you've put out regarding your position on such rights?
Yes, why not, so long as they bring about good practice, but then we would have to marry them into our own experiences and come out with our laws that fall within what those rights are.
So, my lady, so looking at your date of birth, should the majority eventually confirm you, how many years are you going to be on the Supreme Court bench?
6.5 years. My Honorable Chair, 6.5 years.
My lady. Honorable Parliament will do the approval, and we are in the process of vetting. Why do you say should majority confirm you?
I get what the chairman is saying. What I'm suggesting is that normally we take decision by majority. You know, majority carries the vote when the question is put. They say the ayes have it. The ayes have it. It can also be unanimous, yes. But looking at their behavior, they are yesterday's sins. I don't think. Anyway, yeah. You have changed it to ask inconsistent people. Very well. Judicial role in gender justice. My lady, if a case challenging constitutionality of laws granting maternity leave but denying paternity leave come before you, how would you approach the issue to ensure fidelity to both equality and public interest?
I will look at the laws and apply what they say. And if there's something missing, and from the point of the facts before me, I can cure any mischief or lack, I'll do so according to law.
My lady, I'm now going to focus on issues on constitutional provisions relating to the Council of States, i.e. Article 89 to 92, and the growing public calls for its abolition or reform, especially proposals to replace it with a second chamber of parliament, i.e. a Senate or a House of Elders, to strengthen deliberative governance. So my nexus of questions are going to be based on these. So first would be on democratic legitimacy and constitutional design. Now, the law provides that the Council of State is an advisory body with no legislative power. Yet, it is sometimes called a toothless echo chamber. In your view, does its existence enhance or undermine democratic accountability and legitimacy within Ghana's constitutional framework?
Thank you, Honorable Chair. I'm not of the view that its existence undermines what you have just said. I'm of the view that if we find that they lack certain strengths, those could be enhanced to make their output serve our purposes as a nation. Thank you.
Now, my lady, in the advisory role, reference is often made to decisions that they have communicated to the presidency. And the decisions are communicated without the details being shared with the public. And the public lately seem to be so concerned about the governance of our country. Would you suggest that the time has come for the Council of States to be seen to be doing some interfacing by explaining to the public or sharing with institutions like Parliament some of its decisions? After all, even in the lawmaking process, where the president refuses to assent, there's a process that requires a referral to the Council of State for them to have an opinion and bring it back to Parliament for a second consideration of the bill. This, it is stated in the Constitution. but in other matters, we don't. A recent example is the public outcry regarding their determination of a prima facie against Her Ladyship, the Chief Justice. Some hold the view that a transparent system where the Council of State, for instance, could have come out with their written opinion and share with the public on what constitutes the prima facie which led to the president exercising a discretion to suspend. That would have been helpful for governance. Would you be of that position that they should be seen to being proactive and sharing with us the views they express in advising presidential decisions or guiding presidential decisions? It could be anybody. Who knows?
Thank you, Honorable Chair. I do not think that will work in every situation. There may be some things which right now here I cannot mention, which may be necessary for them to explain to the public, but I do not believe that in all things you have to come and explain to the public as an advisory body. Thank you.
Now, my lady, let's delve into comparative constitutional models. In other jurisdictions, upper houses or the Senate exist to provide mature second thought to legislative processes. Do you believe replacing Ghana's Council of State with a second chamber will better reflect the principles of representative democracy?
Honorable Chair, I do not think that will necessarily be so. Thank you.
You don't think?
My answer to the question was, I do not think that will necessarily be so. The replacement.
Very well. Can you explain? Can you justify?
Can I kindly have the question again?
Yes, very well, sure. What I'm saying is that in other jurisdictions, the upper houses or the Senate exist to provide mature second thought to legislative processes. Do you believe replacing Ghana's Council of State with a second chamber would better reflect the principles of representative democracy?
I said I necessarily, Honorable Chair, my answer is that I necessarily do not think that will be so, coming from my earlier answer that the Council of State could be strengthened. Thank you.
So now, let me follow up on the phrase could be strengthened. Can you share some views on ways of strengthening the Council of State to enable them meet modern expectations in governance?
Very well, Honorable Chair, thank you. I'll say that before this moment, this question had never come to me. If I am to give you a view, I'd have to sit down, critically look at the articles on the Council of State before I can come out. But I gave an example that in the advisory role, they may have to share certain things with the public, and not everything. That is one thing that will strengthen good governance. Thank you.
My lady, some have held this view that Article 89 appointment in parts perhaps amount to elite capture. Reason ascribed to this include the fact that it allows the president to appoint majority of its members, and the president may exercise their discretion by perhaps yielding to some elite in society who would want to be there. Do you consider this concentration of appointment of power a threat to Council of State independence? If so, how should it be constitutionally addressed? Of course, I'm mindful of the fact that there are regional reps. Each region brings a representation, and the mode of election comes from the various assembly members. Each assembly nominates or select 2 persons to constitute the college to do this election. But I am, the mainstay of my question is on the concentration of power in the hands of the president to choose majority. Do you think that this is a threat to the independence of the council and the constitution must be looked at, in your view?
In my view, I do not believe that it's a threat. As you said, there's regional representation, but in my view, it's a balance. Thank you.
Well, to the extent that the regional representation does not create the arithmetic balance, like I said, the majority are appointed. I am looking at the issue of the majority being appointed by the president vis-a-vis the independence of SIM. If, as it were, the regional representation would amount to, say, 55% or 60%, and the president's appointment is, say, 40%, like we have in a number of governing councils. Most of the university governing councils, they are up to like 17, 18, but the actual presidential appointment in them are 4, not more. So it's in that context that I want to pick your thoughts regarding whether the Constitution can help us to deal with this imbalance.
Honorable Chair, thank you. You're saying whether the Constitution as it is can help us or if amended. Because it is as it is.
Yes, obviously I'm looking at, when I say to be constitutionally addressed, I believe you
Well, I am still of the opinion that I do not think that because you're saying that most of them are appointed by the president, that is going to affect the way they carry out their constitutional duties. I do not think so.
My lady, given that the Council of State's advice is not binding and that Parliament already performs scrutiny functions, what would you say would be your views for the justification of the constitutional purpose of the Council of State?
Thank you, Mr. Chairman. Not too long ago, you asked whether there was a need to create an upper chamber or second one to help carry out the work of.
That will not just be advisory, but enhance lawmaking.
So I am saying.
Honorable member, with all due respect, let me repeat. If a question is posed to the nominee and the nominee is in the process of answering the question, respectfully, let's allow the nominee to finish answering the question. Then you have the opportunity to ask another question.
Thank you, Mr. Chairman. I remember your question is, their advice is not binding. Is that it? However, I'm still asking the question. You're saying that the advice from Council of State is not binding.
However, Parliament, in the performance of its mandate of scrutiny, is able to undertake reviews and make laws. In that context, I'm trying to pick your thoughts as to whether or not there is still any constitutional relevance of the Council of State. However, you were trying to relate it to my earlier position on the need to create an upper chamber. And I was trying to draw your attention to the fact that the context I placed the upper chamber was to help enhance the process of lawmaking. They will not be there merely for advisory purpose. So I was trying to get that context captured properly so that it aids you in your answer.
Very well. Earlier on, I think I mentioned the Council of State should be strengthened to perform its duties. So I'm of the view that if now the advice is not binding, it it is one of the things that could be looked at. Thank you.
Now, my lady, we have the Council of State, we have the Parliament, we have you, your institution, the courts. In your very honest opinion, do you think there are still very grave deficits in terms of the checks and balances on the executive arm of government?
I hope I understood the question when you say whether there are still very great deficits. Exactly what would that mean?
Well, what I mean by deficits or gaps in the checks and balances is to mean that we've had views expressing concern about the powers of the executive, and that it appears that the checkmating of the executive is not sufficient enough. For instance, in the situation we have now, where the ruling government is having 2/3 or almost in Parliament, the view is that the checkmating, the checks, will not be as expected because they would use their majority to protect government. Same way, when it was 137, the public reacted quite differently. That, well, with that strong parliament where there was almost equality in numbers, the executive would be subjected to much more scrutiny. So that is the background upon which I mount the question to you, that do you think that with all of these, legislature is there, you have the Council of State, including the Judiciary, there are still some gaps to be filled. And of course, I know that CSOs are also doing their best. They whistle blow and all. In spite of all of this, Ghanaians seem to have serious concerns about the governance and the exercise of executive power. Do you think there are still gaps? And what, if so, do you have some suggestions to help strengthen these to ensure some safeguards?
In my humble view, Mr. Chair, I do not think that the grave gaps, or as mentioned by the honourable member, are any deep or many. As I can see, he himself is working very hard, and the judiciary is also there, and the checks and balances within the constraints or the ambit of the Constitution are working. Thank you.
My lady, you are an Article 71 office holder.
Respectfully so.
Right.
Mr. Chair.
So let me ask this. How do you reconcile the exclusive remuneration regime under Article 71 with Ghana's broader public sector pay policy, particularly the single spine salary structure? Would you suggest some amendment? Do you think that there must be some amendment to Article 71 in view of our public sector pay policy, which moves in a certain direction?
Very well. Thank you, Mr. Chairman. I would not suggest that there should be an amendment, but looking at the other side of the coin, where there's always a cry for better conditions, government should pay the other side better. Thank you.
The Constitutional Review Committee is doing some work. Of course, you as a judge, your job is also do your review while sitting on the bench. May I ask, should you eventually get to the bench, would you consider it within the judicial remit to interpret or limit the scope of Article 71 to reduce disparities in compensation across public institutions? And I say so based on your earlier answer that you believe that the others who are not covered by Article 71 should be well considered by government in terms of their remuneration. That they should be paid well, those were your words.
Kindly, Mr. Chair, so what is the current question?
The current question is that would you consider it within the judiciary's remit to interpret or limit the scope of Article 71 to reduce disparities in compensation across public institutions?
Thank you, Mr. Chairman. I believe this is another way of asking me the same question. At the end of the day, I said I did not agree that the Article 71 conditions should be subject to an amendment. The other side should be improved. So why would this happen now? No.
My lady, there are public concerns that Article 71 fosters self-serving pay increment by political elites, including other beneficiaries under 71. The judiciary cannot be taken out because you are expressly stated there. What constitutional or legal checks do you think should be imposed to prevent abuse and restore public trust? The concern has been that the committee, Mr. Bedzede, you are not talking on record. Can you be quiet and listen?
Please.
And if you disagree,
you are supposed to address the chair. You are supposed to address the chair. You are supposed to address the chair. So please go ahead and address the chair. Me, what I've heard is when you said abuse of Article 70, this thing, rhetorically, the head, is it being abused? So this will not detract your attention from proceeding to answer the question that you have to. Yes. Your member will not even know what is happening. So just focus on your question.
my lady, this is part of politics. I'm used to it, so I'm used to it. One day they will be in this chair. One day, very soon. So let them enjoy the liberties of governance and intimidate me. I will get them. They will be.
Let me complete your prophecy by saying that after 50 years.
No problem. It's okay. We prophesied in 2016 that it would take you 50 years, and you are here. Don't worry. Don't worry. You would have to bring a new candidate in 28. We will see. You continue enjoying and intimidating. These are precedents that tomorrow, when you are suffering, you will have no ventilation. So enjoy what you think you are doing to me. You are returning, you are also talking some. I've forgiven you your sins. It's okay. Very well, it's okay. This part of the politics, you know. My lady, it was just to give you some breather. So we come back. So, my lady, the question here is that there are public concerns that Article 71 fosters self-serving pay increments. Now, I want to know from you what constitutional or legal checks do you think should be imposed to prevent abuse and restore public trust? Because the public is always out against this Article 71, and I believe you hear these public outcries.
Very well. Very well, Mr. Chairman. As the Constitution stands and what provision it has made for Article 71, I believe it is within that ambit that when it is time for the emoluments or salaries or whatever underneath it to be paid, are paid. You were talking about political something earlier on, and you said judges are also there. I can only speak for judges. I will say, for good reason, the Judiciary was placed under Article 71. And down the years, as compared to you were advocating for people on single spine, etc. I know others elsewhere who work and are paid single spine have their pay increments annually. It does not happen in the Judiciary. We wait, as it were, 4 years passes, and we are paid those monies, which we should have been earning 4 years ago, 3 years ago, 2 years ago, 1 year ago. You and I know what happens to the economics of it. So, in my view, I don't find that disbursement to the Judiciary as abuse when the time comes for us to be entitled to what is our entitlement. Thank you.
My lady, it's the same thing for the political class, the MPs, the same thing. The ministers, the same thing. But it appears that the public doesn't see it in that light. It's a reason why I would follow up by asking whether you will agree that to bring certainty to this matter, if somebody on single spine receives an annual increment, there is a proper bargaining, whether minister, MP, judge, Public Services Commission chair, Judicial Council, Council of State, there must be a system that allows you to negotiate your wages, remuneration commission that determines year on year, so that you know that each year this is how it's going to be. Now, this thing is constitutionally guided, so you cannot touch it. In the spirit of ensuring certainty, would you suggest a judicial touch on this provision? In other words, amending Article 71, or that the Constitutional Review Committee should look at addressing this issue in Article 71.
Very well, thank you, Mr. Chairman. If the need arises that the Constitutional Review Committee has to look at it, I do not have a problem with that. If it has to come to the point where people will have to bargain, like you said, for their salaries or entitlements, for lack of a better word, like it's done, maybe single spine annually, like you're saying. I mean, in reality, who likes taking their salary 4 years back and it doesn't have economic value? Those are all issues that could be looked at. And if there's a real need, then something could be done about it. But like you yourself said, it is part of the Constitution for now.
So, Article 71 insulates certain public office holders from salary regulation under general law, and those public office holders we already know, we need not repeat. Do you think that this provision itself violates the spirit of equality and non-discrimination as enshrined in Article 17, given the fact that others would have to be on single spine?
Very well, Mr. Chairman, thank you. I am not comfortable with the word insulate. I do not think Article 71 was put into the Constitution to make anybody better off than anybody. The Constitution was promulgated by the people for the people to work for them at a certain point in time. And they thought it so. And we have it as it is. So if you say that it is discriminatory, I would not totally agree. Because for good reason, Article 71 was put in the 1992 Constitution. Thank you.
Lord, I'm now taking you through my last set of questions, and then we are done for the day. And please bear with me. I want us to deal with some theoretical and constitutional justifications, and then ask that, you know, critics argue that the doctrine of adverse possession permits a trespasser to obtain legal title through unlawful occupation, undermining the constitutional right to property. In your view, how does the concept of adverse possession reconcile with Article 20 of the 1992 Constitution, which guarantees protection from deprivation of property?
Well, Mr. Chair, on adverse possession, we know that's not just happened. Certain things happen that eventually end up in adverse possession. And if that does happen, and the law says the property passes on, I do not think how that is contradictory to what the Constitution is saying. People are not denied of owning property, but if you have property and you sit by idle, at the end of the day, you may lose it. Thank you.
So, my lady, it is your view that it does not run counter with Article 20 of the 1992 Constitution, which guarantees protection from deprivation of property?
That's my view.
Very well. That's okay. Now, I want to know, what's your considered view regarding the continued relevance of the doctrine of adverse possession in Ghana today, especially given the growing incidence of land disputes poor record keeping, and customary land tenure complexities.
My name is Mr. Chairman. Did you say what is the continuous worth of adverse possession?
Relevance.
Considering the fact that there are disputes on
yes,
land.
I mean, considering the fact that we've had growing incidents of land disputes, poor record keeping, and customary law land tenure complexities.
Well. Thank you, Mr. Chairman. Adverse possession will always be adverse possession, and land disputes will always arise. At the end of the day, when parties find themselves in court, it's up to whoever to prove whether there's adverse possession or they are the owners of the land. Thank you.
My lady, can you readily share with us any case law which application of same has shaped the law on adverse possession? Do you readily? No. Very well. That's okay. My lady, so we would conclude on Article 33 of the Constitution, which guarantees enforceability of fundamental human rights in the context of sexual freedom, same-sex relationship, use of sex toys, and civil partnerships. I want to pick your thoughts on this. And I have put them together to explore your views on limits and evolution of constitutional rights, particularly in the light of Ghana's dual citizen era, international human rights standards, and the growing debate around sexual autonomy, morality, and legal progressiveness. Now, on constitutionality of sexual freedom. Article 33 allows court to enforce fundamental rights even if they are not expressly stated in the Constitution. In your view, can the right to sexual autonomy or sexual orientation be interpreted as an implied constitutional right under this provision?
Respectfully, let this cap pass away from me. I believe that the Supreme Court has made some pronouncements on, if I will put it this way, people with different sexual orientations. So I would not want to comment further.
My lady, just to bring clarity, my lady, is it your case that there's a Supreme Court decision on this very matter? If I understood you correctly, because the rest of the questions will emanate from this area. So if you say...
You talked about sexual... The question mentioned something about sexual orientation.
Let me put it again. Let me restate it. Is that okay?
Very well.
Let
me hear you again. If I can answer it, I will.
Very well. What I'm saying is that Article 33 allows courts to enforce fundamental rights even if they are not expressly stated in the Constitution. In your view, can the right to sexual autonomy or sexual orientation be interpreted as an implied constitutional right under this provision? In your view, can the right to sexual orientation or sexual autonomy be interpreted as an implied constitutional right under this provision?
If I understood the question, Honorable Chair, the same Article 33(1), in the middle of it, somewhere says, without prejudice to any action that is lawfully available. If that were to be the case, then I believe those rights. But if for now certain sexual orientations are not legally on our books or accepted, then I do not think those things could be interpreted here, sexual autonomy, etc., etc. That's my view of it. Thank you.
Yeah. My lady, I am not going into statutes. I am veering into the Constitution and saying that unless we have a disagreement of the position I've taken to the effect that Article 33 allows the court to enforce fundamental rights that are not expressly stated in the Constitution. First of all, do you agree with me on this position of the Constitution, that those that are not even expressly provided for, the courts are to provide for such rights under 33?
Very well. 33 says the person may apply to the court for redress. So I believe.
Very well. So in that context, I'm picking your thoughts as to how such rights can be interpreted as implied constitutional rights, because they are not expressly provided for. And you have agreed to the suggestion that yes, the Constitution allows a human rights court in making a pronouncement in your own words that when you make the application for certain reliefs and it considers these as within your rights, it may grant that. I want to ask, under the same implied principle, can this be considered?
Thank you, Mr. Chairman. Honorable member, those were not my own words. I read from the Constitution.
That's all.
And at the end of the day,
I said very well. It doesn't call for your interview. I'm agreeing with her.
You see, leader, what I want us to do is that you don't gag the nominee. Once the nominee is ready to provide an answer, it is our responsibility to listen to the answer. You may be satisfied, but others are also here. So allow my lady to provide the answer. So, my lady, you have the floor.
Thank you, Honorable Chair. Yes, Mr. Chairman, the provision made reference to allows an applicant to come to court for rights which are not expressly stated there. Beyond that, what I'll say is that they may come to court. When that time comes, we'll cross that bridge. Thank you.
My lady, on the issue of on this very score, let me further ask you, how, in your view, should the court respond to arguments that criminalize same-sex relationships and say that same is inconsistent with constitutional guarantees of equality, dignity, and non-discrimination?
Honorable Chair, at this watershed point, I have no opinion or comment on that. Thank you.
Now, my lady, we are in an era of global citizenship and legal duality. On the basis of this, I would want to find out from you that given that many Ghanaians hold dual nationality, live in countries where same-sex marriage and civil partnership are lawful, how should Ghanaian law adapt, if at all, to this evolving global reality?
Honorable Chair, as I have stated not too long ago, as I sit in this chair, I have no comment. Thank you.
My lady, may you turn to Article 66 of the Constitution? I know, I heard it.
Well, leader, let me just remind you that a question has been asked on Article 66.
I am aware.
Yeah, just remind you.
I followed the entire proceedings from the office. So I am aware that my lady, in an earlier response to your to a question on Article 66, the term limits, you added your voice to the many other views on this very matter, that the term limit as provided for in the Constitution needs no interpretation. It is what it is. Do you think that such views expressed by you today can change?
Respectfully, no, as I keep fidelity to the law, because that is what is written.
My lady, I shall thank you for indulging me and wish you well.
Thank you, Honorable Chair.
Thank you very much, honorable members and our revered guests, including the nominee. Well, I would give the floor to Honorable Roxanne Nelson Dafama, but limited to what he wants to say.
No.
So please, do. He's a member, he didn't ask a question for the whole day. So please.
Chairman, we are done. I've also seen Mr. Dekanyadi here. So if we all want to acknowledge people, I've also seen Mr. Dekanyadi. I know what he wants to do.
Oh.
I've also seen.
That's our big sister. You and I.
I know, but
so
Uncle Dick is also here.
Yeah, yes.
I know you to be very accommodating.
Yes. My lady, you are welcome and congratulations. We are very proud of you. The entire Peki and Southern, we are proud of you.
Thank you.
That's all. We wish you well.
Thank you.
Honour members
and Calvary Methodist Church.
We've come to an end of the vetting of the nominee. Indulge.
Are you struggling? Experts.
So, Charlie, the deal there, I almost get her.
pipe as tough as it can get.
You get so sorry with your back, sorry. Oh, what you was a thing. What the kind of one day you get? Hey! Now I'm back.
Between a pie and cabo.
Hey, madam, pipe menu.
A sentence pipe. Metono, Omukacham send a one day pa. Say a fee, say a foam. The other pipe we be a yen gum.
Syntax pipe.
Why a leaky?
Come, madam. From today, syntax pipe in my pipe. No 2 ways.
When you know, pipe ben abe use.
SINTEX pipe.
Syntax pipe.
No hala.
The EcoBank JoyNews Habitat Fair 2025. Dream it. Own it. Live it. Coming soon.
Hi, now let me share my wildlife experience with you at Safari Valley Eco Park.
Welcome to Safari Valley Eco Park.
Our electric shuttle pulled up and in no time our tour began. We were surrounded by wildlife from the moment we entered the eco park. We were greeted by experienced tour guides who took us through orientation and how to better enjoy the experience. Watch these animals roam freely in their natural habitat undisturbed by our presence. We saw zebras, sable antelope, brown cranes, mara, silky chicken, nyalas, Shetland ponies, and so many animals I just couldn't keep up. Our tour guides taught us so much about the wildlife, their behavior, and how to interact with them. I even fed them. We also went fishing on a man-made canal. Then we took a break to have lunch in this serene environment. All this amazing experience for this price for adults, this price for teenagers. It's a bargain. As the sun began to set, it was time to go back home, but not before dinner by the campfire. It has been a thrill of a lifetime, and I can't wait till my next visit.
Safari Valley Eco Park, bringing you closer to nature.
The enviable support given to us by international partnership would be like we trying to be enemies of our own self.
The EcoBank JoyNews Habitat Fair 2025. Dream it. Own it. Live it. Coming soon.
Every day, people have money emergencies. Ma, I need my school fees emergency. Mommy, chop money emergency. Emergency. Matches, I'm your rent emergency. Now, there's a new emergency number in town. Dial *770# for all your money emergencies and chop that.
Dial *770# for money emergencies and get easy and quick access to your money, loans, and other banking needs. EcoBank, the Pan-African Bank.
Rent back could be a come on, come see what? Wait, this guy. My friend, see before.
It's the Telecel Too Much Money promo. Win cash daily, weekly, and a grand prize of 1.2 million Ghana cedis. Just reload or buy a bundle with Telecel Cash to earn points and stand a chance to win big. Dial *500# or visit the Telecel Play app to obtain and start winning in the Telecel Too Much Money promo. Terms and conditions apply. This promo is regulated by the NLA on the Caritas Lottery platform.
When is campaign? If you're a baby, many scared do no. If you know, meto chiaka. Inti ene, uno ba no mpe baby amobeda. Oh, no abeka. You did too much money. No matter.
Telecel, connecting and
Hello, good evening and welcome to JoyNews Prime. We are coming to you live from our studios here at Kokomeme in Accra. We are live on DSTV channel 421, GoTV channel 125 and around the world on myjoyonline.com. My name is Carlos Caloni.
And I am Faustina Safo. Tonight, MPP National Executive Committee locked in high-stakes meeting over constitutional reforms as it considers electing a flag bearer before the national executives.
Now, total shutdown of services nationwide as staff of the Birth and Death Registry embark on an industrial action demanding the removal of 8 new bars.
Also, as controversy over whether or not to cap appointments to the Supreme Court deepens, Nominees to the country's top court proposes nomination of at least 20 judges to the Supreme Court.
And in business,
of the Bank of Ghana, Dr. Johnson Isiama welcomes a Fitch upgrade Ghana's credit rating to B-, saying it is a testament to the great work being done on the local currency and the economy largely.
Upgraded our sovereign rating once again. This is testament to the progress we're talking about. You just have to look at our external sector performance and be guided.
Here we come your way with Prime Sports.
Black Stars defender Barbara Mann, who is lashing out at the Sports Authority for the poor condition of our pitches, describing it as a national disgrace.
Remember, we are your home of independent, fearless and credible journalism.
A good time to take a seat and please be our guest.
JoyNews Prime Headlines was brought to you by Malatu and Calipo.
Well, tonight, Supreme Court Justice nominee Justice Philip Brightman has proposed the appointment of at least 20 judges to the Apex Court. There has been growing controversy on whether or not Ghana should amend Article 128 of 1992 Constitution to place a limit on the number of judges to serve at the Supreme Court. The matter has become a subject of interest in the vetting of justice nominees in Parliament in the last 2 days. Now, taking his turn before the committee, Justice Philip Brightman is proposing the appointment of at least 20 judges to expedite hearings and deal with the workload.
Ask me the minimum number that I will recommend for appointment to the Supreme Court. Given the nature of the work they do, they are related with so many cases. Therefore, I think I would suggest 20 as judges that should go to the Supreme Court, because as a matter of rule of procedure, and it is also even backed by the Constitution, when the Supreme Court sits in an ordinary case, the panel is 5. The President will sit together with 4 other Supreme Court justices. If there is the chance to have the matter reviewed, 2 more justices will be added to it. So even in ordinary cases, you will see that in each case there are 5 judges who handle the case. So if you say that judges mustn't be sent to the Supreme Court, then it means that you are giving the court more and more, they will be settled with more and more cases and they cannot have. So I think even any given time, when the panel or the judges in the Supreme Court are about 20, then we are saying that we have about 4 sets of panel of judges to handle those cases. So, Mr. Chairman, I would say, in my humble opinion, given the cases that are in the Supreme Court, I would recommend that 20 judges will be appropriate.
Well, Justice Mensah is also proposing strengthening the lower court, especially the Court of Appeals, to prevent a huge number of cases from traveling to the Supreme Court.
The Court of Appeal must be very strong. I mean, being strong means that we need judges who, they are doing their work very well, I must admit. But we must make it stronger than now, so that some of the cases may not travel beyond that. But there must also be conscious effort on the part of the legislature and then the rules of court committee to ensure that, and of course we can't do that without, we have to subject the debate very wide, so as to see the number of cases that will go to the Supreme Court. Because, permit me to use the UK example. UK, most of the cases end up at the Court of Appeal. The cases that go to the Supreme Court will go there with the leave of the Court of Appeal or the Supreme Court. So you find that they do very little cases, and so the Supreme Court is always, they are not saddled with so many cases. So if that is what we want to replicate in Ghana, then the law itself must be amended so that some of the jurisdictions must be taken away.
Let's go on the phone lines now and speak to a man on the beat, James Aveji. He's been in Parliament all morning. James, now we know that another individual that went through the vetting committee today was one of the 2 female justices who have been nominated to go on to the Supreme Court. That is Bartels Kojo. Some key proposals she's been making. Run us through them shortly.
She's been making 2 key proposals to the, the judicial
proposals to the, the judicial system. One is a call for the recommendation for national service for lawyers. She thinks that although lawyers do, we know that as we speak, lawyers do what they call pupillage, but she wants lawyers to also go through the national service process as part of their training so that they can get some match time to get some experience even before becoming substantive lawyers or start practicing at the various courts. Another key proposal she's been making is the advocacy for non-custodial sentences for petty crimes. We know there's been large concerns about how the court has been what people describe as harsh on persons who commit what they categorize as petty crimes. Someone steals food and they get long jail terms compared to other persons who commit various crimes of different gravity, but sometimes are only fined or sent to prison for a year or 2. She said she'll be advocating for non-custodian sentence of such persons. Community service and all of that cannot be ruled out in some of those issues. And so those are some of the 2 big issues that's been coming up. Of course, she's touched on LGBTQ issues and all of that, which the minority leader, Alexander Penyumakin, has been seeking her view on, and other general court practices and judicial service issues that we've been hearing from the other nominees in the course of yesterday and today as well.
That came up is a proposal for e-justice, where she's proposing that moving forward, like the filing of writs should be done digitally. Tell me more about that.
In fact, it has been, she's not the first person to mention this. The previous Justice Philip Bright Mensah has also been talking about that, where he cites an example of the Kenyan situation where persons who want to file their cases electronically, specific booths have been created, like how initially we have communication centers where you walk in to make call. Similar situations in Kenya. And so she's also been advocacy for that, where persons will not have to move to the courtroom to file cases, where they can sit in the comfort of their home or dedicated places and file cases electronically, and those cases could get into the judicial system and be looked at. Date for a hearing could be scheduled and the client communicated to make the hearing of cases more expeditiously, as well as the call for even the previous nominee also called for even trials to be done digitally, where judges could sit at the comfort of their home or other part of the country and join the proceedings and preside over these cases on screens digitally. And so largely getting into the advocacy for entire digitization or electronic adaptation of proceedings in the courtroom, as the other nominees have all been calling for in the last few days.
Thank you, James Abeji, coming to us live from Parliament. Let's go on the phone lines now and speak to Ansar Sari, former director for the Ghana School of Law, just to pick his thoughts on some of the key proposals that have come up today after the vetting proceedings. We appreciate your time here on JoyNews Prime. I'll first of all like to get your thoughts. Should we consider placing a cap on the number of judges that are nominated to the Supreme Court? Well, Mr. Ansar, you have to position rightly so that I can hear you clearly. I just want to get your thoughts, some of the key proposals that have come up. And the key thing that came up yesterday was that controversial Article 60 and the thoughts by the different justices of the Supreme Court nominees about that article. Is there indeed a lacuna in that article? And we'll bring to you that conversation with Ansar Sari shortly, just to get his thoughts on some of the key proposals that the judges have been making. Key amongst them, placing a cap on the number of judges that would be nominated to the Supreme Court. Should we consider doing that at this point in time? Mr. Ansar Sari, I want to get your thoughts on that.
Good evening.
Good evening.
We need, as a nation, to consider whether our resources can be stretched to cover uncapping. Now, if there's no limit based on the number of persons appointed or elevated to the Supreme Court, there will come a time when we will not be able to pay them. And if judges are not paid, you and I know the consequences and implications for the needs. So, personally, I think that we should cap, the number of persons elevated to the Supreme Court. Under Article 128, Clause 1, the 1992 Constitution purported to cap it, but the wording, the way it was couched or phrased, has given rise to problems. So I think what we should do now as a nation is to seek to amend Article 128, Clause 1 of the 1992 Constitution, and maybe add another Clause 5 to Article 128, which will make reference to Article 128 and state that the number of justices stipulated in Article 128, Clause 1 shall not be altered, by any precedent. That way, no president will come and look for a job for the boys and girls. As some of them are now agitating and proposing that, we should have a Supreme Court situated in the North and call it, Supreme Court of the North. That is, something that shouldn't even, have been uttered in the first place. Supreme Court for the North, for what?
From where you sit, what number should we place on that cap? We've just been hearing from Justice Mensah propose 20 judges. What do you propose?
Well, America has 9. And just consider the population, the size of the population of America, the size of the country, the geographical size and all that. They have only 9. We are about 1 million of America, and we want 20. I will say that it shouldn't exceed 11. Yes, 11. At one time in the history of England, they had only 9 justices at the time America was, created. Perhaps the UK had about 3 judges, so which we didn't exceed maximum 11. Maximum 11.
Another key proposal that came up
for the justices of the Supreme Court.
Okay.
I have to be frank.
Another key proposal that came up just before I let you go is a proposal for e-justice delivery. When it comes to the filing of writ, the proposal being made by Justice Battles Kojo earlier, that we could consider making some of this process digital to help ease the burden on the process. What's your thoughts? Is that the way to go?
Well, I live in Ghana, and I know the problems we get from power outages. If we are in England and they don't have any outages as such, they can talk of e-justice. We are in Ghana. Go to Brahab, Bepome, or go to Ayikuma and talk about e-justice. You want to do electronic filing, and there's no electricity. We are in the rainy season. Most communities in Ghana are going to be without electricity, and you are talking of e-justice. Let us, learn to crawl, and not run faster than our legs and carrier.
Okay.
Leave those, who can afford the luxury. But for me, we should, consider the economic implications of, going e-justice or digital justice. Whatever it is, we teach our students the drudgery of longhand writing to, reflect the economic situation on the ground.
Okay.
So that if there's no light, they can work, they can write, they can buy candle, read their notes.
Okay.
If you say that e-justice, and the law deals with timing, computation of time.
Okay.
File the process within 3 days. If you miss the 3 days, you are out.
I appreciate your time so much here on JoyNews Prime.
Well, away from the vetting, several applicants seeking birth and death certificate across the country were forced to reschedule crucial appointments, some involving travel education and job placement, following nationwide shutdown of services by the Civil and Local Government Staff Association of Ghana. The move comes during mounting tension at the registry, where workers are demanding the immediate removal of the acting registrar, Samuel Adom Boyche. They accuse him of fostering a toxic work environment marked by intimidation. Public Relations Officer of CLOSAC, Edmond Akwe, spoke to Mamiese Thompson on the Joy News Desk.
Mr. Samuel Adom Boyche is intimidating workers of the birth and death registry. He calls himself the lion. He's passing verbal accusations to the association, saying that CLOSAC is foolish. Who can work with the lion in the office? Can he go into the office premises with macho men to intimidate our members? Is that the right work environment that we want? As an association, let's protect the welfare and safety of our members. We cannot guarantee the safety of our members within the birth and death registry.
What would you say to people who think that this is also a strategy to get the man out of office, especially when in February you staged the same action, insisting that the man not be, appointed to that office?
We are law-abiding citizens. As a union, we go according to law and order. So when we were called to the table, we should sustain our strike. We did. We expect that he, being the acting registrar, should act the right way, not to go and intimidate our members. We cannot allow an institution like Birth and Death that has built its reputation over the years for one person to come and destroy it. We will not sit down as a union to let this go on.
These acts of intimidation, have they been reported to maybe say the National Labour Council?
Well, these agitations are not going in the line of Labour Council. This agitation is employer-employee, agitation, and we are dealing with the employer directly.
Well, the situation forced applicants who trooped to various offices to reschedule key appointments because they could not access services. Emmanuel Bride Kweku captured the situation in Kumasi in the Ashanti region.
So, as you can see in your shot, these are the staff and workers here at the Birth and Death Registry here in Kumasi. And as you can see, they are locking up this facility. They have packed the chairs that were originally arranged here into the office. The workers are going to lock up this place in protest or in direction of what they were given by the national leadership, that's CLOCSAG, and the Civil and Local Government Staff Association workers in Ghana. The directive they gave in protest of the acting director of the registry over his misconduct and some allegations they leveled against him. And so they are closing this facility. We understand some applicants have also trooped in here to seek services from the Birth and Death Registry. But unfortunately, these applicants were actually turned away by the staff and workers here.
They said they are on strike. That's why we are going back. Now they are sacking us to go because they are on strike till further notice. That's why we are going.
But you urgently need a certificate for something?
We need it for passports. But now we don't know what to do next because without the birth certs, I don't think we can get our passports.
There was a mistake when I was making my birth cert. They used a different name, my middle name as my surname. And when I went to make my passport, I was asked to do the rightful changes before I can do the passport, else I'm going to face a lot of challenges. So I decided to come here today for it. When I came, they told me that they are on strike unless I come back on Monday.
My son is about completing school. I need a certificate for him. It's been 2 years now. I haven't been able to access
it. Because of strike now, because without birth cert, 20 million passports.
Until this strike is called off, for the many prospective applicants or those who had come here to seek services from the Birth and Death Registry, it would have to be on hold from here at the Birth and Death Registry here in the Ashanti region. My name is Emmanuel Bright Kweku.
Well, let's head to the Upper West region to speak to Rafiq. Rafiq, how is the situation in that region?
In the Upper West region, it's not as we are reporting from the Ashanti region. This evening, I tried some around 3-4 p.m. I visited some officers in the region. I'm talking about the birth and death, and then they were really working. So let me start a particular case has to deal with the War Municipal Office of the Birth and Death Registry, which is located just closer to the War Municipal Hospital. I met the workers, they were working, and I asked them whether they were not on strike, and they told me that they haven't heard anything from their bosses. For them, they were working.
All right. Thank you so much for sharing the latest update on the situation in the Upper West region with us.
Well, meanwhile, we have been doing some checks as well in the Central region. Let's touch base with our correspondent just to get a sense of what is happening in the Central region. We appreciate your time, Abigail Aisel. Just run us through what is happening on the grounds. Is the strike beginning to bite hard already?
To the Cape Coast Birth and Death Registry, and we found the place locked. It was under lock and key. Luckily for us, we didn't meet any stranded individuals seeking the services of the facility. It was the same issue at the Elmina Birth and Death Registry as well. I was able to get in contact with some of the employees there who tell me that they received directives from the national management not to go to work today. And thankfully, they haven't received any calls for individuals who are trying to seek services of the facility. Usually, they have people who contact them personally when they are coming to the facility, but today they haven't received any calls, and they are presuming that the people are aware of the strike going on right now, and that's why they haven't called them. But today, when we visited both the Cape Coast and Elmina Birth and Death Registry, there were no operations happening. The place was under lock and key.
We appreciate your time, Abigail. Now, our sources at the National Labour Commission indicate that CLOCSAG never communicated their intended industrial action to authorities. Let's speak now to the National Labour Commission Assistant Public Affairs Officer Julian Pauvi. We appreciate your time here on JoyNews Prime. Is that the case? You were never consulted?
Evening once again. PLOXA did not officially write to the Commission on its intention to embark on a strike action. However, the Commission's attention was drawn to some online publications indicating that PLOXA had directed staff of the BEFs and DEFs registry to embark on a stay-at-home strike effective 17 June 2025 over an alleged misconduct by the acting registrar of the BEFs and DEFs registry. The Commission, having been notified of this, wrote a summons letter inviting parties to appear before it on Thursday, 19 June 2025 at 2 p.m. And we also directed or advised that the union, that is PLOXA, to stay any and all ongoing actions and appear as scheduled. The Commission also advised the acting registrar of the BEFs and DEFs registry to respond officially to the allegations made by PLOXA as well.
What timeline did you give him to respond to the allegations?
By the close of tomorrow, that is Wednesday, 18 June 2025. And the hearing is on Thursday, 19 June 2025 at 2 p.m.
So you're already mediating the talks, even though you are not officially notified?
Yes.
What should we expect?
And that is one proactive step that we've... Sorry.
No, make your point.
Because, I mean, PLOXA is government machinery, and their services are so important that it can create a standstill in services, as we've seen happening around the country. And that is why the Commission thought it's wise to invite them to appear before at the earliest time, which is the Thursday, 19 June 2025.
And have you gotten official response that they would indeed honor this invite?
What is important to us is that we've sent them through our dispatch clerks to appear before us on the Thursday, 19 June. So it is expected that they appear before us.
Thank you so much. We appreciate your time here on JoyNews Prime.
Well, let's shift our attention to some politics because the New Patriotic Party has set July 16, 2025 for its National Delegate Conference. A 9-member planning committee chaired by former First Deputy Speaker Joseph Osei also has been tasked with overseeing preparations. This follows a National Executive Committee meeting which ended a while ago. Let's go live now to speak to my colleague Collins Frimpong, who has been following development at the party's headquarters here in Accra. Collins, what more can you tell us regarding this particular meeting?
So, Carlos, the meeting started around 10 a.m. today and it ended a few minutes ago, as you have stated. Quite a number of issues that the National Council and also the National Executive Committee looked at, and some of the main issues that they looked at, first of all, was the Ablekuma North parliamentary elections, where coalition have stalled for several months now after the 2024 general elections. And according to the General Secretary of the NPP, Justin Kodia-Frimpong, who addressed the media right after the meeting, according to him, the National Council of the NPP has expressed frustrations over the delay in the collation of the Ablekuma North elections in the Greater Accra region. And according to him, the National Council is accusing the Ghana Police Service for colluding with the National Democratic Congress, the NDC, and also the government to obstruct the process. And according to him, the explanation that he provides is that the Electoral Commission, the EC, has stated vehemently that they are ready to continue with the collation, but the Ghana Police Service have been giving excuses, and according to them, there is an issue. There is a court hearing at the High Court preventing them from continuation, and also if they will go ahead to provide security to the EC for them to continue with the coalition, that one would depend on a directive from the Attorney General. So this is what Justin Kodia-Frimpong, who is the General Secretary of the NPP, stated today concerning the Ablekuma North elections, and because of that, the NPP is writing to the Ghana Police Service to provide security, demanding that they need to provide security to the Electoral Commission to ensure the continued collation of the parliamentarian elections in the Ablekuma North elections. Another issue that the Council and also the National Executive Committee has been looking at is the Frank Davis Committee, which was set up in April this year to look at Professor Michael Quay's committee's report that was presented on the 2024 general elections. And the committee that was set up, the 9-member committee that was set up by the party and also chaired by Frank Davis, presented a number of proposals, and one of the proposals was the party's electoral college. And according to Frank Davis, the committee is proposing that they need to expand the college, but the National Council has also referred to that this particular decision, whether they are going to expand the college, the electoral college, will depend on their delegate conference, which they have confirmed that it is going to take place in July 16th, 2025, next month. And also another proposal from the committee was that they need to work on the presidential primaries as soon as possible. And they also recommended a review of the constitution. But the National Council or the committee, the NEC, stated that the review of the primaries, the date or the timing, does not demand or does not call for amendment of the party's constitution, because Article 13 of the Constitution states clearly that that particular issue needs to be addressed at the delegate conference. So they are going to address that at the delegate conference on July 16, 2025. And finally, the presidential primaries is going to happen in 2026. On January 31. So this is what has been happening here at the Alisa Hotel in Accra here concerning the NPP National Executive meeting today.
All right, thank you so much, Collins, for those great updates from the NPP headquarters.
Oh, you're still watching JoyNews Prime, and still to come, Israel makes fresh push for Ghana to abandon its long-standing neutral stance in international affairs and take sides in global conflicts. We have more after this quick break.
See, let me tell you something. I'm large and in charge. You see this life, they say follow who know road. I'm the road and I'm in control. I drive my own life and nobody can tell me what to do.
Nobody?
Absolutely no one. I'm large and in charge.
Please, stop here.
Sure, honey.
Areas we won't. Obia on a master. A big you that.
Calipo fruit juice drink. This advert is FDA approved.
Every day, people have money emergencies. Ma, I need my school fees emergency. Mommy, chop money emergency. Emergency. Catch it. I'm your rent emergency. Now, there's a new emergency number in town. Dial star 770 hash for all your money emergencies and chop.
Dial star 770 hash for money emergencies and get easy and quick access to your money, loans, and other banking needs. EcoBank, the Pan-African Bank.
Hey, Charlie, what number? The malaria really knocked you down, eh?
Charlie, no joke. Fever, headache, vomiting, loss of appetite. I couldn't even eat my usual fufu.
You and your fufu. But I hope you got tested before the malaria treatment.
Yes, I did. And thanks to Malatu, I kicked out malaria one time.
When malaria strikes, take Mala 2, containing artemether and lumefantrine. Comes in tablets and suspension for effective treatment of malaria.
Great to have you back. Thank you. No problem.
Mala 2 is suitable for adults and children. Manufactured and distributed by NS Chemist Limited. This advertisement has been vetted and approved by the FDA.
Hey, new Wele.
But you won this so many times before.
Every dress be new Wele with Printex.
Once upon a time, in the heart of Accra, a man in his fancy car sought directions. But oh, the Ghanaian way.
Hello, bro. Good afternoon. Good afternoon. Can you please show me where the Presby Church is?
Oh, sure.
Go straight. 10 left at the big mango tree with the broken branches with most of the mangoes falling. Right after that tree, there is a watch cellar. If you reach, ask there. Anybody will show you.
When the Black Stars stick to the field, every Ghanaian becomes a coach.
My Fatika want to be dribble. The coach must go.
The sacred cue for our beloved Gobe. As we wait patiently, rehearsing the perfect vibe.
Have you at it? Mami Gobe, the cocono. One Garino.
These, my dear ones, are some few moments that makes our Ghana truly special.
And as we share these stories, let us also remember a plate of lele rice, connecting our hearts through the flavors of our culture. Lele rice, ye nimno fritete. This advert is FDA approved.
Malaria's remedy is Lonat. Therefore, we're gonna use Lonat to recover. You have malaria? Yes, are you shivering? Yes. You got chills? Yes, take Lonat. First day, take Lonat. Second day, take Lonat. Third day, take Lonat. That's all. Lonat scatter malaria. Lonat ide scatter malaria.
This advert is FDA approved.
Welcome back to other stories now.
Well, Israel is intensifying pressure on Ghana to abandon its long-held policy of neutrality in international affairs and take a definitive stance in global conflict. The push comes after Ghana, currently chairing the IAEA board, abstained from a crucial vote that found Iran in breach of its nuclear non-proliferation obligations. Shortly after the vote, Israel launched missile strikes on key Iranian targets. Israeli ambassador to Ghana, Roy Gillard, expressed disappointment over Ghana's position, saying that as a friend and chair of the IAEA, Israel expected Ghana's full backing. He called on Ghana to reconsider its non-aligned foreign policy and stand in support of Israel.
Your government was elected to serve the interest of Ghana. My government was elected to serve the interest of Israel. I think Israel is facing, luckily for you, more challenges than Ghana. Ghana, I think, supports Israel. I think Ghana understands Israel. Indeed, we are facing a new situation in the Middle East since the 7th of October 23. Ghana, by the way, issued immediately a declaration who supports Israel, and back in 23, support Israel's right of self-defense. Now Ghana, I think, maybe because of what you said, that Ghana do not want to expose itself. I think Ghana is taking again a neutral position vis-a-vis this conflict. We have an ongoing dialogue with your government, and I hope we shall be able to express Israeli needs and Israeli interest in a better way.
Well, the Israeli ambassador to Ghana, Roy Gillard, also dismissed Ghana's concern that the Israel-Iran conflict could trigger a spike in global crude oil prices. According to him, those fears have not yet materialized.
First of all, I listened to what President Mahama said about the concern. You spoke about it earlier, the concern from the rise of the price of fuel. So far, by the way, it didn't come true. There was a 7% rise in the price of an oil barrel at the first day of the war, but since then it is stable. It is around $74 a barrel, which is again stable in the last 5 days. Hopefully it will remain. The only thing I expect Ghana is to understand Israel better.
Meanwhile, Ghana has activated emergency measures to protect its nationals in Israel caught in the escalating Israel-Iran conflict, where some Ghanaian nationals, including students, remain trapped as the country's borders are sealed. According to the Foreign Affairs Minister Samuel Okudzeto-Ablakwa in an X post, the Ghana's embassy in Israel has identified 922 Ghanaians. On your screen is the ministry's second update since the war. And these are the measures. No Ghanaian fatality or injuries. Evacuation from Iran proceeding successfully. And Ghana's embassy in Israel has identified 922 Ghanaians currently living in Israel. And included in that figure are 65 Ghanaian students staying in 6 Israeli universities. And channels for regular communication with the Ghanaian community in Israel have been established, with Israel authorities declaring a state of emergency and closing all borders. An evacuation from Israel cannot be carried out now, except with the express authorization of Israeli authorities. Ghana is pursuing those approval options. Now, in a briefing by the Israeli Foreign Ministry, all diplomats and embassy officials from all over the world have been encouraged to work from home. Our embassy is complying with that advice. We are ensuring that all Ghanaians living in Israel have access to bomb shelters. And the Ministry of Foreign Affairs has approved an emergency evacuation plan for Israel, which will be promptly activated when conditions are met. And President Mahama's administration is resolved to spare no effort in ensuring that Ghanaians caught up in this Israeli-Iranian conflict are offered full protection and removed from danger. We shall not fail our compatriots. Now, let's explore further with international relations expert Dr. Ishmael Lovo. Thank you so much for joining us here on Joy News Prime. Now, Israel says Ghana's neutrality is no longer enough in today's global conflict. And should Ghana at this point abandon its long-standing non-aligned position? Dr. Lovo, if you can hear me, I'm asking, Israel is saying that we should abandon our neutrality position. And I'm asking if that call is necessary at this point. Well, we'll try to reconnect to Lovo and bring you details of that conversation later.
Well, away from that, President John Dramani Mahama says Ghana's economy is beginning to turn a corner, pointing to falling inflation, a stabilizing city, and a credit upgrade from Fitch as signs of progress. Our global credit ratings agency Fitch Ratings announced it had upgraded Ghana's long-term foreign currency issuer default ratings from restricted default to B with a stable outlook. Speaking at the Ghana-EU Partnership Dialogue in Accra, President John Dramani Mahama credited ongoing reforms and debt restructuring efforts for restoring investors' confidence.
Our long-standing partnership with the European Union has evolved into one of mutual respect, shared ambition, and deepened strategic alignment. This dialogue is not simply a formality, but a testament to our shared commitment to building a resilient, inclusive, and sustainable future for our people. Ghana and the EU have consistently pursued a common agenda that has been rooted in our shared values and is based on sustainable development, democratic governance, climate action, and regional stability. Through this forum, we reaffirm our partnership as development allies and co-architects of a new global order that prioritizes equity, innovation, and dignity. On macroeconomic recovery and fiscal governance, Ghana's economic outlook is rebounding steadily. Our administration remains committed to restoring macroeconomic stability through prudent fiscal management, enhanced domestic revenue mobilization, and expenditure rationalization. Working in partnership with the Bank of Ghana, we're stabilizing inflation, stabilizing the cedi, and pursuing debt restructuring strategies to to restore confidence and rebuild the fiscal space for development.
Well, on regional security, the president said Ghana is stepping up defense spending in response to the growing threat of terrorism in neighboring states. He also urged stronger cooperation on migration, saying the Ghana Labour Export Program will ensure safer and more structured labor mobility.
The Ghana Labour Export Program will ensure that labor mobility happens safely and humanely. This will help prevent the risky Sahara and Mediterranean crossings many of our youth undertake. On peace, security, and defense cooperation, Ghana remains a beacon of peace in West Africa. However, the growing threat of violent extremism across our borders demands urgent and coordinated action. It compels us to increase defense spending to prepare our armed forces to protect our country's territorial integrity in the event of any threat. The EU has been a steadfast partner through support under the European Peace Facility, including provision of non-lethal military equipment. We are now looking to elevate this cooperation. Ghana seeks EU collaboration in developing a resilient and technology-driven defense industry.
Well, let's explore our earlier story further with international relations expert Dr. Ishmael Hovo. We appreciate your time. We lost you earlier, but we just wanted to pick your thoughts briefly on Israel's proposal. They want Ghana to abandon its long-standing neutrality stance and take a position. Is that the way to go? Should we consider that at this point in time?
Good evening to you and good evening to your viewers. I'm not sure that that would be a very prudent policy for Ghana, given our current state of development and the need for us to pursue a very balanced diplomatic approach that ensures that people across the globe, or nations across the globe, are friendly to us to derive benefit where we think we can derive benefit. So while the ambassador is within his right to express his frustration, I'm also sure that Ghana is right to stick to the policy of non-alignment and positive neutrality. Indeed, we have, if it's come to Israel, there are occasions where we have supported them. In fact, when they were attacked by Hamas, we expressed the fact that they have the right to self-defense, and we acknowledge that, and we support them to defend themselves. But then if we think that at a point, the level at which they are taking the issue of self-defense is beyond what we can accommodate, we are right within our right to say that we are not going to back them full haul.
I just want to get an understanding what the potential diplomatic threats or benefits would be if Ghana sides with either Israel or Iran on this issue.
Now, so when you side with one side, you don't only risk the relation with that particular country, because across the two divides, there are countries that are divided along that line. So Iran has its own supporters, and Israel also has its own supporters. So what we are going to risk is that once you take side, you have aligned to that section, and therefore conducting relation with the other side becomes difficult. And given where we are, we have interests that cut across all the various divides, and we have to pursue a very balanced approach that ensures that we maintain a position where we can engage both sides of the divide.
I appreciate
and of course,
Thank you.
As a country, of course, neutrality also allows you to be a mediator. It's not all that bad. So.
Thank you so much, Mr. Ishmael Hovo, for bringing us updates on that. But we have to let him go at this time. And guess what? It's showbiz time.
Yeah.
He'll be in the studio shortly.
Right.
So please stay with us.
Okay. So.
Well, it's time for showbiz, and Empress Becky joins me in the studio. Hi, Becky.
I'm looking for the Empress. Empress, that's new.
Yeah.
Okay.
Like the title?
That has actually been gazetted by somebody else. But
okay,
it's cool.
Please.
Good to see you, Fosti. Let's talk about Inchinchim ban, because they are advocating for the formation of a union for musical bands in Ghana to enhance their credibility. Speaking on the musical band series of E-Vibes, the band leader revealed that Inchinchim band also plans to develop a software platform to simplify the booking process for bands in Ghana.
So Inchinchim thought about something years ago that we are trying to get a software or like an app. We bring all bands on board, bring everybody who wants to patronize the band on board, so that you know that this band is, and it's because people don't trust the band. So this band is trustworthy. If I'm paying through this app or something for the band, or we discuss, Charlie, let's be a group as a like bands association, so that if we are charging, let's say 50,000, band class A of bands are charging 50,000, class B charge like from a range of, let's say, 20,000 to 30,000, class C like 10. So you know that if you are taking a band in Ghana, you have a minimum charge like, let's say, 10,000. But no, you do the business, you go and charge 20,000, and the band will go and take 3,000 with more equipment and everything than yours, and go and play. And you can't do him anything. You didn't buy the instrument or equipment for the person. And it's worrying us. Aside that is normal gigs. Aside that, the art, like a band is an artist. Like it's not only one person. So
you haven't projected that well.
Yes, that's what I'm saying, because
a lot of people
this guy is not agreeing with me. We taking the money and then putting it. Go and just do a photo shoot or go on a radio tour, and no.
I want my money.
Yes. You see, and I think that is what is killing us. And the young guys coming, hey, we the young guys coming. I beg you, music pays. If you really, and this is the only this is the only profession that can take you to the highest person in the world.
Inchinchim band right there. The story is still airing on the JoyNews channel and also on the Joy Prime channel. It's all about the musical band series. If you haven't seen it yet, well, I'm telling you, here for Steve, I'm not sure you've watched this.
I haven't watched this episode.
Yeah,
I haven't.
You haven't. Yeah,
I have to.
You have to pay attention. Tomorrow I'll bring you something else on Inchinchim band. But for Steve, it looks like the whole world is coming to Ghana. Like everybody seems to be traveling to Ghana. I don't know why. It's not December yet, but because I know that in December we have visitors coming in just to have fun, relate with the locals and all of that.
Anthony Joshua was here not too long ago. And we're wondering what exactly is drawing them to Ghana when Ghanaians are looking for opportunities to leave the country.
We have a beautiful country for States. Because you're living here, you cannot appreciate it. But they all appreciate it. And so, Empire star Jussie Smollett, he's also in Ghana. There have been pictures that, he's posted on his Instagram page. He visited the Black Star Square. Oh, that's him.
Oh my God.
This one is
Hello, handsome.
Du Bois. He visited that place as well.
Okay.
He was also at the Black Star Square. Obviously, if you're coming to Ghana, if you're anywhere around the world and you're planning on traveling to Ghana, the Black Star Square is, your first point of call. You need to be at the Black Star Square. There's a lot happening at the Black Star Square that's...
Becky, you need to bring him to JoyNews for an interview.
I'm not too sure. I'm not too sure exactly why he's in Ghana, but I know that his cousin brought him. He's just having fun.
Oh my God!
Celebrities for they're coming. Oh, he was inside ShopRite, shopping as well. I know.
If he's single, let the single guys
he belongs to the Rainbow family. I'm not sure you've been following. Jassy Smollett, I'm sure he's taking
another giant has.
I don't know his
slain.
boyfriend or his husband.
Oh my God!
But I'm sure he's taking. He's not looking for anything for Steve.
Okay.
But let's still stay in the U.S. But Jassy is here in Ghana. We hope that you're having a good time, Jassy, and please bring the rest of the cast to Ghana. We're expecting all of them. But a sad one for Steve before we go. Former Grey's Anatomy star Eric Dane speaks out for the first time in a television interview about his battle with ALS, a degenerative neurological disorder. His doctor, Dr. Merritt, warns ALS cases are on the rise and gives information about a research study to slow ALS.
The gifted and beguiling star of Grey's Anatomy, immortalized as Dr. McSteamy.
Everything.
He is also the tormented father on Euphoria. And yesterday, for the first time, he told us the detail of his shattering diagnosis, ALS. How you wake up each day and wonder what's lost to the disease.
I have one functioning arm. My dominant side
is your right side?
Yeah, my left side is functioning. My right side is completely stopped working.
And then your left arm is fine?
No, it's going. Yeah, I feel like maybe a few more months, and I won't have my left hand either. It's sobering. I'm fighting as much as I can. There's so much about it that's out of my control.
The 52-year-old actor is here so that anyone else who receives the shattering news will know they're not alone.
McSteamy right there. For those of you who have seen Grey's Anatomy, that's McSteamy right there. We wish him all the best. But Fossey, let's talk about the BEC kids. They are very excited. I know the first time I completed, JHS, I knew that I wasn't going to school the next day. There wouldn't be no learning and all of that. So I was very excited. I'm not too sure about these kids who, just got out of school. So I'm
sure they're excited as well.
There's a story from the NEMA cluster of schools as BEC candidates wrapped up their final paper. For many, it marked the end of junior high school and the start of new dreams. JoyNews' Jacqueline and Soma Yeboah was there to capture the emotions.
So the bell just went off some few minutes ago. This means that the final paper for the 2025 BEC is over. We're here to gauge the mood of the students right here. They just finished with their closing assembly. So I want to find out how excited they are.
We wrote creative arts and French.
In French? Yes. How was it for you?
Oh, it's not that hard, but it's hard.
It's not that hard, but it's hard. Oh, why? What was hard, the French or the creative arts?
Yeah, the French.
How was the paper for you? Good. It was good. How was the French?
It was quite good, but alhamdulillah.
Alhamdulillah. Comment ça va?
Ça va très bien.
What grade are you hopeful of coming out with? 7-1. How was the French for you too?
The French was good.
Okay, what school do you want to go to? Big Boss.
Hey, Auntie. Auntie says 7-1. We wish you all the best.
We wish you all the best.
But remember that there's senior high school, then there's university, then you're going to do your master's. There's a whole lot of things. Don't be excited. Please watch JoyNews and log on to my journal.
Please be excited. Every little feat is.
It's a long way. It's a long way. Tell the kids it's a long way. And 7 ones. Wish you all the best. I didn't get 7 ones though.
Okay, we have to go at this point. Bye.
Every day, people have money emergencies. Ma, I need my school fees emergency. The chop money emergency. Emergency. Catch it. I'm your rent emergency. Now, there's a new emergency number in town. Dial star 770# for all your money emergencies and chop life.
Dial star 770# for money emergencies and get easy and quick access to your money, loans, and other banking needs. EcoBank, the Pan-African Bank.
Bills, Mama Pisiapo. Afisa said, Nasika bebre, Abamo Bia, Botomaya de. Bills, I can't move you more. You see 2025 year, and it does for homo Bia or Tuopa, only a Jumaye. But when it's bills, now that you loan, now ubit media, wow, Juma. Way a loan don't come me. We hear shade, we hear Ghana card, a one now Zaka Usika. Nasa we you been so we are wow Juma, Opesa would tremu, and now Juma ni how would you Busumia Ketia, and your bill said bray, now bet you luna, who for be beer and siawa, collateral, and nasa deposit, Anne, we hear mubia.
It's your feed, yes, you will be a winnie to me be a ye, who bet me a bet you loan. It is a woods nephew, and as a when yes, you can be dear. Hey, wow!
Fred Bills says, yeah, now what's near to our bills? Nemo, this is a cacao.
Every dress. Hey!
It's new, Leo.
When it's quality, it always looks new. Every dress be new Wayland with Printex.
So, Charlie, the deal there, I almost get her.
Syntax pipe, as tough as it can get.
You get so sorry with your back, sorry. Oh, what am I doing? You was a thing.
What the cat never won.
We can catch him. Hey! Now, I'm back.
Between the kept high and cabo.
Hey, madam, pipe, menu.
A syntax pipe. Metono, Omukacham send a one day pa. Say a fee, say a foam. The other pipe we be a yen gum.
Syntax pipe.
Why a leaky?
Come, madam. From today, syntax pipe in my pipe. No 2 ways.
We need a pipe ben abe use.
SINTEX pipe.
Syntax pipe.
In a carry water. No hala.
After this fufu and pepper soup, I go score goals like them the dash points.
Kivo 100% natural hot pepper. Good for your jollof, stew, soup, shito, spaghetti, and noodles. Kivo hot pepper. Moko show.
I'm a match winner, but the real champion is Kivo 100% natural hot pepper. Champion taste.
This advert is FDA.
Hey, new Wele.
Yes, so it's Printex.
It's new Wele.
So you want this one also?
Every dress be new Wele with Printex.
Upon a time, in the heart of Accra, a man in his fancy car sought directions. But oh, the Ghanaian way.
Hello, bro. Good afternoon. Good afternoon. Can you please show me where the Presby Church is? Oh, sure. Go straight. 10 left at the big mango tree with the broken branches with most of the mangoes falling. Right after that tree, there is a watches cellar. If you reach, ask there. Anybody will show you.
When the Black Stars take to the field, every Ghanaian becomes a coach.
Why Fatika want to be dribble? The coach must go.
The sacred cue for our beloved Gobe. As we wait patiently, rehearsing the perfect vibe.
Have you acted? Mami Gobe, the cocono. One Garino.
These, my dear ones, are some few moments that makes our Ghana truly special.
And as we share these stories, let us also remember a plate of lele rice, connecting our hearts through the flavors of our culture. Lele rice, ye nimno free tete. This advert is FDA approved.
Prime Business is brought to you by EcoBank and Syntex Tank.
Hello, good evening and welcome to Prime Business. I am Pius Kojobaka. Ratings agency Fitch has upgraded Ghana's credit rating to B- from restricted default and assigned the country a stable outlook. More in this report.
The verdict by Fitch is more of an advice to investors around the world that Ghana is now in a better position to meet its debt obligations due to the significant progress that it has made with creditors under the debt restructuring program. Fitch, for instance, in the report issued on Ghana, noted that even though the country still has about $2.6 billion to be concluded when it comes to the debt restructuring program, it sees the risk to Ghana as small. Fitch revealed in the report that it hopes that Ghana can finalize the remaining debt restructuring initiative by the end of this year. Now, despite the good verdict on the economy, Fitch was quick to warn that they still see inflation rate pressures contributing more to the fiscal consolidation path. Meanwhile, the Finance Minister, Dr. Atto-Forson, in a statement has maintained that the move should signal growing investor confidence in the economy.
Reacting to the upgrade of the country's credit ratings, Governor of the Bank of Ghana, Dr. Johnson Esiema, said this is a testament to the great work being done on the local currency and the economy largely. He was speaking at a thought leadership event by the Ghana Association of Banks and ABSA Bank on the topic, Banking the Last Mile.
And only yesterday, for some of you may have heard, Fitch has upgraded our sovereign rating once again. This is testament to the progress we are talking about. You just have to look at our external sector performance and be guided. Do not be driven by speculations. Do not be driven by what somebody said. Do not be driven by what His Excellency the President said. Be driven by what I say. And of course, be driven by what the data says. Look at the data we put out there and be guided accordingly. Now, as I always say, our focus is to limit exchange rate volatility.
Meanwhile, the Bank of Ghana says it is committed to a flexible exchange rate system backed by strong economic policies to support business growth. The governor said the central bank is noted not interested in any rigid exchange rate targeting nor predetermined value of the local currency.
The Bank of Ghana has adopted a disciplined, market-oriented approach, reducing its reliance on reserves and instead leveraging a more efficient FX auction framework, enhanced market surveillance, and also stricter alignment of foreign exchange demand with real sector transactions. These measures, colleagues, have curtailed speculative pressures and ensured that foreign exchange flows reflect legitimate trade, investment, and remittance activity. In parallel, the macro fiscal adjustment being implemented under the IMF-supported program is yielding results. Fiscal discipline is restoring credibility, and external financing flows have improved. Combined with sustained disinflation, positive real interest rates, and resilient export and remittance inflows, these developments have anchored expectations and restored confidence in the currency's value. So let me be clear, colleagues. We are not pursuing a rigid exchange rate target or a predetermined band. None of those. The Bank of Ghana remains committed to a flexible exchange rate regime, one that is anchored in fundamentals, responsive to shocks, and supportive by credible policy tools. We remain vigilant and fully prepared to act in a timely and measured manner to preserve orderly market conditions and safeguard the broader macroeconomic stability that is necessary for financial innovation and inclusion to thrive.
And we know the central bank is expected to act swiftly this week by boosting its dollar supply to banks in an effort to meet rising market demand.
We are learning that the spike in dollar demand has been influenced by recent comments by President John Mahama that they are looking at the true value of the Ghana cedi being pegged at 10 to 12 Ghana cedis. This has resulted in some businesses trying to move fast to take positions once the dollar is cheap before any future depreciation. Another reason for this pressure, according to bank treasurers, is that there were some offshore investors that were taking profits for their earlier investment in the country. However, the central bank has given the firm assurance that all commercial banks that are having demand issues will be met this week. This should be complemented by general market support in addition to what the regulator will provide to the market. This should help in firmly stabilizing the Ghana cedi to ward off any fresh demand pressures that will come in the coming days.
More from the central bank because they have reiterated their commitment to supporting digital transformation and adoption of artificial intelligence across key sectors of the economy. Now, speaking on behalf of the governor at the launch of Blue Node AI Cloud by Blue Space Ghana, Deputy Director at the FinTech and Innovation Office, Uri Kwasari, said the central bank is fully aligned with innovative technology that strengthens financial services and economic development.
Speaking on behalf of the Governor of the Bank of Ghana, Deputy Director at the FinTech and Innovation Office at the Bank of Ghana, Uri Kwasari, said the bank is committed to supporting the digital innovation landscape and encouraging the use of artificial intelligence to transform financial services, trade, and public service delivery.
At this important milestone, the launch of the Blue Node AI Cloud platform. This launch goes far beyond technology. It represents a strategic shift in how Ghana is preparing for the next generation of digital transformation, financial innovation, and data support.
Revenue Operations Lead for Blue Space Financial Cloud, Kwame Pla, highlighted the platform's direct value to financial institutions.
So Blue Node AI Cloud is an innovation Blue Space Financial Cloud is starting. We're setting up an infrastructure as a service where, backed by AI technology, to be able to provide quality infrastructure to treasury, trade, and financial systems. We're primarily focused in the financial services sector, which is the bread and butter of our business. The next level which we're looking at is to provide resilient disaster recovery technology for all our clients and also partners. This does not also leave out other agencies besides financial services.
Her Excellency Juliet Bino Sutherland, High Commissioner of Barbados to Ghana, noted that Barbados is exploring new avenues of cooperation with Ghana, particularly in AI and cloud-based technologies.
Ghana has emerged in West Africa as a leader in the technology space, in both fintech and in both regulation of fintech and even in cybersecurity. Ghana is rated extremely heavily. Organizations like Blue Node and their partner Pax, Nexum, have come into this space and are really raising the bar. What persons like myself do is visit organizations, try to learn more about what is happening in various sectors, in this case fintech.
Regional Sales Director at Nexans, Adrian Edges, emphasized the critical role of infrastructure in scaling AI adoption in Africa.
Well, if you're talking about AI cloud, it can be, from a Blue Node perspective, is fantastic for the region. You know, having the data center local in Ghana, supporting local African organisations. The ability to deliver sovereignty within the region is amazing. One of the key benefits that we're actually providing Blue Space with the Blue Node technology is the ability to scale on demand.
The launch of Blue Node is being hailed as a major leap in Africa's digital transformation journey, positioning Ghana at the forefront of the region's AI and fintech revolution. Blue Node AI Cloud, launched by Blue Space Ghana, is a sovereign, high-performance AI infrastructure purpose-built to support Africa's financial services, trade, and public sector transformation.
Away from the central bank, but on AI, the Institute of Chartered Accountants Ghana has initiated steps to incorporate artificial intelligence into the regulation of the accountancy profession in Ghana. This initiative forms part of the Institute's broader efforts to align with evolving global trends in the field. Chief Executive Officer of the Institute, Akwesi Agyeman, made the announcement in an interview with Joy Business following a health walk and fun games held to kick off this year's Accountant Week celebrations.
This year's Accountancy Week celebration is focused on digital skills and artificial intelligence in Ghana. According to the Institute of Chartered Accountants Ghana, ICAG, artificial intelligence, AI, is playing a key role in many global markets. Hence the need for Ghanaian accountants to take personal interest in AI. Speaking at the Fun Games to kickstart the Accountants Week celebration, Chief Executive Akwesi Agyeman said this is critical to improve upon their work.
Whether we like it or not, that is what the order of the day. Artificial intelligence is about everything in the world, everything about humanity, including professional bodies. Accountancy profession is also impacted with digital space, digital platforms, and AI being the new thing across the globe. We cannot do without getting into AI. So what we plan to do during the conference is to unwrap AI, delve deeper into AI, and then also drawing the accountants' attention to what AI is offering. Some people say, hey, with AI, we may be losing our jobs. Yes, if you fail to move along with AI, then you stand the risk of losing your job. But if you are with AI, and then you know what is in AI, and you know how AI can impact your job, can impact your work, then definitely you are keeping your job.
President of ICAG, Augustine Addo, also explains that the Fun Games will help usher members into the celebration on a positive note.
In the second quarter of the year, the Institute devotes 1 week as Accountants Week. During the week, the Institute organizes programs that would allow us to have an introspection about the previous year's activities and see what we did, what we didn't get right. Then we'll also look at what we can do in the forthcoming year to improve the systems that we did last year and also to see the way forward.
The week-long celebration will climax with a conference and awards ceremony at Takoradi in the Western region.
And to some other stories, data from EM Advisory projects that Ghana could lose approximately $1 billion in export revenue in the medium to long term due to the 10% U.S. trade tariffs, I should say. Now, speaking to Joy Business, co-founder and managing partner at EM Advisory, Dr. Abdul Ganiyu, proposed value addition to Ghana's exported commodities as a strategic response to leverage opportunities in the U.S. and other international markets. More in this report.
If the 10% tariff imposition stays, then Ghana could suffer over $1 billion lost. So as far as export revenue to the U.S. market is concerned, in the normal scheme of things, you would think this is still not significant. But if we narrow it down to the individual businesses, we think it does. And that's why we looked at the first 10 commodities and what the implications are. So now, what will the individual businesses do? One is to have in mind that your exports to the U.S. market could suffer a fall of about 20% if you consider the 10% tariff imposition and the trade elasticity of the U.S. economy.
Dr. Abdul Ganiyu underscored the importance of strategic business engagement to help mitigate the rising cost of export in light of evolving global trade dynamics.
Could be, maybe you want to even reduce your price before it gets to the U.S. market so that importers in that economy are not going to pass it on to the local consumer. You can think about that. Maybe another option is to look at burden sharing, right? And that is why developing strategic relationships between exporters and importers is so critical. Because you've been exporting to the US market over the period, you certainly would have built some form of relationship with importers over there. So maybe take 5% on your side, you take 5% on the other side, and at the end of the day, what happens? It neutralizes, so the prices will still be the same.
The AGI Breakfast Meeting, held in partnership with Emerging Market Advisory Limited, focused on the theme, the impact of the US tariff increase on Ghanaian exports.
The Automobile Assemblers Association of Ghana has expressed the need for strong policy support to drive growth within the sector. President of the association, Jeffrey Opon-Pepra, called for a clear strategy to build a full value chain from local parts production to vehicle assembling. Mr. Pepra also said the right policies could turn Ghana into a true automotive hub for West Africa. He spoke at the 2025 Ghana Automotive Summit.
Speaking at the 2025 Ghana Automotive Summit, the president of the Automobile Assemblers Association of Ghana, Jeffrey Opon-Pepra, called for a clear and coordinated strategy to build a thriving industry capable of serving not just Ghana, but the entire West African region. He also urged government to expedite the rollout of a component manufacturing policy to complement current efforts in vehicle assembly, noting that this would create jobs, attract investment, and stimulate broader economic growth.
On this note, I also emphasize that government should come to our aid and speed up also component manufacturing policy, which is waiting for a lot of investment. But first, let's get the auto policy moved, and with that, all the unlocked potentials will definitely come through on its own. There's a strong investment sitting on the shelf waiting. We don't have to lose this opportunity because other economies are looking at what we are doing. And I will talk further about our collaborations with the Ivorian government, which we have started discussion last year in November.
On this part, Chief of Staff Julius Debra reaffirmed government commitment to supporting Ghana's growing automotive industry, promising enhanced incentives for members of the Automobile Assemblers Association of Ghana.
As a government, we will definitely make sure that the rightful incentives are provided, because literally our thinking is that if you have a hen and it lays an egg and you decide to eat the egg, your chances of getting more chicks is going to be non-existent. However, if you decide to let your hen hatch the eggs, pretty soon before you turn around, you see that you have a lot of chicken that you can sell and use.
The annual summit brought together key industry players, policymakers, and international investors to discuss the future of Ghana's automotive industry and the strategic role it can play in the country's industrial transformation.
This is still prime business. Unilever Ghana has relaunched its Pepsodent charcoal toothpaste at the Kwapong Diaspora Dome. In an interview, brand manager for oral care, Glenn Abraham Ampoma, said the upgraded formula is more than just a product. It is a cultural statement designed to whiten teeth, refresh breath, and empower Ghanaians with confidence to smile through tradition. More in this report.
Unilever brought together stakeholders and media for the unveiling of its Pepsodent charcoal formula. According to brand manager for oral care, Glenn Abraham Ampoma, the product combines innovation with cultural identity.
We've relaunched Pepsodent charcoal. It is a power-packed product. A product that has activated charcoal, has lemon and a lot of other elements. We will take Ghanaians on a journey of whitening their teeth, getting them to flash their smiles, because smiles is big for Ghana, smiles is big in Ghanaian culture, and they want to show our place in tradition.
Ampoma emphasized that the relaunch fits seamlessly into Unilever's long-term marketing strategy, positioning the brand at the heart of Ghanaian traditions, where smiling is seen as a national expression of warmth.
Pepsodent charcoal really aligns well with Unilever's marketing strategy. As Unilever, we want to find our place in culture, and then as you mentioned, Ghanaians are big on culture. You want to be the product that gives people a reason to smile. So the whole conversation we're having now is about smiles, getting people to smile, getting people to flash it, restoring the natural whiteness of the teeth, and then giving people the confidence that they need, establishing that firm root in their oral health. We are taking Ghanaians on a journey of crafting their smiles. The people painting, the people doing the art, they are craftsmen. They believe in their crafts. We have people that draw. It takes them time, and then they've learned, and then they've perfected their craft. You don't get a perfect smile in one day. You have to be involved in the journey. You have to be able to go through the grind, go through the mill, and then follow the process, and then get your smile.
Precedents relaunch signals a bold intersection of science, beauty, and culture, bringing Ghanaians one step closer to smiles that last a lifetime.
Let's now go to the commodities market. And that was the latest currency update. Ending Prime Business with me, Pius Kojo Baka. I truly appreciate your time.
I went to get polytank.
Oh, and you're fine.
Go straight.
No, I want for left, right.
That's right. Ghana na ye wono. So when you do more, and ye data. Oh no! Abe, na here. Me pe polytank ato. And you just come in here by you to be never head you. Oh, food to be here. Enjoy your cra.
Akuya bulambo customer. Emuha.
Like they take took my eyes. So go to the distributor and you give the original polytank. You hear the sound?
Polytank. Papananka Sankasa.
Hey, Charlie, what number? The malaria really knocked you down, eh?
Charlie, no joke. Fever, headache, vomiting, loss of appetite. I couldn't even eat my usual fufu.
You and your fufu. But I hope you got tested before the malaria treatment.
Yes, I did. And thanks to Malatu, I kicked out malaria one time.
When malaria strikes, take Malatu, containing artemether and lumefantrine. Comes in tablets and suspension for effective treatment of malaria.
Great to have you back.
Thank you. No problem.
Malatu is suitable for adults and children. Manufactured and distributed by NS Chemist Limited. This advertisement has been vetted and approved by the FDA.
See, let me tell you something. I'm large and in charge. You see this life, eh? They say follow who know road. I'm the road and I'm in control. I drive my own life and nobody can tell me what to do.
Nobody?
Absolutely no one. I'm large and in charge.
Please, stop here.
Sure, honey.
Oh, that's
Areas we won't. Obia or the master.
How do you know that?
Calipo fruit juice drink. This advert is FDA approved.
What has fathering Damien taught you as a young father?
Now, anything I do, and I'm thinking, will someone refer to my sins someday, pointing at my son, say, your father did this?
For more than 20 years now, I have never seen my dad. I do not know who my dad is. The story my mom told me is that he never wanted to see me. He never wanted to have me as a child.
Does it come with a certain anger?
I just wish we came to this world without fathers being in existence.
You don't have money. It's you to go and work. Why are you complaining? Men are not supposed to complain, but a man will not complain because he wants to complain. Sometimes he just needs somebody to talk to.
I opened the door to his room. And the man that I've been eating with, the man I've been dancing with, the man I've been traveling with, the man who was picking me up from school and dropping me off, he was lying on a stretcher. Maybe I should have talked to him more. Maybe I should have gotten married before he died. Daddy, I'm sorry.
I started having doubts when the physios took me out on the pitch. I had to adapt to my new leg or my new knee, I would say. You know, sometimes you just feel like, is this actually you, or will you be able to go ahead with your career again? You know, off the pitch was where it actually got to me. You understand? Because we won the game, everyone should be happy. And you know, this kept going even off the pitch. That's where it got to me.
When the FA called you and said you were going to be part of the team, did you think you deserved the call up at the time?
No, I honestly declined it. Sometimes it's a disgrace. You play against someone from a different country, and then you go to the club level, and then the first thing he sees and he tells you is, we thought Ghana was a big country, and look at your pitch. You know? So it's kind of a disgrace to us. You know?
Hi there, welcome to Prime Sport with Razak Musbao. Now, Baba Rahman, Black Stars defender, has delivered a stinging critique of the poor state of football pitches in Ghana, calling it a national disgrace that demands immediate attention. It's come in the wake of renewed scrutiny over Ghana's playing surfaces, especially after the 2025 MTN FA Cup final, which was held at the University of Ghana Stadium, drawing widespread criticism due to its subpar condition. Now, yet to be televised exclusive interview with Joy Sports, Baba Rahman urged authorities to act decisively to resolve the long-standing problem.
This is a very serious thing. The nation needs to address. You know, I think it's time that I'm begging whoever is in charge to maybe just get a proper pitch for the national team, you understand? Because sometimes it's a disgrace. Like you play against someone from a different country, and then you go to the club level, and then the first thing he sees and he tells you is, we thought Ghana was a big country, and that look at your pitch, you know. So it's kind of a disgrace to us, you know. But also, I think I kind of understand them also because of our weather here. It's very hot and it's difficult to manage the pitches. But I think if they can just dedicate one stadium for the national team use, I think it will help us a lot. You know, it help everyone, like from the young teams to the.
Now, the Barbara man has been speaking also about his career with the Black Stars, and even this season how he fared with his club in Greece. Well, the full interview will air tomorrow at 6:30 a.m. on the AM show, and also later at 8:30 p.m. and also across all our platforms. Turn attention to boxing now, because the Ghana Boxing Authority has confirmed the successful repatriation of the remains of Nigerian boxer Gabriel Oluwaseun Olaronwaju, who tragically passed away in Ghana in March this year. The body was airlifted today, June 17, from the Kotoka International Airport, and has arrived in Lagos, Nigeria, with a brief stopover that took place in Lome, Togo. The GBA, in a statement issued by its Communications Directorate, expressed profound gratitude to Ghanaians, members of the boxing fraternity, journalists, and media houses for their unwavering support since the incident occurred. Well, the boxer is expected to be buried later this month in his hometown in Nigeria. Meanwhile, former President John Dramani Mahama has disclosed that the Bukom Boxing Academy was originally established to identify young talent from across the country, bringing them together to live, train, and study simultaneously. However, this vision, he says, was paused after his tenure ended, and is now stating that he's looking forward to reviving the dream to produce more boxing talent in the country.
Unfortunately, over the years, things have gone down, and that's what we try to revive by setting up the Bukom Boxing Arena. It's actually an academy because it's got hostels, it's got classrooms and all that. And the intention was that we'll scout and look for young talents all across the country and bring them to live and train there and go to school at the same time, you know. And so we're going to have teachers teach them so that they don't miss on their lessons and all that. Unfortunately, after I left office, that dream, you know, was put on hold. But we have the opportunity to take it up again. My one regret is I didn't build it bigger than it is now. I realized that. I thought that 4,000 was enough to come and see a boxing match, but it looks like we need a much bigger arena to contain the new interest that is coming up.
Now, boardroom midfielder Musa Mohammed is giving back to his roots in a big way through the Musa Foundation. The 23-year-old has extended his support to grassroots football with donations to 2 local youth teams during a special football festival held at the Nkoko Salvation Park over the weekend. We have more for you from that event in this report.
Through the Musa Foundation, the 23-year-old boardroom midfielder extended support to grassroots football by donating sets of jerseys, football, and an undisclosed amount of money to 2 youth teams. The presentation was held on Saturday, June 14, 2025 at the Nkoko Salvation Park as part of a mini football festival organized to celebrate the occasion. The 2 beneficiary teams played in an exhibition match which Musa attended. The winning side received a trophy and medals, while the runners-up were also awarded medals along with donated jerseys and football. After the presentations, Musa Mohammed shared the motivation behind this gesture.
The motivation is from the beginning of my career. You can see there are a lot of young footballers and, you know, some old footballers in this town that they didn't get the opportunity to, you know, to utilize their talent to the top level. So as far as I'm able to reach at the top, and I'm still, I'm still moving. So I decided to put something like this in my town so that it can motivate the young ones and the seniors as well.
His gesture drew warm praise from patrons and participants who lauded his generosity and commitment to youth development.
I am very appreciative for what Musa is doing for us. He always brings people, the Zongo people together so that we'll be peace. Thank you for what he's doing and encouraging all the footballers, the young ones, to improve. So we are appreciative for what he's doing.
Musa is our friend who is now currently in Turkey. He organized this program it's a fun game. He organized yearly to bring the community together and motivate the upcoming young footballers. We are proud of wearing his jersey and showcase him. The community is much grateful for what he's doing for us.
The day wrapped up with a friendly encounter between Musa 11 and the Nkoko Barracks.
To Ghana's volleyball team now, and the women's team have been preparing for a major continental challenge as they look to represent Ghana in the Africa Beach Volleyball Championship. Now, the qualifiers, which is expected to take place later this year, will see Ghana face off their contenders, their counterpart from the continent. Now, the team has been training in Accra as they prepare for the qualifiers for the 2025 World Championship in the World Championship over there. Well, my colleague Emmanuel Ofei was at their training ground later today and came to this report after interacting with some of the players who are excited and very much looking forward to the qualifiers.
The men's and women's beach volleyball teams trained at La Boma Beach on Tuesday as they wrapped up their final preparations for the week ahead of the qualifiers for the Africa Beach Volleyball Championship in Morocco. The tournament, which doubles as a qualifier for the World Championship in Australia this August, will take place from June 22nd to June 30th, 2025. President of the Ghana Volleyball Association, George Tete, described the current preparations as the best he has witnessed and expressed strong belief in the teams, especially after their recent success in Rwanda.
This is the best I have seen in so many years. I have no doubt that they will be able to take the slots in Morocco for the World Championship. Well, now most of our players are playing international volleyball. We have a lot of professionals, and I thank God they are all down. You can see them here. And just last week, there was a similar tournament in Rwanda where people emerged tops. So we have no doubt that they will be able to repeat that feat.
Board chairman of the association, Bawa Fuseni, also emphasized that qualifying in Morocco would enhance their chances of attracting corporate sponsorship.
Been toughened, so they are strong to go. Both men and women. Both men and women, we have players who are playing outside. So it is a plus to the team. So they are well groomed enough to go on for and take a spot in the coming championship. Two of our players, the men, they just played Open Championship in Rwanda, and they were first. They took the gold medal. So we are ready. We are ready to recapture our rankings in Africa.
Head coach of the men's team, Siedu Ajanaku, stated that his players have mastered the technical aspects of the game and are ready to make a mark of the World Championship in Australia.
Personally, this is not my first competition. I've played in the Youth Olympics in Argentina and Youth Commonwealth Games in Bahamas. So this is not my first competition.
But on the African continent?
Yes, I've also played in African Games. So it's not anything different from this. Okay. Yes. So like I'm saying, we are ready. Every member of the team is ready to bring their best out during the competition. So far, we started, every training from your pre-season, our endurance, our skill work, and we've touched on everything. So this is our last week of preparation, and I'm telling you that we are ready.
Now it's time to turn attention to the European football now and bring you the latest in Germany with our partner station, GWTV, where sports presenter Daniel Barcelona is connecting with us now, all the way from Berlin. Daniel, good to have you again after a while, but let's talk about Bayern Munich because they did kick off their Club World Cup campaign against Auckland City with a very strong performance. In fact, 10-0 so far, the biggest victory in the history of the Club World Cup. How did you assess their performance?
Should talk about first Bayern Munich, who